ಅದೇ ಗೊತ್ತಾಯ್ತು. ತೆಗೆದ್ರಾ? ಅದು 2 ನಂಬರ್ ಹೇಳ್ಕೊಡಲ್ಲ. HP ರಾಜ್ಯದ 2 ನಂಬರ್. ಮೇಡಮ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರು ಪ್ರೀವಿಯಸ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ನೀವು ಯಾಕೆ ಮಾಡಿಲ್ಲ? ಇಷ್ಟು ಈಸಿಯಾಗಿ ಮಾಡಿಲ್ವಾ ಅಂತಿಲ್ಲ ನನಗೆ. PS ಮೇಡಮ್ನ ಕೇಳಿ ಹೋಗ್ಬಿಟ್ಟು ಏನಾಯ್ತು ಅಂತ. ನನ್ನದು ಲಾಸ್ಟ್ ಕ್ವೆಶ್ಚನಲ್ಲಿ ನಿಮ್ಗಾಗಿರೋದು, ಮತ್ತೆ ನಂದಿನಿ ಮೇಡಮ್ಗಾಗಿದೆ. ಮಾಡಿದ್ರೆ ನಾವು ಕ್ವಶನ್ನೇ ಕೇಳಲ್ಲ ಯಾರಿಗೂ. ಪ್ರೀವಿಯಸ್ಸಲ್ಲಿದೆ, ನೀವು ಯಾಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಲ್ಲ? ಮೇಡಮ್ ನೋ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಂತ ಹೇಳಿಲ್ಲ. ವೈ ಕರ್ಕೊಂಡು ಗೊತ್ತಾ ನಂದಿನಿ ಮೇಡಮ್ ಕೇಳಿ ನೋಡ್ತೀನಿ ಅಂತ ಈಸಿಯಾಗಿ ಹೇಳ್ಬಿಟ್ರೆ ಎಲ್ರಿಗೂ ಟೆನ್ಷನ್ ಕೊಡ್ತೀರಾ. ಮೇಡಮ್ ಟೆನ್ಷನ್ ಕೊಟ್ಬಿಟ್ಟು ಆರಾಮಾಗಿ ಹೋಗ್ಬಿಟ್ಟು ನಾವು ಬಂದಾಗಿಂದ ಓದ್ತಾ ಇದ್ದೀವಿ ಅಲ್ವಾ? ಗುಡ್. ನಾವು 9:45ಗೆ ಬಂದಿದ್ದೀವಿ. ಅದು ಅವಾಗೇ ಬರೋದಿಲ್ಲ. ಸರ್ ನಿನ್ನೆ ಮ್ಯಾಟ್ರಾ ಬೇರೆ ತಾನೆ. ನಿನ್ನೆ ಫ್ರೈಡೇ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಡೇಟ್ ಇರೋದು ಕೊಡಬೇಡಿ. ನೀವು ಪಾಸ್ ಓವರ್ ಅಂದ್ರೆ ಆಗ್ಬೇಕಿತ್ತು. ನಾನು ನೋಡಿದ್ದೀನಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮೇಡಮ್ ನೀಟಾಗಿ ಹೇಳಿದ್ರು ಪ್ರೀವಿಯಸ್ ಅಕೇಶನಲ್ಲಿ ಇಲ್ಲ ಕೊಡಲ್ಲ. ಬಿಫೋರ್ ದಟ್ ಇಟ್ ವಾಸ್ ದೇರ್. ಯಾಕಂಗೆ ಮಾಡಿದ್ದೀರಾ? ಯಾಕಾಗಿ ಮಾಡ್ತೀರಾ? ಫೈಲ್ ಅಲ್ಲೇ ಇದೆ, ಫೈಲೇ ನಂದಿನಿ ಮೇಡಮ್ಗೆ ಹೋಗಿದೆ. ನೀವು ಬೇಕಾದ್ರೆ ನೆಟ್ಟಲ್ಲೇ ತೆಗೆದು ನೋಡಿದ್ರು ಸಿಕ್ಬಿಡುತ್ತೆ. ಇನ್ ಕೇಸ್ ಮಿಸ್ ಆಗಿದ್ರೆ ಫೈಲು ಅಪ್ಲೋಡ್ ಮಾಡಿದರೆ ಸ್ಟೆನೋಗ್ರಾಫರ್ಸು ಐ ಯು ಡೂ ಲೈಕ್ ದಟ್. ನಿಮ್ಮಿಂದ ನಾನು ಬಯಸ್ಕೊಂಡೆ. Any adjournment? List 2, page 7, serial number 12 to 16. Page 8, serial number 17.
Follow the procedure. Follow out page.
Which page 9, serial number 18 to 21. Page 10, serial number 23.
Hmm. Hmm.
Loan regard to Medicaid elections. I have secured certain documents. When we have it day after tomorrow, and file it along with the synopsis and along with those documents and credit scheme, that office scheme elections.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತೀರಾ? ಇದೆಯಾ? ಸಿಗುತ್ತಾ? Short synopsis file ಮಾಡ್ತೀರಿ ಅಂತ it was undertaken.
Short synopsis and along with the LIC where we have raised the loan, that was also supposed to be produced. I got it yesterday.
Who is responsible to waive off 50%, 25%? You have respondent number 3. Who is respondent? Not filed the statement of objections. Last time you said additional statement of objections.
Additional statements for the federation. That along with the loan which we have secured from LIC, I will file it along with the affidavit.
Counsel for the petitioner. You are representing the petitioner.
Respondent number 3, federation.
Respondent number 3. Raise for time. To produce additional documents with short synopsis and to address the arguments on merits. This time. Into amount to be
and it's on 27. It is on 27. There is a status for order, and it's on 27. So kindly have it on first week of December.
Now, how it is connected to this?
On the basis of that order, we are right.
Or that on that is order, my lord, based on the single judge order, my lord, they served file, my lord, they are sent to the delegation regarding respect of this petitioner is concerned. Now that order has been challenged before the, my lord, division bench of son of court. Division bench, my lord, granted its status forward.
Then counsel for the petitioner submit that.
List 2, serial number 6. List 2, 6 ಅಲ್ಲ.
The point for consideration in the present case is involved in writ appeal number.
Let's go.
1811
Barkodi. So and so.
and 1812.
Before the division bench. Hence praise for time. Yes.
25.
Next.
List 1, page 1, serial number 1. Ramchandraji Bhatt, N. Chidanand Kiriyala.
ಈ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾರೆ ಅದನ್ನೆಲ್ಲ ಲಿಸ್ಟ್ 2 ಅಂತ ಏಜೆನ್ಸಿ ಇದೆಲ್ಲ ಮಧ್ಯಾಹ್ನ ಬೆಳಿಗ್ಗೆ ಪಾಸ್ ಓವರ್ ಇವೆಲ್ಲ ಬೇಡ ಡೈರೆಕ್ಟ್ಲಿ ಡೇಟ್ ಗಿವನ್ ಮಾಡಿ ಡೈರೆಕ್ಟ್ಲಿ ಬರೋದು ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಇದೆ ಅಲ್ಲ ಬೇರೆ ದಿನ ನಮ್ದು ಬೆಳಿಗ್ಗೆ ಬೇರೆ ತಗೊಳ್ಳಿಕ್ಕಾಗಲ್ಲ ನೀವು ರಿಕ್ವೆಷನ್ ತಗೊಂಡ್ಬಿಟ್ರೆ See, on the other day, both of you have not addressed the arguments regarding the basic facts.
Yes.
You only concentrated on your objections.
Yes.
Who raised the loan? When the loan was raised?
Yes.
Which are the properties that were mortgaged? The property belonging to whom?
Okay.
Whether they are obligants or the main borrowers.
Okay.
When the attachment before judgment was passed. Under what circumstances such order was passed? There was no argument in that regard.
My lords may refer to my list dated 11 and
Deputy 60,663, that is serial number 1, my lord, that has to be heard separately, my lord, that is, my contention is in that the petitioners are not borrowers.
ಎಲ್ಲ
They are
ಆಗಿದೆ.
not members of the society at all.
ಆಯ್ತು, correct.
That is my case, my lord, with regard to
ಆಯ್ತು,
that.
ಇವಾಗ ನೀವು ಹೊಸದ್ ಮಾಡ್ಬಿಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದಾಗಿದೆ. I
My lords
understood
may
your point.
refer to-
It is regarding the trust.
Trust.
I understand. See, this KP Acharya, he is the borrower.
Yes.
Along with his wife.
yes,
Each
there are
have-
multiple loans, my lords.
Huh?
There are multiple loans.
How many loans?
There are 14 loans.
ಅದೆಲ್ಲ ಎಲ್ಲಿದೆ?
ಎಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿದ್ದಾರೆ. ಕ್ಲಬ್ ಮಾಡಿ
ಮಾಡ್ಲಿ
ಎಕ್ಸಿಕ್ಯೂಷನ್
sir,
ಮಾಡಿದ್ದಾರೆ.
ಮತ್ತೆ
I have produced the judgment of 3 suits, my lords.
ಸರ್ ಏನಾದ್ರೂ ಸಿನಾಪ್ಸಿಸ್ ಏನಾದ್ರೂ ಬೇಕಲ್ವಾ?
My list dated
There are-
11/9/25, may can appreciate.
Synopsis, you have not filed. There are so many details. If you-
Since it was arose out of the execution petition, we did not concentrate much on the,
See, when he says that the property is mentioned in the 16663, that belongs to the trust.
trust.
And it is not the individual
Yes.
property of the borrower.
Yes,
Have to consider the entire
My-
facts of the case.
my submission is way back in 2017 itself, everything was attached. And they were intimated. Public notice was caused. Till this date, ABJ has not been challenged by anyone, including that of the trust.
Can you file a short synopsis, dates and events?
Yes, I can furnish.
Pass over the matter. You come up with a short synopsis. That
All
will be
right.
easy for me to follow.
All right. But before that, can I take my lordship to the document in relation to which I filed? This is, today I am producing, Your Honor, because I stated that there are 3 reports. 3 reports. I am making it clear, that's all. We have taken average of 3 reports. I am producing all 3 reports. Last time I did not produce 3 reports. I produced only 1 report. Now, there are 3 reports. The average of 3 reports was taken, and I am producing all the 3 reports to clear the issues.
They are authorized or recognized valuer.
Yes, my lords. All 3 are recognized values.
How many items of the properties?
Altogether 7 items.
Huh?
7.
7.
Yes.
Well, 5 with the average valuation.
Because ultimately we have deleted 2
Yes.
because of the order passed by the Honorable Court.
Permitted to go on with the sale?
5 items.
5.
Yes. Average was taken in so far the 5 is concerned.
Yes.
And short glance over the document which I produced earlier, as per list stated 11, produced on 19, 11/9/2025, my lords. 11/9/2025 documents,
11/9.
just produced on 19/9/2025.
Who produced by?
I produced by the respondent. 11/9, last time.
1.3, sir.
Sorry, 26325.
2632.
Yeah, 26325.
All the 5 properties were sold out in
Yes.
the auction.
Yes,
For what amount?
6 crore 80 lakh,
6 point?
6.8 crores. Sales certificate I already produced. ಸಿಕ್ಕಿ.
ಅವರದ್ದಲ್ಲ,
ನೋಡಿ.
ನಮ್ಮಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಅಲ್ಲ ಅವರದ್ದಲ್ಲ. ನಮ್ಮಲ್ಲಿ ನಾನು ಬುಲೆಟ್ ಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು, ಯಾರು ಮಾಡಿದ್ದಾರೆ ಕೇಳ್ಕೊಂಡು ಕೇಳ್ಕೊಂಡು ತಗೊಳ್ಳಿ. ಅದನ್ನು ಸಿಂಗಲ್ ಲೈನ್ ಅಂತ ಹೇಳಿ. ಹಾಂ, ಎಸ್.
Once you refer to page number 1. Page number 1 to 8 are the sum of few 3 judgment which was passed in case number 3122 to 315. That gives brief history of the case, my lords.
No, you are referring to the documents,
Yes, my lords.
produced on which date? You already produced.
I've already produced extra copy, my lords.
Extra ಬೇಡ, ಇದರಲ್ಲಿ ಎಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ? ಇದು ನೀವು ಅದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಡಾಕ್ಯುಮೆಂಟ್.
Produced on 19, but it was dated 11/9.
ಎಲ್ಲಿದೆ ನೋಡಿ ಇದು? ಅಲ್ಲ. ಯಾವ್ದಿದೆ ನೋಡಿ. Yes, that is not available in the file. Anyhow, ask
26326, man. 32. Fine. My lords, may kindly refer to page number 1. It is a judgment in respect of case number 312. Where my lordship refer the respondents are Somanath Shetty, Sarojini, wife of KP Acharya.
yes,
They are the only respondents in that particular case. And sorry, KP Acharya and Sarojini KP Acharya. And that gives the history of the case, my lords, wherein it is seen that a loan of rupees 50 lakh was availed on 31/1/2020, 2006.
by Somnath Shetty.
Jointly they have availed. 1 ರಿಂದ 3ನೇ ಪ್ರತಿವಾದಿಗಳು ವಾದಿ ಸಂಘದ ಎ ತರಗತಿ ಸದಸ್ಯರಾಗಿದ್ದು ದಿನಾಂಕ 16ರಂದು ಸಾಲ ಕುರಿತು ಸಾಲ ನಂಬರ್ 16 ಅಂತೆ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ಣಯದಂತೆ ವಡ್ಡಿ jointly availed by them, all 3 of them. And in that case, 2 properties have been ABJ has passed in respect to 2 properties, my lords.
ಎಲ್ಲಿದೆ?
Last events. Second page. 1 ರಿಂದ 3ನೇ ಪ್ರತಿವಾದಿ ವಾದಿ ಸಂಘದಿಂದ ಪಡೆದ ಸಾಲವನ್ನು ಮರುಪಾವತಿಸಿ ಸುಸ್ಥಿರಾದರಾಗಿದ್ದು ಸಾಲದ ಕರಾರ ಪತ್ರದ ಷರತ್ತನ್ನು ಪಾವತಿಸಲು ವಿಫಲವಾಗುವುದರಿಂದ ಪ್ರತಿವಾದಿಗಳು ಸಂಘದ ದಾವಾ ಮೊಬಲಗು 49 ಲಕ್ಷ ಸ್ವಾನ್ಸು ಮತ್ತು ದಿನಾಂಕ 15/12/2017 ಬಾಕಿ ಅಸಲು 29 ಲಕ್ಷ ಸ್ವಾನ್ಸ್ ಮೇಲೆ 15% ಬಡ್ಡಿ ದಾವಾ ಖರ್ಚು ಇತರ ಖರ್ಚಿನ ಜಂಟಿಯಾಗಿ ಪ್ರತ್ಯೇಕ ಪಾಲಿಸತಕ್ಕ ತಪ್ಪಿದಲ್ಲಿ 1ನೇ ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿ ಸೇರಿದಂತಹ ಸಂಘದ ಅಡಮಾನ ಆಸ್ತಿ ಈ ಕೆಳಗಿನ ಆಸ್ತಿಗಳನ್ನು ಕಾಣಿಸಿದ ಎಬಿಜೆ ಮಾಡಲಾದ ಸ್ಥಿರಾಸ್ತಿ ಮತ್ತು ಅದರಲ್ಲಿರುವ ಸುಸ್ತಿ ಚಿರಾಸ್ತಿ ಮತ್ತು ಮಾರಾಟದಿಂದ ವಸೂಲಿ ಮಾಡಲು ಮತ್ತು ಅಡಮಾನ ಮಾಡಿದ ಆಸ್ತಿಯ ಮಾರಾಟದಿಂದ ಸಾಲ ಮೊಬಲಗು ಸಂಪೂರ್ಣ ವಸೂಲಿ ಮಾಡಿದ್ದಲ್ಲಿ 1 ರಿಂದ 3ನೇ ಪ್ರತಿವಾದಿಗೆ ಇನ್ನಿತರ ಸ್ಥಿರಾಸ್ತಿಗಳನ್ನು ಮತ್ತು ಜಪ್ತಿ ಮಾಡುವ ಮೂಲಕ ವಸೂಲಿ ಮಾಡಲು ವಾದಿ ಸಂಘಕ್ಕೆ ಅಧಿಕಾರ ಆದೇಶಿಸಲಾಯಿತು. ಶೆಡ್ಯೂಲ್
This 39/10, 40/2 PK.
Yes.
ABJ was
ABJ was made. In next case, my lords, page number 4, wherein the debtors different, Shweta, Sarojin, and KP Acharya, and Somana Shetty. 313.
No, there are only three, Shweta, Sarojini and Somna Shetty.
In first case, 312, only 3 persons.
ಹೌದು
Second case, ಅಲ್ಲಿ 4 ಜನ ಇದ್ದಾರೆ ಸರ್.
ನಾಲ್ಕಿಲ್ಲ.
4, sorry, more, sorry. I'm sorry.
Three only.
ಹೌದು, ಶ್ವೇತಾ, ಸರೋಜಿನಿ ಮತ್ತು
ಸೋಮನಾಥ್ ಶೆಟ್ಟಿ
ಸೋಮನಾಥ್, KP Acharya ಇಲ್ಲ.
ಇಲ್ಲ.
So ಅದರಲ್ಲಿ in respect of 3 items, the order was passed. Amount to same 50 lakhs, sir, but it was taken on different times. ಅದು ಆಗದ್ದು 2006 ಅಲ್ಲಿ ತಗೊಂಡದ್ದು, ಇದ್ರಲ್ಲಿ 2012 ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದು.
No, you better file.
I'll file in absence. Kept by him.
ಅದು I have raised some questions you may have to answer, both of you. I'll furnish you.
Yes, ma'am.
And any other points you may think it appropriate.
All right.
ಅದು ನಾವು ಇಬ್ಬರಿಗೂ ಒಂದು copy ಕೊಡಬೇಕು. Yes. Also.
Serial number 2. Kandesh TB, HN Basuraju.
Non-compliance of office objections raised on IA. Who filed impleading application? ಯಾರು?
Including ಹಾಕಿದ್ದಾರೆ.
ಯಾರು ಇಲ್ವಾ? Impleading ಇಲ್ವಾ?
The dispute is pending, my lord, section 70. The interim order passed by this honorable court, my lord, to this voting has been given, delegation which was sent by the petitioner society.
Voting ಆಗಿದೆ.
ಆಗಿದೆ.
Go before the registrar. In fact, ಇಲ್ಲಿ ಏನು ಇದು ಮಾಡಬೇಕು?
What happened?
No, admittedly, the dispute is already raised before the registrar.
Please.
Yes, dispute is pending.
ಅದಕ್ಕೆ ಆನ್ಸರ್ ಕೊಡಿ ನನಗೆ. Whether section 70 dispute is pending.
ಅದ್ರ ಮೇಲೆ
ಹೌದು ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ವಾ?
ಹೌದು.
ಹೇಳ್ಕೊಳ್ಳಿ first.
Dispute pending.
That is in respect of what?
Delegations meeting ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ ಯಾವ ಪಲ್ಲೆ.
ಇಲ್ಲೇನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ?
ಅದೇ ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಆರ್ಡರ್ನ ಚಾಲೆಂಜ್. Dispute ಅಲ್ಲಿ ಇಸ್ಪಾಟೆ ಎಂಟ್ರಿ ಮಾಡೋದು ಬೇಡ. That has been challenged.
ಈಗ ನೀವು ವೋಟ್ ಮಾಡಿ.
Vacating ಹಾಕಿಲ್ಲ.
What is the next area?
ಹಾಕಿಲ್ಲ. Vacating ಹಾಕಿಲ್ಲ.
Page number ಯಾವುದು?
Revision of my laws, page 43. On the date of dispute, my lords, without giving notice and on the first date of hearing, my lords, granted interim.
What is the interim order?
Interim order, my lords, the stay the delegations meeting dated, my lords.
And thereby preventing you from voting.
Voting.
ಈಗ now your purpose is served since this court permitted you to vote.
This is.
Can you pass over?
Pass over ಏನು sir? It is so clear.
Senior counsel.
ಅದೇ ಬೇರೆ ಇದೇ ಬೇರೆ ಎಂದು what is ಬೇರೆ?
Senior counsel.
Whatever they are not entitled to file a writ petition. In fact, ಅವ್ರೇನ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ either they have to file a vacating application therein or file a revision petition under section 107 of the KCS Act. Revision ಆಗ್ಬೇಕಾಗಿತ್ತು KT ಮುಂದೆ. ಡೈರೆಕ್ಟ್ ರಿಟ್ ಬರಲ್ಲ ಸರ್. Anyway, dispute pending ಇದೆ.
That's over.
Serial number 3.
ಇದನ್ನ ಮಧ್ಯದಲ್ಲಿ ಏನಿಲ್ಲ. ಮಧ್ಯದಲ್ಲಿ ಕರೆಯೋದು. Just complete ಆದ್ಮೇಲೆ ವಾಪಸ್ ಬರೋದು. ಅಷ್ಟೇ.
I appear for the respondent.
Site reserve or site reserve to
Permanent.
Site reserve ಇಲ್ಲ. ಅದೇ last time Lakshman sir ಅವ್ರು order ಮಾಡಿದ್ರು.
R2 you represent.
Serial
Can't
number.
register.
state, my lord.
I appear
Please.
for the
PA takes notice for respondent number 2. R1 ಗೆ ಇವರು.
Homework sign.
I appear for respondent 1, Your Lordships.
Yes.
State.
Why you have not furnished?
I'll furnish PF and
Who moved the matter?
joint.
Who moved the memo?
I moved the memo, Your Lordships.
Why?
What has happened is I have filed execution proceedings. On the previous date of hearing, Your Lordship, this honorable court passed an order saying, directing the sub-registrar not to register any sites pertaining to this layout which involves the petitioner society, Your Lordships. Now, if the execution petition is in its final stages. Now, if I succeed in the execution petition and there will be a direction to the petitioner society to execute a sale deed in my favor. That will also be stalled is my submission. To that extent, that interim only for this case, for this respondent, it may be modified. That is my prayer, Your Lordships. Seniority wise, I am entitled to one site, Your Lordships. I filed a dispute. I succeeded in the dispute. They filed an appeal before the appellate tribunal. The appellate tribunal confirmed the order passed by the DR, Your Lordships, the Joint Registrar of Cooperative Societies.
Which is your site number?
261 years.
1 minute, 1 minute.
We have to not eliminate any.
Contesting respondent means respondent number 1.
1. I am the member of the society and I am entitled to 160/40 site, Your Lordships.
Site number 261.
261.
No, initially petitioner has filed a memo, is it? Seeking permission.
We will allot alternative site. Which states name, giving that memo came to the business manager. So on that memo itself, they are directed that not to eliminate until execution petitions will also be stayed until.
Execution petition. Only sub-registrar direction.
Yavudu society?
National
Technological Institutions Housing Society.
NTI.
Yes, why such order was passed? It is against both the petitioner as well as respondent.
Respondent. Regarding my lord, their claim is my lord, they are in the seniority. His claim is my lord, they are in.
No, he himself has filed a memo
Saying that they will give alternative sites, but
to respondent number 1.
But that layout which they in the memo which they say, that is not the very layout where I was initially allotted. That respondent number 1 is not inclined towards that layout because it is very far. Now then
Why you want to run the risk?
Please.
Why you now sale is complete? No.
Sale is not complete. I have filed execution. Now, if I succeed in the execution petition, they'll have to execute the sale deed for this very site.
Wait for the disposal of this writ petition on merits.
Please.
On merits, now the service is complete. Argue the
Please.
matter on merits.
Please.
Piecemeal act. Ready? Sir, when you take the interim order, you should be ready always. Otherwise, I'll vacate ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಒಳ್ಳೆಯದು. I will simply dismiss the writ petition, Master. Counsel for the petitioner prays for time. He undertakes to address, the learned counsel for the petitioner and respondents undertake to address the arguments on merits, since the interim order is in operation this time.
Serial
Next.
number 4, TB Sandesh. Yes, Sarathi.
ಒಂದೇ ವಾರಕ್ಕೆ ಕೊಡ್ಬೇಡಿ, ಸ್ವಲ್ಪ ಮುಂದೆ.
Lordship, we are for the caveators.
ಹ್ಮ್.
Today, today only we have been served the copy, madam. Kindly fix it on Monday.
Cavator, respondent number 4.
Yes,
Please.
What is your name?
Here,
Sir, name.
We are sorry.
yes, sir.
ಯಾಕೆ ಹೆಸರು ಹೇಳೋದು ಕಷ್ಟ ಇದಕ್ಕೆ? ಅವರೆಲ್ಲ ಹೇಳ್ತಾರೆ ನಿಮಗೆ ಕಷ್ಟ ಆಗಿದೆ.
I thought respond.
Counsel Shri V.R. Sarathi,
1, 2, 3 state, my lord.
David petitioner respondent number 4 is present and prays for time. File statement of objection.
1, 2, 3.
Make his submission.
1, 2, 3 state.
1 to 2.
ಏನಿದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆಫ್ ಕಾಪಿ
Non-compliance.
ಒಂದೇನಾ? ಅದು ಒಂದೇ. Since the copy of the petition is served on the caveat petitioner, his objections he is complied with this term. ಯಾವಾಗ? AGA takes notice of it.
1, 2, 3, my lord.
3. Waiter. ಯಾವಾಗ?
Society already registered members. After lapse of 2 years members, now they are filed the appeal before the authority.
ಆಯ್ತು, on merits it will be considered. Get ready on the next date of hearing.
Yes.
ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ.
Yes, report.
Next Monday.
Next.
Monday.
Serial number 5, Ashok Kumar.
Madam.
Chandrasekhar.
I am for respondent number 1 in this case. Petitioner is the borrower. He has not paid the amount. An award was passed. And seizure warrant was issued. Against that, they have filed the writ petition. Writ petition itself is not maintainable. This honorable court has granted an interim order subject to payment of the amount, 50% of the
That
amount.
was not deposited.
They have not paid any amount. Interim order was granted on 31/10/2023.
25.
An appeal lies under section 46 of Savarda Act.
No, interim order is not in force now. It is clarified with an order dated 8/2/2024.
Please, madam. But the register, assistant registrar is not proceeding further in the matter.
That is your
Therefore-
lookout. Now the court has clarified that.
Please, please.
Yes, the amount of 50% was not
Not deposited, the society is at
The
liberty to-
benefit of conditional order will not be available for the petitioner.
Please.
What else is necessary?
My submission is, my lord, writ petition itself is not maintainable. Since in
But
view of
the
this,
interim order is not in force. That is what I am saying.
please,
Yes. Counsel for the petitioner is
ಮಾಡಿದ್ದಾರೆ,
absent,
but
no
that
representation. Counsel for respondent number 1 and AGA for respondent number 2 and 3 are present. They submit in unison that since the interim, the condition imposed while granting interim order with a order dated 13/10/2023 was not complied with, this court clarified the situation that the petitioner is not entitled for the benefit of the interim order since he had not deposited 50% of the award amount as directed. Next, then council submit that the writ petition itself is not maintainable. What is the reason?
The appeal is provided under section 46 of the Karnataka Savarda Act.
Petitioner has not invoked the efficacious remedy of deferring the appeal as provided under section 46 of 46 of Karnataka Savarda, the full act. It appears the petitioner is not interested in prosecuting the petition. However, to afford one more opportunity this time, finally disposal. Next.
Serial number 6, Shivaprasad Shantanagowda.
Next.
Point number 2 as well as in pleading applicant. Petitioner is working as a secretary in the.
No, what is the petitioner here? Who is?
Petitioner, she was earlier working as a secretary in the primary society, Your Lordship. Thereafter, there are 30 allegations of misutilization of money, misutilization of the check, misutilization of power, for which inquiry has been initiated, and she has been dismissed. Thereafter, she challenged before the assistant registrar first respondent. Now, Your Lordship, there is a there is an order passed by the assistant registrar specifically stating that you reconduct the you just re-inquiry the matter once again, and also you reinstate her other than the secretary post, any other post for a period of 3 months for a temporary arrangement you make for the petitioner. This was the condition. But Your Lordship, instead of if there is any impugned order agreed by the petitioner, it has to be challenged before the deputy registrar as per 106(2)(a). He filed a writ petition, Your Lordship, behind the back of the respondent, the impleading applicant. She is working as a secretary in the very same society from past 7 years. Now obtain the interim order to get the post of the secretary, because the documents what Your Lordship inquiry will be under her custody, which will be manipulated, which will be Your Lordship in the during the course of inquiry. And I have been, Your Lordship, now she is coming and troubling me, stating that I have been by virtue of interim arrangement passed by this honorable court, Your Lordship, I have been reinstated for the secretary post. Therefore, I filed the impleading.
How your petition is maintainable, sir? Why you have not invoked 106? Why you have not invoked 106? Annexure ಎಲ್ಲ ಬೇಡ ನನಗೆ 106 ಬರುತ್ತಲ್ವಾ?
Under section 64, I did exoneration, but through resolution, they have rejected section 64 order.
106 is not applicable.
It's applicable.
It's applicable. Annexure H is the challenge, Your Lordship, order.
106, why it is not applicable? It is an order passed by the registrar.
Yes, Your Lordship.
Under which provision that order was passed?
Under section 70, Your Lordship, the order was being passed by the assistant registrar.
This one for you, not for you. 70 alwa, 70 alwa.
106(2)(a, Your Lordship.
Under 70 alwa.
70, okay.
105 already, 105, 6 alwa.
Any appeal as any decision order made by the assistant registrar.
71 ಅಲ್ಲೇ ಆರ್ಡರ್ ಆಗೋದು.
71 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗೋದು, 71 ಅಂತಲ್ಲ. KT ಅಲ್ಲ?
Yes.
106 my lord, not 5 my lord, it's K8. 105.
Appeals, Your Lordship. Sorry, Your Lordship, I stand corrected.
Appeal to the tribunal.
Appeals to the tribunal.
Please.
Annexure F also have challenge over this. The resolution passed by the respondent number 2, my lord. Where they rejected section 60.
This order is under 71.
Please, my lord.
71,
Any,
not
my lord,
70.
appeal filed by my lord under 70. The order may be, my lord, 71 only. 71 only. Disposal, any application.
Aggrieved by 71.
Please.
Any decision of the
Please.
registrar.
May pass over the matter, my lord, sir. My senior will.
ಇದು ಏನಾದರೂ ಒಂದು ಕೇಳಿದ ಕೂಡಲೇ senior will come.
in pleading application, they have filed, my lord. To that, my lord will file objection.
Sir, when the petition itself is not maintainable according to them, there is the question of considering the application.
Pass over the matter, my lords, will argue the matter. Senior will argue the matter, my lords. Sikara pass over.
If when the matter is called for the second time, if there is nobody or if we again seek for passover, I will straight away dismiss the writ.
Yes, yes, my lord.
Right?
Yes.
So
Your Lordship,
the
no apology in the afternoon, you can,
One-
tomorrow, Your Lordship.
one,
Please.
the learned AGF or so and so and learned counsel for the impleading applicant submit that the order is passed by the registrar under section under section 71 of Karnataka Cooperative Societies Act. Efficacious remedy of preferring the appeal under section 105 is provided without invoking section 105. Petitioner has approached this court, hence the petition is not maintainable. What about annexure F?
Resolution, my lord.
Resolution, Lordship.
Asked by
Any resolution agreed, once again, they have to approach section 70, Your Lordship.
Next paragraph. They further submitted that even annexure F, that is the resolution passed in the meeting that was held on 1/11/2019, is to be disputed by is to be challenged by raising a dispute under section 70 of Cooperative Societies Act, and hence pray for dismissal of the petition. Question pending it, pending. Pass over. Pass over.
Your Lordship, tomorrow, Your Lordship.
ಬರ್ಲಿ ಸರ್ ಅವ್ರು ಹೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ ಅಂತ ಇರ್ತಾರೆ ಅವರು ಎಜೆ ಇರ್ತಾರಲ್ಲ
2:30.
ನೋಡೋಣ.
Serial number 7, TB Sandesh, C. Parmeshwarappa, AC Balraj.
Forensic report ಅಪ್ಪ. Forensic report. Resignation.
Handwriting expert. ಏನು
Authority passed the order for appointing the special officer to the society. On the ground that Mother kindly see page number 62 of the scheme.
legal petition. Petition or legal? Petition ಕೊಟ್ಟಿಲ್ಲ ಏನೇನೋ ಕೊಟ್ಟ. Petition ಮೇಲೆ ಕೊಟ್ಟರೆ ಏನು ಬರಬಾರ್ದು.
ಅಪೀಲ್ ಹಾಕಿದ್ದಾನ? ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ಇಲ್ಲ. ಅಪೀಲ್ ಹಾಕಿಲ್ಲ.
What is this annexure B? What is annexure F?
Annexure B, Mother, appointing the special officer to the society for having no quorum of the. Kindly see the page number 22.
This appointing special officer by
By the third respondent,
Yes, yes.
on the ground that Mother, some of the directors have given a resignation. Out of the seven directors have given a resignation.
Special officer.
There is no quorum, hence the appointing the. And the serial number, page number 22 on Mr. D, second paragraph.
then what is F?
Against this order, Mother, refer the appeal on section 106. 106 ಅಲ್ಲಿ have taken a contention Mother in the appeal. ಒಂದು ಮತ್ತು ಎರಡನೇ ಮೇಲ್ಮನವಿ ಅಂದರೆ ನಿರ್ದೇಶಕ ಸ್ಥಾನಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿರುವುದಿಲ್ಲ.
Yes.
ಮತ್ತು ಸದರಿಯವರು ಯಾವುದೇ ರಾಜೀನಾಮೆ ಪತ್ರವನ್ನು ಒಂದನೇ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗೆ ನೀಡಿರುವುದಿಲ್ಲ.
Yes.
ಆದರೆ ಒಂದನೇ ಎದುರುದಾರರು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳು ಒಂದು ಮತ್ತು ಎರಡನೇ ಮೇಲ್ಮನವಿ ರಾಜೀನಾಮೆ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ಪತ್ರವನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿ
What is the finding?
ಮತ್ತು ಒಂದನೇ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿ
ಎರಡು ಮತ್ತು ಮೂರನೇ and that basis the third respondent appointing the special officer. Lord, the petitioner 1 and 2, my lord, they have not given the recognition to the CEO.
What is the finding in appeal 106?
Lord, finding given by the second respondent stated, my lord, the first and second petitioner have given an evidence. Apart from other petitioners not given evidence, therefore the appeal has been dismissed.
You have led the evidence stating that you have not resigned from the society.
ಅದನ್ನ cross examination ಮಾಡಿಲ್ಲ ಏನು ಮಾಡಿಲ್ಲ. Only on that point other petitioners are appellant ಅವರು ಮಾಡಿಲ್ಲ ಅವ್ರು ಯಾರು ಕೂಡ ರೆಸಲ್ಯೂಷನ್ ಕೊಟ್ಟಿರಲಿಲ್ಲ ಸೊ ಹಾಗಾಗಿ ಅವ್ರು ಯಾರು ಕೂಡ ಮಾಡಿಲ್ಲ. ಓನ್ಲಿ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ರು ಮೊದಲನೇ ಮತ್ತು ಎರಡನೇ petitioner ಮಾತ್ರ ಆಗ್ತದೆ. ಸೊ ನಾವು ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ನಾವು ಮಾಡಿದ್ವಿ. ಸೊ ಅದನ್ನ ಖಂಡಿಸಿ
Who is the contesting respondent? Yaru government.
Government. Please. So regarding my lord, the enquiry matter, my lord, to page number 51 and 52, my lord.
Enquiry held by?
Please. The appeal of order. Annexure, my lord, page number 51.
Annexure E or F?
F. E. F.
E na.
F, lord.
The date 9/11/20.
Lord, 9/11/23, lord.
10/7/24 order.
It's 9/11.
ನಂಗೆ 10/7 ಇದೆ.
Please, my lord, merit.
ಯಾವುದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ.
51, my lord. 9/11.
51.
Please.
51 ಎಲ್ಲಿದೆ? ಇದು middle of the document.
Lord, operative portion of the.
11. Annexure
Please.
E.
9/11/23. May I read, my lord?
1 minute.
Lord, the last bottom fourth, last paragraph. ನಾಲ್ಕನೇ ಮನವಿದಾರರು ಎನ್ ರಾಜು ಅವರ ಪತ್ನಿಯವರು ತಿಮ್ಮಾಜಿಪುರ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚೇರ್ಮನ್ ಆಗಿದ್ದು, ಎರಡನೇ ಮೇಲ್ಮನವಿದಾರ ಸಹನಪ್ರಿಯ ಆರ್ ತಿಮ್ಮಾಪುರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವೈಸ್ ಚೇರ್ಮನ್ ಆಗಿರುತ್ತಾರೆ. Regarding my lord, 51 last bottom page. I read me. ನಾಲ್ಕನೇ ಮನವಿದಾರದ ಎನ್ ರಾಜು ಅವರು ಪತ್ನಿ ರಶ್ಮಿ ತಿಮ್ಮಾಜಿಪುರ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚೇರ್ಮನ್ ಆಗಿದ್ದು, ಎರಡನೇ ಮನವಿದಾರ ಸಹನಪ್ರಿಯ ಆರ್ ಅವರು ತಿಮ್ಮಾಜಿಪುರ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವೈಸ್ ಚೇರ್ಮನ್ ಆಗಿದ್ದು, ರಶ್ಮಿ ಹಾಗೂ ಸಹನಪ್ರಿಯ ಆರ್ 2021ನೇ ಇಸ್ವಿಯಲ್ಲಿ ನಡೆದ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚುನಾವಣೆ ಸದಸ್ಯರಾಗಿದ್ದು, ಅಂದಿನಿಂದ ಇಂದಿನವರೆಗೂ ಆಡಳಿತ ಮಂಡಳಿ ಬರುತ್ತಿದ್ದಾರೆ. ಸರದಿ ರಶ್ಮಿ ಮತ್ತು ಆಕೆಯ ಪತಿ ನಾಲ್ಕನೇ ಮನವಿದಾರ ರಾಜು ಮೇಲ್ಮನವಿದಾರರನ್ನು ರಾಜಕೀಯ ರೀತಿಯಲ್ಲಿ ಬೆದರಿಸಿ ತನ್ನಿಷ್ಟ ಬಂದಂತೆ ಇಲ್ಲಸಲ್ಲದ ಆಮಿಷ ಒಡ್ಡಿ ರಾಜೀನಾಮೆ ಕೊಡಿಸಿರುವುದು, ಪುನಃ ರಾಜೀನಾಮೆ ಹಿಂಪಡೆಯುವಂತೆ ಒತ್ತಾಯ ಮಾಡಿ ಆಕೆನೆ ಕೈಗೊಂಬೆ ಮಾಡಿರುವುದು ಈ ಮೂಲಕ ಸಾಬೀತಾಗಿರುತ್ತೆ. My lord, it is very clear, my lord, regarding the resignation given to the CEO. ಈ ಎರಡನೇ ಮೇಲ್ಮನವಿದಾರರು ಹಾಲಿ ಸಂಘದ ಸದಸ್ಯತ್ವಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿರುವುದು ಏನಾಗುತ್ತೆ ಎಂಬ ಕನಿಷ್ಠ ಅರಿವು ಚೆನ್ನಾಗಿ ಬಲ್ಲವರಾಗಿದ್ದು, ಹಾಗೂ ಸಹನಾಪ್ರಿಯ ಎಂಬುವರೆಗೂ ಇದು ಪದವಿಯವರೆಗೆ ವ್ಯಾಸಂಗ ಮಾಡಿದ್ದು, ಯಾವುದಕ್ಕೆ ಸಹಿ ಮಾಡಿತಾಳೆ ಎಂಬ ಕನಿಷ್ಠ ಅರಿವು ಅವರಿಗೆ ಇರಬೇಕಾಗಿದೆ. ಹಾಗೆಯೇ ಯಾವುದೇ ಪತ್ರಕ್ಕೆ ಸುಖಾಸುಮ್ಮನೆ ಸಹಿ ಹಾಕಿ ಕೊಡಲು ಆಕೆ ಅವಿದ್ಯಾವಂತೆಯಂತೂ ಅಲ್ಲ. ಆದ್ದರಿಂದ ಆಕೆಯ ಹೇಳಿಕೆ ನಂಬಲು ಅರ್ಹವಾಗಿರುವುದಿಲ್ಲ. My respectful submission is, my lord, once, my lord, the resignation is given, within 15 days, my lord, they are not taking the withdrawn. Please.
It is a forgery.
Please.
Such a government was raised before the appellate authority.
Where?
Kindly see 57.
57 in
Page 30, appeal memo.
ನಾನು ಹೇಳ್ತಾರೆ ಏನು ಹಾಕಿದ್ದೀರಿ ಅಂತ ತೋರಿಸಿ 30 ಅದು
37 ಅಂತೆ RS ಫಿಲ್ಸ್ ಒಂದು ಆಯ್ತು ನೆಕ್ಸ್ಟ್ 10/7/24
Now kindly see the 29B.
Twenty-nine. Whether the forgery and contention regarding forgery can be considered by this court in the writ petition? Appeal ಇಲ್ಲಿ sir, writ petition. Now you filed the writ petition. I am asking you. I understood the point. Now I am asking you the position of law. It is now your contention that the signature relied on by the respondent is forged one. When such disputed facts are there, can it be decided in the writ petition? What is the remedy for the petition? ಇಷ್ಟನ್ನೇ ಕೇಳ್ತಾ ಫಸ್ಟ್ ಡೇ ಇಂದ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ಇವತ್ತಿನವರೆಗೂ ಅದಕ್ಕೆ ಆನ್ಸರ್ ಇಲ್ಲ ಸುಮ್ಮನೆ ಗೋ ಟು ಪೇಜ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇಷ್ಟು ಬಿಟ್ರೆ sir, unless you answer my question regarding position of law, I will just record it and dismiss your petition. This is the third time I think that is being listed before this court, and I am again raising the same thing. First day ne idan raise madidene, and ivatnavreಗೂ ಅದಕ್ಕೆ ಉತ್ತರ ಇಲ್ಲ. On the other hand, allogi illogi ad nodi id nodi ishte ಎಲ್ಲಿ ನೋಡಿದ್ರು ಇಷ್ಟೇ ಇರೋದು ಮತ್ತೇನಿಲ್ಲ. ತಗೊಳ್ಳಿ.
Given the resignation that has been placed before the board meeting. ಅದನ್ನೇನು ಕೂಡ ಮಾಡಲೇ ಇಲ್ಲ. Directly they have appointed the special officer for the society.
Counsel for the petitioner and appointed AGA for respondent and so for respondent number so and so. The petitioner is challenging. ನೋಡ್ಕೊಳ್ಳಿ. On the ground that petitioner number 1 and 2 have never tendered their resignation and their signatures were forged for the purpose of appointing the special officer. In the appeal, a categorical finding was recorded that the signatures of petition number 1 and 2 were made by them, knowing fully well the consequences of such resignation. Now the petitioner is impugning the said order. Next part. When the matter was posted on 14/10/2025, the counsel for the petitioner was called upon to convince the court as to why in the writ petition a rowing inquiry is required to be held by referring to the disputed question of facts. However, it was noticed that a handwriting expert was appointed to verify the disputed signature with the admitted signature. But the said handwriting expert has addressed a letter that the disputed and admitted signatures have not been sent along with the required fees. And therefore, no report is received by this court. Next. And counsel for the petitioner is not in a position to convince the court regarding the position of law as to whether the writ court would go into the disputed facts of the case to find out whether the petitioners have signed the resignation letter or not. I am of opinion that in the writ only the admitted facts, only a decision could be given on the admitted facts and not on disputed facts. Under such circumstances, I do not find any reason to entertain the petition. Hence, petition dismissed. Petition dismissed.
Serial number 8, Ravindranath M.
ಅದು ಒಂದು ನಿಮಿಷ ಅದನ್ನ ಮಾಡಿ ಹರೀಶ್ಗೆ ಒಂದು ಸ್ವಲ್ಪ ರಿಸರ್ಚ್ ಮಾಡಿ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಕ್ವಶನ್ಸ್ ಯಾವುದು 8 ಎಸ್ ಎಸ್
Appearing for the petitioner, my lord, impleading application copy ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ನೋಡ್ ಒಂದು ಇದು ಮಾಡ್ತೀನಿ kindly have it next
Chief Executive Officer files a petition seeking ranking vote in the election.
ಆಯ್ತು who filed the application?
Who filed application? They are not a contesting candidate. Copy is served on them earlier.
ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇವಾಗ ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀವಿ ಸೀನಿಯರ್
Counsel for the petitioner prays for time to file objections to IA 1 of 2025. Since the copy of the application is served on him today morning in the open court. ಯಾವಾಗ ನಾನು ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ
Election is also over.
ನೀವು ಡೇಟೇ ಕೊಟ್ಬಿಡಿ ಆಮೇಲೆ ಮೆಮೊ ಇದು ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ. ಇಲ್ಲ ಯಾರು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದು ಹೂ ಮೂವ್ ದ ಮೆಮೊ ನೀವು
impleading applicant ಅನ್ಸುತ್ತೆ
is the urgency
The elections are already over. The petition filed by the executive officer seeking voting right. It could be start by the members of the society who are agreed by included in the ineligible voters.
Now election is already concluded.
Election is already over and results have also declared to some extent. Only 1 or 2 contract results yet to be declared. The writ petition itself is not maintainable. The executive officer cannot maintain a writ petition on behalf of the members. That was the view taken by this one.
My lord, kindly see the page number 12,
What
my
is to
lord.
be decided now?
Dispute only.
You are permitted to vote.
Please, my lord.
Already vote is cast.
Please, my lord.
ಮತ್ತಿನ್ನೇನು ಮಾಡಬೇಕು? You have to raise it. You are the executive officer.
The chief executive officer.
I am a member of the society.
You have the right of vote.
My lord, kindly see the page number 12 of the writ petition, my lord. Society CEO and society and a member of the respondent 5, my lord. TAPC member.
This dispute is to be decided by whom?
Sorry, my lord.
Now, my lord, challenge the dispute before the register, my lord.
He is final eligible to vote. Annexure D he is questioning.
Please.
No, my lord. Annexure C, my lord. Ineligible list, my lord.
ನೋಡಿ ನಿಮ್ಮ prayer ನೋಡಿ.
Challenging.
Include the name of the petitioner.
In the annexure DL ನನ್ನ name include ಮಾಡಿ ಅಂತ ನನ್ನ prayer ಇದೆ ಸ್ವಾಮಿ. Annexure C is the ineligible voter list.
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ನೀವು.
ಅಲ್ಲ ನನ್ನ ಇನ್ಎಲಿಜಿಬಲ್ ಮಾಡಿದ್ನೆ ನಾನು ಎಲಿಜಿಬಲ್ ಲಿಸ್ಟ್ ಹಾಕಿ ಅಂತ ನಾನು ಪ್ರೇಯರ್ ಕೇಳಿದ್ದೆ ಸ್ವಾಮಿ.
ಬಟ್ ಸಿ ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನಾನು ಮೆಂಬರ್ ಅಂತ ಹೇಳಿ ತೋರ್ಸಕ್ಕೆ ಸ್ವಾಮಿ, ನಾನು ನೆಕ್ಸ್ಟ್ ಸಿ ತೋರಿಸ್ತಾ ಇರೋದೇನಂದ್ರೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದ್ದು ಸಿಒ ಹಾಕಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗ್ತದೆ.
ಡಿಸ್ಪ್ಯೂಟ್
17
ಪ್ಲೀಸ್ ಎಲ್ಲ ಬೇರೆ ಆರ್ಡರ್ನಾಗ ಆಗುತ್ತೆ, ಆದ್ರೆ ನಾನು ಇಂಪ್ಲೀಡಿಂಗ್ ಒಂದು ಫಾರ್ಮಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀನಿ ಸರ್.
ಯಾಕೆ ಸರ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್, ಈಗ ಅದೆಲ್ಲ ಯಾಕೆ
ಬೇರೆದೆಲ್ಲ ಹಂಗೆ
go before the registrar and raise the dispute. Now vote ಅಂತೂ ಆಲ್ರೆಡಿ ಆಗಿದೆ. Then that is the reason why you approach this court.
Please.
Your purpose is now served.
Please.
Go back to the registrar. ಅಷ್ಟೇ, ಅದೆಲ್ಲ ಬೇಡ, later time ಅದೆಲ್ಲ ಬೇಡ. Third, learned counsel for the petitioner, learned senior advocate for the impleading applicant, and learned AGA for so and so. The petitioner is challenging inclusion of the name of the petitioner in the ineligible voters list and seeking to include his name in the final eligible voters list produced as per Annexure D. As per the interim order dated 6/11/2025, the returning officer was directed to permit the petitioner to cast vote in the election that is held on 9/11/2025 and keep the vote cast by the petitioner separately in a sealed cover, which shall be subject to the further orders by this court. Accordingly, the petitioner has already cast his vote in the election. Next paragraph. Now, the dispute regarding inclusion of the name of the petitioner in the ineligible voters list could be raised by the petitioner before the registrar, invoking section 70 of the Karnataka Cooperative Societies Act. Under such circumstances, I do not find any reason to bypass the efficacious remedy under section 70 and to entertain this petition. As petition is disposed of, with liberty to the petitioner to invoke section 670 and raise the dispute if he is advised to do so. The result is agilva. The returning officer is directed to announce the result without counting the vote cast by the petitioner. However, keeping the vote cast separately, which shall be subject to the final result of the dispute that may be raised by the petitioner.
Please.
In view of disposal of the petition. Yes.
Number 9, Procedural, Ravichandra MR.
Your Lordships, I appeal for the petitioner.
Yes.
The petitioners herein are the residents of Maragadanahalli village. Earlier, this Maragadanahalli village was within the area of operation of Kodihalli Milk Producers Cooperative Society. The said Kodihalli Milk Producers Cooperative Society passed a resolution and released this village from its area of operation. Pursuant to that, a chief promoter was appointed by respondent number 2, assistant registrar by the Annexure C, with the direction, specific direction for the chief promoter to collect shareholders from the villagers of the Maragadanahalli village, wherein the said chief promoter failed to collect the share amount from the petitioners herein. There was an inquiry conducted by the assistant registrar and the CDO, and the specific direction was issued to the chief promoter to collect the payment from the petitioners herein. They failed to receive the share amount. I approach this honorable court, and this honorable court on 5/11/2025. The Lordships kindly turn to the order dated 5/11/2025. May read your Lordships 5/11/2020.
Petition respondent number 4 has no objection to take you as a
Lord.
member.
And also, your Lordship, there is a specific.
What happened, my lord? On 5th, my lord, there is a.
And a learned counsel for respondent number 4 and additional government advocate undertakes not to register the society till next date of hearing. The said undertaking is placed on record. Learned counsel for respondent seeks for a short accommodation to get instruction and make this submission on merits. On the very same day, along with the amendment application, your Lordships, on the very same day, the said respondent number 2 registers the society. Page 10 along with my respondent number 4 had entered caveat. He had filed caveat on 9/10/2025 and the writ petition copy was served on 4/11/2025. That said submission was made on behalf of the respondent number 4 on 5/11/2025. In spite of that, having the knowledge of the pendency of this writ petition, the respondent number 2 has intentionally and with a bona fide intention has registered the society on 5/11/2025 and also has issued the certificate under section 8 on the very same day. And after that, now on 9,
Where you have
that annexure K, page 10, your lordship.
L.
Along,
L is the certificate.
L is the certificate, K is the order on the very same day, both on 5/11/2025. Now, on 9/11/2025, annexure M, your lordship. Returning officer is appointed and that returning officer at page 18 has issued a calendar of events fixing the date of election on 23rd. The Maragadanahalli village consists of more than 1,500 residents, your lord.
Lord, my submission is, my lord, in respect of my lord, 5/11, my lord, before passing order, my lord, they are registered. One thing. Another thing is, my lord, the petitioners as, my lord, members in Kodihalli society, my lord. Their membership is not transferred to this society. And before that, my lord, they given regarding proclamation regarding that, my lord, they have proposed to in that village. Section 16, my lord, kindly.
No, when you undertake not to register
My lord,
the society.
the order passed, my lord, in the evening session, my lord, to regarding, my lord, on that day, my lord, in morning session itself, my lord, they have been registered.
What was the urgency, sir? What was the urgency? At least respondents were knowing that the writ petition is pending.
Please, my lord, one thing, another thing is, my lord, they're already member of the Kodihalli society. That membership is not transferred to the society.
That was not your submission on the last day.
On that regard, my lord, I will not take an instruction. That is regarding lordship, my lord, I have it on next week ಅಂತ ಹೇಳಿದ್ರಿ ತಾವು.
Publicized in
the main ground
village,
is
my lords. I'm submitting the documents, my lords. Wherein, my lords, we have even after
notice,
public notice was given, they have not come forward, my lords. For the reason they were already being the members of another society, they could not come and register here. They have to seek for transfer of the same. This petition is just to stall the proceedings, my lords. If I have not taken the publicity in the village,
The procedure for transfer of membership.
That AR has to do that.
That
before registration, assistant registrar has to do that.
They have to approach.
And in my writ petition, I have stated so, your lordship.
Your instance.
Your lordship.
At your instance, he has to do that.
He has to do that. I have brought to the notice of the assistant registrar, and in my writ petition, I have stated that, and I have produced annexure A out of 220.
That such a direction was issued, sought in this writ petition, directing the registrar to transfer your membership.
No, that is not there. But that is the before registration, your lordship. That is the duty. The duty cast is upon the assistant registrar. He has to look out all those things.
You read your prayer in the petition, directing to issue writ of mandamus respondents to admit the petitioners as members. It is not your prayer to transfer your
No,
membership.
before admitting, that is the before admission, your lordship. That is the procedure which has to be.
Why that there is no such specific prayer in the petition, sir? Have you stated that I am the member of so and so?
I have stated, your lordship, in paragraph 1.
What is the
Out of 222 members,
membership is to be transferred from one society to
your
another?
lordship, kindly, out of 222 petitioners herein, in my paragraph 1, your lordship, I have stated so, and out of 222, 183 petitioners are the members of Kodihalli Milk Producers Cooperative Society, and 39 petitioners are not the members of any of the societies.
No, when you are already a member in the earlier society, how can the registrar admit you? It is only transfer.
And also, my lord, the society also admits that, my lord, they become a member of the, they are ready to give members.
When they are admitting, your lordship, my submission is, when they are admitting that, when they are conceding before your lordship that they are ready to admit us as the members. then what was the urgency for the respondent number 2 to register the society during the pendency of the writ petition and also after making the submission before your lordship?
According to, you have heard his submission. In the morning session, in the morning itself, that was registered. Now, rightly or wrongly, that is already registered. What is the remedy?
Appeal.
Now your lordship, the problem is that now, out of 1,500, more than one, the villagers are 1,500 villagers. Out of 1,505 odd villagers, only 155 members have been admitted now as the members of the society.
Now you speak for yourself. How many petitioners are there?
222.
Yes.
Your lordship, kindly turn to rule 3, which prescribes how the registration has to be done. What is the duty cast upon the assistant registrar before registering the society, before issuing the certificate under section 8?
What is the duty?
Your lordship,
What is his
he has to prima facie be satisfied that all the conditions which were imposed in wide annexure C has been complied by the chief promoters, and the resolution should be passed within the promoters.
According to you, which is the condition he has not followed?
3 section sub-rule 3, 4, 5, 3A, sub-rule 3 and also 3B is not complied. Your lordships, kindly turn to rule 3, 4 and 5. Now the only intention of the chief promoter is that, your lordships, they have to constitute a board within those 155 members, and after constituting the board, they are ready to admit all the other villages, so that the other villages should not participate in this election and there should be no competition for them. That is the only
Rule 3 in Tandri.
rule 3, sub-rule 4, your lordship.
No.
After getting permission from the registrar, that is, your lordship, in the writ petition wide annexure C, the order, the chief promoter shall get a few receipt books printed in the name of the proposed society and collect the share capital from the persons intending to become the members of the proposed society. He shall issue receipts to the proposed members for the amount collected with his signature under his name and designation. The money so collected shall be deposited within 7 days from the date of collection in an account opened by the chief promoter in the name of proposed society in a scheduled or a cooperative bank. He shall maintain a cash book, receipt book, voucher book, and other accounts for the money collected and remitted to the bank. However, he shall be competent to retain such amount as may be necessary and sufficient to incur incidental expenses like printing, stationery, typing, postage, etc. Sub-rule 5. After collecting the share capital to the extent permitted by the registrar from the specified number of persons, the chief promoter shall convene a meeting. This is not done, your lordship. A meeting of the promoters of the proposed society.
Sub-rule 4 is complied. Sub-rule 4 is complied.
Sub-rule 4 is complied only to the extent of 155 members which they are given.
Yes. Now 5 is not complied according to you.
5 is not complied at all. Particulars of receipts and expenditures incurred and the names of proposed members from whom share capital is collected. After getting a resolution passed in the promoters meeting, he shall submit a proposal to the registrar for the registration of the society in the prescribed application along with 5 copies of the bylaws of the proposed society and the list proposed members with their names and address. If there is any change in the promoters list, it can be ratified by the registering authority. Application shall be signed by each one of the applicants who is an individual and by a person duly authorized on behalf of any cooperative society which is an applicant and shall be accompanied by the prescribed fee. Now, your lordships, kindly turn to sub-rule 3A, 3, sub-rule 3, your lordships, in that. The registrar may, for the purpose of satisfying himself of the matters specified in section 7, call for such further particulars or make such enquiry as he may deem necessary. He may permit the applicants, if so desired by them, in writing to make such alterations or additions to the proposed bylaws submitted with the application in order to make them conform to the provisions of the Act and rules thereunder. If the registrar refuses, that is appeal provision. 3B, now, your lordship. Before registering,
What is the procedure for transfer of your membership from one society to another?
I should make an application to the chief promoter. Chief promoter has to submit the list to the assistant registrar. After registering, and request should be made to the earlier society to transfer that.
You have submitted such an application?
That is not being accepted. That is my case, your lordship. For that reason, I have approached your lordship.
You submitted your application?
I have submitted the representations, your lordship. Kindly turn to, on my representation. First enquiry, your lordships, kindly turn.
Annexure?
D, first, annexure D is the letter. Ulleka, page 54, your lordship.
Hmm.
In that, your lordship, before that, your lordship, may 53 ಒಳಗೆ condition number 7 ಒಂದನ್ನೇ ತೋರಿಸಿ. ಈ chief promoter ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ ಆದೇಶ ಅದು, ಅದರೊಳಗೆ ಕಂಡೀಷನ್ ನಂಬರ್ 7 ಸದಸ್ಯತ್ವ ಬಯಸುವ ಪ್ರತಿಯೊಬ್ಬ ಅರ್ಹ ವ್ಯಕ್ತಿಯಿಂದ ಕಡ್ಡಾಯವಾಗಿ ಸದಸ್ಯತ್ವವನ್ನು ನೋಂದಣಿ ಮಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು ಹಾಗೂ ಷೇರು ಮೊಬಲಗನ್ನು ಸಂಗ್ರಹಿಸಿ ಬ್ಯಾಂಕಿಗೆ ಜಮೆ ಮಾಡಿದ ನಂತರ ಸಂಘದ ನೋಂದಣಿಗಾಗಿ ಕೆಳಕಂಡ ಮಾಹಿತಿಯೊಂದಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸುವುದು. This is the condition imposed in the order wide annexure C while appointing the chief promoter, and that was the duty casted upon the chief promoter to collect all the share amount from all the intended members. That was not done. We made a representation, your lordship, that is your lordships will get at annexure D ಉಲ್ಲೇಖ ದಿನಾಂಕ 10/7/25. annexure D ಒಳಗೆ ಉಲ್ಲೇಖ ಶ್ರೀ MK ಸತೀಶ್ ಕುಮಾರ್ ಬಿನ್ ಕರಿಯಪ್ಪ ಹಾಗೂ ಇತರೆ ಗ್ರಾಮಸ್ಥರ ಮನವಿ ದಿನಾಂಕ 10/7/25. Pursuant to that request, your lordship, assistant registrar has directed the CDO to hold an inquiry. May read your lordship that. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾರಗೌಡನಹಳ್ಳಿ ಗ್ರಾಮ ಮಳವಳ್ಳಿ ತಾಲೂಕು ಇಲ್ಲಿ ನಿಯೋಜಿತ ಹಾಲು ಉತ್ಪಾದಕರ ಸ್ಥಾಪನೆ ಸಂಬಂಧ 9/7/25 ನಡೆಸಿರುವ ಗ್ರಾಮ ಸಭೆಯ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿ ಈ ಕಚೇರಿಗೆ ದೂರನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುವ ದೂರಿನ ಪ್ರತಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಕಳುಹಿಸುತ್ತಾ ಈ ದೂರಿನ ಬಗ್ಗೆ ಗ್ರಾಮಕ್ಕೆ ಭೇಟಿ ನೀಡಿ ಗ್ರಾಮಸ್ಥರ ಸಮ್ಮುಖದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಸಿ ಸಂಘ ಸ್ಥಾಪನೆ ಬಗ್ಗೆ ವಸ್ತುನಿಷ್ಠ ವರದಿಯನ್ನು ನಿಮ್ಮ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ 1 ವಾರದೊಳಗಾಗಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸುವಂತೆ ತಿಳಿಸಲಾಗಿದೆ. Pursuant to that, your lordships, an inquiry was conducted and CDO submits a report holding that yes, there are lapses on the part of the chief promoter. He has not taken wide publication. No advertisement has been taken. So, your lordship, that your lordships will get at page annexure D1, page 56, last paragraph, your lordship. ಆದರೆ ನಿಯೋಜಿತ ಸಂಘಕ್ಕೆ ಸದಸ್ಯರನ್ನು ನೋಂದಣಿ ಮಾಡಿಕೊಳ್ಳುವ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮದಲ್ಲಿ ಬಹಿರಂಗವಾಗಿ ವ್ಯಾಪಕ ಪ್ರಚಾರ ಕೈಗೊಂಡು ಗ್ರಾಮದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಸದಸ್ಯರಾಗ ಬಯಸುವ
annexure D kindly see, my lord. That is a my lord duru. It is not say that my lord give transfer to their society. Kindly see, my lord.
Representation was given.
To regarding my lord dispute is concerned. They say that my lord not to register the another society. Now the lordships are asked my lord question to regarding whether you have given a representation to transfer the membership to this society. ಗ್ರಾಮಸ್ಥರ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ವ್ಯಕ್ತಪಡಿಸಿ ಈ ಕಚೇರಿಯನ್ನು ದೂರನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. They not said the my lord regarding the transfer this membership.
Their grievance is exactly that.
My lord.
Already they are the members of the earlier society.
My lord, in respect of if there is the other society, my lord, unless until my lord the transfer they will remove from their society.
When they gave the representation raising objections,
please,
you could have informed them, give proper application.
No, my lord, we have
See, it was within your knowledge that they are the aspirants for membership.
That has been, my lord, we have called for the taken a report and also
whether any endorsement or reply is given to their representation.
Like they read the last paragraph in
page 55. Bottom ಅಲ್ಲಿ.
ಏನಿದೆ?
Bottom ಅಲ್ಲಿ. 50.
ದಿನಾಂಕ 9/7/25 ನಡೆದ ಪ್ರಥಮ ಸಭೆಗೆ ನನ್ನೂರಿನ ಅಧಿಕಾರಿಗಳಾದ ಮಾರ್ಗ ವಿಸ್ತರಣಾ ಅಧಿಕಾರಿಗಳಾದ ಇಂದಿರಾ ಹಾಗೂ ಮ್ಯಾನೇಜರ್ ಸದಾಶಿವರವರು ಭೇಟಿ ನೀಡಿದರು ಎಂದು ದೂರುದಾರರೇ ಹೇಳಿದ್ದು, ಸದರಿ ಸಭೆಗೆ ಗ್ರಾಮದ 50 ಜನರು ಹಾಜರಾಗಿದ್ದರು ಎಂಬುದಕ್ಕೆ ನಿಯೋಜಿತ ಸಂಘದ ಮುಖ್ಯ ಪ್ರವರ್ತಿಕರು ದಾಖಲೆಯನ್ನು ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಉಲ್ಲೇಖ 2ರ ದೂರು ಅರ್ಜಿಯಲ್ಲಿ ಇತರೆ ಗ್ರಾಮದ ಮುಖಂಡರಿಗೆ ಮಾಹಿತಿ ನೀಡದ ರಹಸ್ಯವಾಗಿ ಕೆಲವೇ ವ್ಯಕ್ತಿಗಳು ಸೇರಿ ಗ್ರಾಮದ ಹೊರಗೆ ಸಭೆ ನಡೆಸಿರುತ್ತಾರೆ ಎಂದು ಆರೋಪಿಸಲಾಗಿದೆ. ಮೇಲ್ಗಂಡ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಯಾವುದೇ ಒಂದು ಸಂಘವನ್ನು ಸ್ಥಾಪಿಸುವ ಮುನ್ನ ಪ್ರವರ್ತಕ ಸಭೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಗ್ರಾಮದ ಎಲ್ಲಾ ಜನರನ್ನು ಸಭೆಗೆ ಕರೆಯಬೇಕೆಂಬ ಬಗ್ಗೆ ಆಗಲಿ ಮತ್ತು ಸಭೆಗೆ ಇತರ ಗ್ರಾಮದ ಮುಖ್ಯಸ್ಥರನ್ನು ಆಹ್ವಾನಿಸಬೇಕೆಂದು ಕಾಯ್ದೆಯಲ್ಲಿ ಅವಕಾಶವಿರುತ್ತದೆ. ಅದ್ಯಾಗೋ 9/7/25ರಂದು ಜರುಗಿದ ಪ್ರವರ್ತಕ ಸಭೆಗೆ ಗ್ರಾಮದ 50 ಜನರು ಹಾಜರಿದ್ದು, ಅಲ್ಲದೆ ಸದರಿ ಸಭೆಗೆ ಮುನ್ಮೂಲ ಅಧಿಕಾರಿಗಳ ಮಾರ್ಗದರ್ಶನಗಳ ಅಧಿಕಾರಿಗಳಾದ ಇಂಜಿನಿಯರ್ ಮತ್ತು ಮ್ಯಾನೇಜರ್ ಸದಸ್ಯರು ಭೇಟಿ ನೀಡಿ ಇದರ ಉಪಸ್ಥಿತಿಯಲ್ಲಿ ಸಭೆಯನ್ನು ನಡೆಸುವುದರಿಂದ 9/7/25ರಂದು ನಡೆದ ಪ್ರವರ್ತಕ ಸಭೆಯನ್ನು ರದ್ದುಪಡಿಸಿ ಮತ್ತೊಂದು ಸಭೆಯನ್ನು ನಡೆಸಿದ ಅಗತ್ಯವಿಲ್ಲವೆಂದು ಮತ್ತು 9/7/22ರಂದು ಜರುಗಿದ ಸಭೆಯನ್ನು ಕಾನೂನುಬದ್ಧ ಸಭೆಯನ್ನು ಪರಿಗಣಿಸಬಹುದು.
Next ಏನು?
For that minutes are produced in the objections minutes, the documents which say we have given all the.
See, with all this, what was the urgency when the writ petition was pending?
My lord, there is a two groups are there, my lord. There somehow.
Let there be a group, sir. Why be the party?
To regarding, my lord, the application, he says that.
For a moment, after the direction was issued on 16th.
No. Yeah. Very
2025 minutes, we have given notices. We have produced photographs for having affixed everywhere in the village. They don't come forward, minutes. If they don't come forward, minutes, what should we do, minutes? They come here before this honorable court. Then on 16th, we have posted in the public notice everywhere in the village. They don't see that. But at least when they know it, minutes, they could have given a representation stating that we are not accepting their membership. That is not their grievance. They say that.
Sir, my simple question.
Yes.
Writ petition was pending.
Yes.
You made a representation along with learned AG not to register the society. On the same day, you go and register the society. Get the certificate.
One submission.
Can it be held as very fair and reasonable?
I made a submission, Manoj. Already we have submitted everything to the register.
So you should have informed them.
Manoj, on 5th morning, this happened, Manoj, we did not know, Manoj.
So when
Then they have.
see, respondent number 4 was knowing about the pendency of the writ petition. He engaged you as a counsel,
Yes.
right?
Yes.
You appeared before this
Yes.
court. And was it not necessary for respondent number 4 to inquire as to what had happened in the court? Or was it not necessary for you to inform respondent number 4 regarding the undertaking given by before this court?
I told them, Manoj, that Manoj, we have undertaken to make them members of the society.
No, what was the hurry for the respondents?
Subsequently, it has communicated to us, Manoj. It was not communicated.
No. It will be subject to the result of the writ petition. Registration.
I will make a place.
Or may I make a
submit the application and let them get registered before in the society. We are only asking them to register. They have not come forward with the application. Their grievance.
You file a necessary application.
Your Lordship, may.
Their grievance is not that they are not accepting the application. Their grievance is that they have not publicized it. When we are providing everything,
By
they also.
Your Lordship, if they make a submission
Who is the chief
before
promoter?
within
They cannot come before me.
Now calendar is issued.
within 3
Calendar is issued.
within 3 days, we will give the application along with the share amount, Your Lordship. After admitting us as the members, let them conduct the election for the first board.
Transfer, they have to give to the AR March.
Tomorrow itself we will give. Tomorrow itself.
Transfer with them. Their representation may kindly be seen.
Tomorrow itself we will give.
What is the, see, tomorrow he will submit the application along with required fees.
If it is in accordance with law, we will consider and that registration minutes they have to take up.
Let them, my lord, they give the registration to transfer this membership to the new societies concerned.
ಅಷ್ಟೇ ಟ್ರಾನ್ಸ್ಫರ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ.
ಅಲ್ಲ ಅದು ಹಾಗೆ ಆಗುತ್ತೆ. ಯಾಕಂದ್ರೆ 16 ಕೆಳಗಡೆಗೆ there is a bar. I cannot be a member of 2 villages and there is a restriction. Your Lordship kindly turn to section 16. ಅಲ್ಲ ಅದನ್ನು ನಾನು ಮಾಡ್ತೀನಿ. ನಾಳೆನೆ ನಾನು ಅಲ್ಲಿಗೂ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ತೀನಿ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಯುವರ್ ಮೆಂಬರ್ಶಿಪ್
ಅದನ್ನು ನಾಳೆನೆ ಕೊಡ್ತೀನಿ. ಅಮೌಂಟ್ ಶೇರ್ ಅಮೌಂಟ್ ಅನ್ನು ನಾಳೆನೆ ಕೊಡ್ತೀವಿ ನಾವು. ಇವ್ರು ಅದು ಆಗ್ತಿದ್ದಂಗೆ ಎಲೆಕ್ಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ಲಿ ಫ್ರೆಶ್ ಆಗಿ.
ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
ನಾನು AR ಗೆ ಕೊಡ್ತೀನಿ ಡೈರೆಕ್ಟ್ ಆಗಿ.
ಅಲ್ಲ ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು? ಚೀಫ್ ಪ್ರಮೋಟರ್ ಗೆ.
ನಾನು ಅವರಿಗೆ ನಾಳೆ ಕೊಡ್ತೀನಿ ಚೀಫ್ ಪ್ರಮೋಟರ್ ಗೆ.
Also the society
R4. ಕೊಡಿ ಅವರಿಗೆ.
ಅವರಿಗೆ ನಾಳೆ
Now
ಕೊಡ್ತೀವಿ.
he is represented by an advocate.
ಚೀಫ್ ಪ್ರಮೋಟರ್ಗೆ ನಾಳೆ ಕೊಡ್ತೀವಿ. ಆಮೇಲೆ ನಾವು ಟ್ರಾನ್ಸ್ಫರಿಗೂ ಅಪ್ಲಿಕೇಶನ್ ನಾಳೆನೆ ಕೊಡ್ತೀವಿ ವಿತ್ ಅಮೌಂಟ್ ಅನ್ನ. ಅದಾದ್ಮೇಲೆ ಎಲೆಕ್ಷನ್ ಮಾಡ್ಲಿ ಅವರಷ್ಟೇ.
In violation of the undertaking given to this court, refer to in the order dated 5/11/2025. Respondent number 4, in collusion with the other respondents, managed to register the society on the very same day, that is on 5/11/2025. And who issued the certificate?
R2 your lordship.
Respondent number 2 issued the certificate as per edition L. Next, learned counsel, learned AGA for respondents 1 to 3 and learned counsel for respondent number 4 submit that even though such an undertaking was given in the afternoon session, the registration of the society was complete in the morning session, which was not communicated to them. Next part. Learned counsel for respondent number 4 suggests that the petitioners let petitioners give necessary application for transfer of their membership from which society?
Kodihalli Milk Producers Cooperative Society
Milk Producers Cooperative Society
to Maragaudanhalli Milk Producers Cooperative Society.
Milk Producers Cooperative Society along with fees in the required format ಇದೆ ಅದಕ್ಕೆ.
ಅದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರಿಗೆ ಅವರು
in accordance with law.
ಉಳಿದ
The
ವಿಲೇಜ್
same will be considered.
those who are not members of that villages, they will directly pay the share.
Sir, why you hold the brief, sir? I am concerned only with petitioners.
ಅಲ್ಲ petitioners ಒಳಗೆ 183 ಮಾತ್ರ ಅಲ್ಲಿ ಮೆಂಬರ್. ನಾನು ಆ ಲಿಸ್ಟ್ ಅನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಅನಕ್ಷರಿ.
ಈಗ petitioners ಅಲ್ಲಿ ಕೊಡಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ನಾಳೆ.
ಅಲ್ಲ 33 ಅದರೊಳಗೆ 33 members, they are not the members of Maragaudanhalli village. In paragraph 1 I have stated so your lordship.
Then who will file the application?
One who are annexure A ಒಳಗೆ ಏನ್ ಮೆಂಬರ್ಸ್ ಲಿಸ್ಟ್ ಇದೆ
ಅವರು ಯಾರು ಅಂತ ಹೇಳಿ. They are not the petitioners.
ಅದೇ petitioners.
ಅದನ್ನ ಹೇಳಿ ಯಾರ್ಯಾರು ಅಂತ. Learned counsel for the petitioner submits that petitioner numbers.
ಅಲ್ಲ ಹಂಗ ಅಲ್ಲಿ ಯಾರು ಮೆಂಬರ್ಸ್ ಇದಾರೆ ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳಲಿ. ಅದರ್ ದೆನ್ ಹೂ ಆರ್ ನಾಟ್ ಮೆಂಬರ್ಸ್ ಅವ್ರು ಡೈರೆಕ್ಟ್ ಆಗಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ಲಿ ಅಂತ ಹೇಳಿ ಶೇರ್ ಅಮೌಂಟ್ ಅನ್ನು ಡೈರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ಲಿ ಅಂತ.
You yourself is not clear.
ಅಲ್ಲ ಅದು 200
transfer of membership ಅಂತ
my lord, they say that my lord, they are already member of the society. They are my lord two categories of the peoples my lord file the petition.
ಇಲ್ಲ ಈಗ ಅದನ್ನು ಕ್ಲಾರಿಫೈ ಮಾಡಿ. Which of the petitioners will submit an application?
ಅಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ.
ಕೊಡಿ, ಅದು ಕೊಟ್ರೆ ಮಾತ್ರ ಇದು ಮಾಡಿ.
ಅಲ್ಲ ಅದನ್ನ ನಾನು ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ಅಂತ.
Counsel for the petitioner submits that petitioner numbers so and so will submit necessary application to respondent number 4 along with share amount
prescribed under wide annexure C
in accordance with law, and the same may be considered to transfer the membership as referred to above. In view of the above, the petitioners referred to above are permitted to submit the representation and submit the application along with share amount to respondent number 4 by tomorrow, upon which respondent number 4 take necessary steps in that regard. This time. ಆಯ್ತು, ಅದೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡಿ ಏನಾಗಿದೆ.
ಅಲ್ಲ 23rd ಗೆ ಎಲೆಕ್ಷನ್ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ. Till then let them not conduct election because ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ ಎಲೆಕ್ಷನ್ ರೀಶೆಡ್ಯೂಲ್ ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ.
Lordship my lord, to say my lord, if tomorrow they will give my lord, they will consider that unless my
ನಾಳೆ ಕೊಡ್ಲಿ, ನಾಡಿದ್ದಿಗೆ ಲಿಸ್ಟ್ ಮಾಡಿ
please.
ಮತ್ತೆ ನಾಳೆ ಮತ್ತೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಇಲ್ಲ.
ಇಲ್ಲ ನಾನು ನಾಳೆ ಯಾರು ಎಷ್ಟು ಕೊಡ್ತಾರೋ ಅಷ್ಟಕ್ಕೆ ಅವ್ರಿಗೆ ಬೆನಿಫಿಟ್
ಅಷ್ಟೇ. ಮತ್ತೆ ಅದಾಯ್ತು ಇದಾಯ್ತು ಅಂತ ಕತೆ ಹೇಳ್ತಾ
ಅಲ್ಲ,
ಇರ್ಲಿಲ್ಲ.
even though my lord ಅವ್ರು ಕೊಟ್ಟೆ ಬರ್ಬೋದಿತ್ತು ಇವತ್ತು.
ಅಲ್ಲ ಎಲ್ಲಾದ್ರೂ ನಮ್ದೇ ತಪ್ಪಿದೆ, ನಿಮ್ದು ಇಬ್ಬರದು ಏನು ತಪ್ಪೇ ಇಲ್ಲ. ಮಚ್ಚು
ಏನಿಲ್ಲ.
I appear for the petitioner's counsel, Miller. The petitioners are all elected directors of respondent 6 primary society.
Yes, you take this for respondent.
1, 2, 4, 5 government executive, 3 ಗೆ ದೇವರಾಜು, respondent 6 ಗೆ 6 ಗೆ your lordship may permit me to take hand summons. Kindly see the order at annexure G, page 100. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕುರುಬೂರು ರೇಷ್ಮೆ ಬೆಳೆಗಾರರ ಹಾಗೂ ರೈತರ ಸೇವಾ ಸಹಕಾರ ಸಂಘ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರ ಚುನಾವಣೆಯನ್ನು ನಡೆಸಲು 12/6/23ರಂದು ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿ ನೇಮಕ ಮಾಡಿ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದ್ದು 22/11/25ಕ್ಕೆ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರ ಅವಧಿಯು ಮುಕ್ತಾಯಗೊಳ್ಳಲಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರಿಂದ 4ರ ಪತ್ರಗಳಲ್ಲಿ ಆನೂರು ಹಿರೇಕಟ್ಟಿಗೆನಹಳ್ಳಿ ಗ್ರಾಮದ ಸದಸ್ಯರು ಮನವಿ ನೀಡಿ ಈಗಾಗಲೇ ಆನೂರು ಹಿರೇಕಟ್ಟಿಗೆನಹಳ್ಳಿ ಗ್ರಾಮಗಳಲ್ಲಿ ಹೊಸದಾಗಿ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘಗಳು ನೋಂದಣಿಯಾಗಿರುವುದರಿಂದ ಈ ಗ್ರಾಮಗಳನ್ನು ಕೈ ಬಿಟ್ಟು ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಅನುಮೋದನೆ ಮಾಡಲು ಕೋರಿದ್ದಾರೆ. They want 2 villages, voters from members from 2 villages to be excluded. Third parties make that complaint. ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಸಂಘದ ಅಂತಿಮ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಈಗ ಸಲ್ಲಿಸಿ ಅನುಮೋದನೆ ಮಾಡಿಕೊಡಲು ಕೋರಿರುತ್ತೀರಿ. ನೀವು ಸಲ್ಲಿಸಿರುವ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಆನೂರು ಹಿರೇಕಟ್ಟಿಗೆನಹಳ್ಳಿ ಗ್ರಾಮಗಳನ್ನು ಸೇರಿಸಿ ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸಿರುತ್ತೀರಿ. ಆದರೆ ಉಲ್ಲೇಖ 2ರಿಂದ 4ರವರೆಗಿನ ದೂರು ಅರ್ಜಿಗಳನ್ನು ನಿಮಗೆ ಕಳಿಸಿ ಅಂತಿಮ ಮತದಾರ ಪಟ್ಟಿ ತಯಾರಿಸುವಾಗ ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ತಯಾರು ಮಾಡಲು ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ಆದರೆ ನೀವು ಸಲ್ಲಿಸಿರುವ ಅಂತಿಮ ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಆನೂರು ಹಾಗೂ ಹಿರೇಕಟ್ಟಿಗೆನಹಳ್ಳಿ ಗ್ರಾಮವನ್ನು ಸೇರಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಈ ತನ್ಮಧ್ಯೆ ನಿಮ್ಮ ಸಂಘದ ಮುಖಾಂತರ ಮಾನ್ಯ ಗೌರವ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ದಾಖಲು ಮಾಡಿದ್ದು ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ನಿಯಮ ಪ್ರಕಾರ ಚುನಾವಣಾ ದಿನಾಂಕಕ್ಕೆ 15 ದಿನಗಳ ಮುಂಚೆ ಅಂತಿಮ ಮತದಾರ ಪಟ್ಟಿ ಅನುಮೋದನೆಯಾಗಬೇಕಾಗಿದ್ದು ನಿಮ್ಮ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ದೇಶಕರ ಅವಧಿಯು 22/11/25ರಂದು ಮುಕ್ತಾಯಗೊಳ್ಳಲಿರುವುದರಿಂದ ಅಂತಿಮ ಮತದಾರ ಪಟ್ಟಿಗೆ ಆಕ್ಷೇಪಣೆಗಳು ಸಲ್ಲಿಕೆಯಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುವುದರಿಂದ ಈ ಹಂತದಲ್ಲಿ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಅನುಮೋದನೆ ಮಾಡಲು ಬರುವುದಿಲ್ಲ. So they don't want to hold election. What actually has happened is, my lord, kindly see annexure E.
Now, who is the petitioner?
Petitioners are all the elected directors, members of respondent number 6. A direction under section 12(5) was issued saying you delete 2 villages from your area of operation. We pointed out it is not possible. We did not agree to that. Then in the meanwhile, election was to start. We made all the efforts, prepared the voter list. Earlier to 6 months, we informed them.
Already those 2 cooperative societies are registered now. Anuru and
It will not make any difference if there is a society registered. Kindly. ಆನೂರ್ ವಿಲೇಜ್ ಅನ್ನ ನಾವು ಪಾರ್ಟಿ ಮಾಡೋದಿಲ್ಲ, ಅವರಿಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
When such a submission was made? For the first time it is listed, sir.
Your lordship may kindly have WP 32/529 of 2025. It had come up day before yesterday challenging 12(5).
ಯಾವುದು ಡಿಫರೆಂಟ್ ರಿಟ್ ಪಿಟಿಷನ್
ಅಂದ್ರೆ ಸೊಸೈಟಿನೇ ಹಾಕಿರೋದು ಈ 12(5) ಕೆಳಗೆ ಈ ವಿಲೇಜ್ ಅನ್ನ ಡಿಲೀಟ್ ಮಾಡಬೇಕು ಅನ್ನೋದನ್ನ ನಾವು ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
This is coming for the first time.
This
similar case.
Guys, a direction under 12(5) is issued saying you delete these villages because there are separate societies registered in those societies, in those villages. On the ground of division or etc. Kindly turn to page 26.
She may kindly have it tomorrow that she will take instructions.
Page 26, my lord. First question, your lordship may kindly see. I put page 26.
In this writ petition, it is allowed partly.
The first question, your lordship may kindly see page 26. I put page 26.
Yes.
Whether by direction issued under subsection 5 of section 12 of KCS Act, the area of operation of an existing society can be directed to be deleted to facilitate the establishment of a new society. That was the main question that was raised. Kindly go to page 41. (15.19). Thus, I answer point number 1 by holding that no direction can be issued under subsection 5 of section 12 of the KCS Act to delete a particular Gram Panchayat or a taluk or a district from the area of operation of an existing society, let alone to facilitate the establishment of a new society. ಇದನ್ನ ನಾವು we informed them. Kindly see, ಆ ಊರಿನ ಮೆಂಬರ್ಗಳು ನಮ್ಮಲ್ಲಿ ಲೋನ್ ತಗೊಂಡಿದ್ದಾರೆ, ಆ ಲೋನ್ಗಳನ್ನೆಲ್ಲ ಇನ್ನೂ ರಿಟರ್ನ್ ಮಾಡೋದಿದೆ. Kindly see annexure F, malo. Page 97. Page 97. 18. Got it, malo. Page 97. ಈಗಾಗಲೇ ಕೊಟ್ಟಿರುವ ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ಅನುಮೋದಿಸಿ ಕೊಡುವ ಬಗ್ಗೆ ತಮ್ಮ ಪತ್ರದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ. ಉಲ್ಲೇಖದ ಪತ್ರವು 18/10/25 ವಾಟ್ಸ್ಆಪ್ ಮುಖಾಂತರ ನಮಗೆ ತಲುಪಿರುತ್ತದೆ. ಸದರಿ ವಿಷಯವು ಸಂಘದ ಅಧ್ಯಕ್ಷರ ಗಮನಕ್ಕೆ ತರಲಾಗಿರುತ್ತದೆ. ಅಧ್ಯಕ್ಷರು ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಸ್ವತಃ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳುವುದು ಸೂಕ್ತವಲ್ಲವೆಂದು ತಿಳಿಸಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ಗಮನಕ್ಕೆ ತಂದು ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯು ಕೈಗೊಳ್ಳುವ ತೀರ್ಮಾನವನ್ನು ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರಿಗೆ ತಿಳಿಸುವುದು ಸೂಕ್ತವೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟು ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯನ್ನು 28/10/25 ನಿಗದಿಪಡಿಸಲಾಯಿತು. ಸದರಿ ಸಭೆಯಲ್ಲಿ ಈ ಕೆಳಕಂಡ ತೀರ್ಮಾನಗಳನ್ನು ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ನಮ್ಮ ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಲ್ಲಿ 3 ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ 29 ಗ್ರಾಮಗಳು ಒಳಗೊಂಡಿರುತ್ತವೆ. ಈ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳ ಪೈಕಿ ಹಿರೇಕಟ್ಟಿಗೇನಹಳ್ಳಿ ಮತ್ತು ಆನೂರು ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳಲ್ಲಿ ಪ್ರತ್ಯೇಕವಾಗಿ ಕೃಷಿ ಪತ್ತಿನ ಸಹಕಾರ ಸಂಘ, ಹಿರೇಕಟ್ಟಿಗೇನಹಳ್ಳಿ, ಆನೂರು ವಿವಿಧೋದ್ದೇಶಕ ಪ್ರಾಥಮಿಕ ಕೃಷಿ ಗ್ರಾಮೀಣ ಸಂಘ ಆನೂರು ಗ್ರಾಮಗಳಲ್ಲಿ ನಮ್ಮ ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸದೇ ಇದ್ದರೂ ಸಹ ಸದರಿ ಸಂಘಗಳನ್ನು ನೋಂದಾಯಿಸಿರುವುದು ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರ ಉಲ್ಲೇಖಿತ ಪತ್ರದಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ದಟ್ ಈಸ್ 1710 ಪತ್ರ. ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯು 28/10/25 ನಡೆದ ಸಭೆಯಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳಲಾಗಿದೆ. ಆನೂರು ಮತ್ತು ಹಿರೇಕಟ್ಟಿಗೇನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿರುವ ರೈತರು ಸುಮಾರು ವರ್ಷಗಳಿಂದ ನಮ್ಮ ಸಂಘದ ಸದಸ್ಯರುಗಳಾಗಿದ್ದು ಅವರುಗಳಿಗೆ ನಮ್ಮ ಸಂಘದಿಂದ ಕೆಸಿಸಿ ಸಾಲ, ನಗದು ಸಾಲ, ವ್ಯಾಪಾರ ಸಾಲಗಳಂತಹ ಸಾಲಗಳನ್ನು ಕೊಡಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಸದಸ್ಯರಿಂದ ಸಾಲ ವಸೂಲಾತಿ ಮಾಡುವ ಜವಾಬ್ದಾರಿಯು ನಮ್ಮ ಸಂಘದ ಹೊಣೆಗಾರಿಕೆ ಆಗಿರುತ್ತದೆ. ಆನೂರು ಹಿರೇಕಟ್ಟಿಗೇನಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿರುವ ಸದಸ್ಯರು ಸದಸ್ಯತ್ವ ಅಥವಾ ಸದರಿ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯನ್ನು ಸಂಘದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸುವ ಅಧಿಕಾರವು ವಾರ್ಷಿಕ ಮಹಾಸಭೆಗೆ ದತ್ತವಾಗಿರುತ್ತದೆ. ಹಾಗಾಗಿ ಈ ಹಂತದಲ್ಲಿ ವಾರ್ಷಿಕ ಮಹಾಸಭೆಯನ್ನು ನಡೆಸಲು ಕಾನೂನಾತ್ಮಕ ತೊಡಕು ಇರುವುದರಿಂದ ಮತ್ತು ಈ ವಿಷಯದ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಯಾವುದೇ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳಲು ಕಾನೂನಿನಲ್ಲಿ ಅವಕಾಶ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಯಥಾಸ್ಥಿತಿ ವಿಷಯವನ್ನು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರ ಗಮನಕ್ಕೆ ತಂದು 22/11/25ಕ್ಕೆ ಮುಕ್ತಾಯಗೊಳ್ಳಲಿರುವುದರಿಂದ ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರ ಸುತ್ತೋಲೆ ನಿರ್ದೇಶನ ಸಹಕಾರ ಸಂಘಗಳ ಕಾಯ್ದೆ ನಿಯಮಗಳ ಅಡಿಯಲ್ಲಿ ತುರ್ತಾಗಿ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆ ನಡೆಸುವುದು ತುಂಬಾ ಅವಶ್ಯಕತೆ ಇರುವುದರಿಂದ ಸಂಘವು ಈಗಾಗಲೇ ಸಲ್ಲಿಸಿರುವ ಮತದಾರ ಪಟ್ಟಿಯನ್ನು ಅನುಮೋದಿಸಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯ ಚುನಾವಣೆಯನ್ನು ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ನಡೆಸಲು ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಇವರಿಗೆ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗೆ ಸೂಚಿಸಲಾಯಿತು. ನಾನೀಗ ತೋರಿಸಿದ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಸೇಮ್ ಕ್ವಶನ್ delete those villages because they are registered in new society. Such a thing is not permissible to be done is the judgment. ಅದರದ್ದು ಸ್ವಲ್ಪ ಡಿಸ್ಕಷನ್ ನೋಡೋದಾದ್ರೆ kindly turn to 50.14 para, that is page 36. The perusal of section 14 indicates that such amalgamation, transfer of assets and liabilities or division of cooperative societies contemplated under section 14 is voluntary in nature. It is for the members of the cooperative society to decide on any of the above to pass a resolution which can be given effect to. Section 14A, which has been omitted in the year 2013, effect from 11 to 2013, prior to deletion, is read as under. There could have been division of the cooperative society, there could have been amalgamation of cooperative society by a direction of the department. Then 15.60. Thus, it is prior to 11/2/2013 that the registrar could have directed amalgamation, division, reorganization in public interest. The said provision has been deleted with effect from 11/2/2013 in pursuance of the 97th Amendment to the Constitution, wherein the right of cooperative society to be democratically run has been accepted. It is in pursuance of the said 97th Amendment that interference by the officers of the government or by the government has been restricted and cooperative society would be required to be run as per the democratic will of the members of the society, so long as they comply with the requirements of the ACS Act. There is duty which has been cast on the state under 43B, Article 43B to promote voluntary formation, autonomous functioning and democratic control and professional management of cooperative society, which is also in furtherance of the right to carry on business recognized in Article 91G. The fact that 14A has been omitted from the statute to contemporaneous with 97 would indicate that registrar would not have any right to direct amalgamation, transfer of assets, division, reorganization of the cooperative society, and the only manner in which the same can be done is voluntarily under section 14 of the ACS Act. Therefore, there is no particular statute or object recognized in the ACS Act which would confer power of the registrar to direct deletion of any particular area from the area of operation of an existing society so as to facilitate establishment of a new society. Then there are the KTC point towards the society and the register model. The existing society of a consent whoever wants, they can resign and go. Whether there is a mandate for establishment of PSCS in Gram Panchayat, whether there is an embargo on 2 or more PSCS operating in the same area.
Yes.
That would be page 41, point number 2. Court held. Page 50, para 16.30. Hence, I answer point number 2 by holding that mandate under the circular of 2008 to establish PSCS in each Gram Panchayat does not operate as an embargo for two PSCS to operate in the same area. It would not require an existing PSCS to delete from its area of operation a particular Gram Panchayat to enable establishment of a PSCS in that Gram Panchayat. It is for the member of an existing PSCS to comply with all his obligations to the PSCS of which he is a member. Thereafter, resign and join the new PSCS. If a person is not a member, the discretion would always be of such person to join such cooperative society as he or she wishes to join. Now, 22nd ಗೆ ನಮ್ದು ಟರ್ಮ್ ಮುಗಿತದೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡೋದಕ್ಕೆ ನೀವು ವೋಟರ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಅದರ ವಿಲೇಜ್ ಅನ್ನ ನೀವು ಬಿಟ್ಟಿಲ್ಲ ಅದಕ್ಕಾಗಿ ನಾವು ಇಲೆಕ್ಷನ್ ಮಾಡೋದಿಲ್ಲ ವೋಟರ್ ಲಿಸ್ಟ್ ಅಪ್ರೂವ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ. The other petition challenging that qualified direction is 32529 of 2025. ನಾವು ಮೊನ್ನೆ ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀವಿ. Now I request the Lord, it may be taken with 32/5/25, but let them not appoint administrator. It is not their mistake that these things are.
32/5/25.
I know, but complications, like, why do you complicate the issue?
Election ಮಾಡೋದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲವನ್ನೂ ಮಾಡ್ತಾರೆ.
ನ್ಯಾಯಾಲಯದ ರಿಕ್ವಿಡಿಷನ್ ದಾಖಲು ಮಾಡಿ ವಿಚಾರ ಅಂತ ಕಂಡು ಬಂದಿರುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ pendency of the requisition also will expire. The board will expire. The term of the board will expire.
See, the decision of the coordinate bench is very specific in that regard. Then categorically it is held. There cannot be no such directions. There cannot be any such direction. ಅದಕ್ಕೆಲ್ಲ ಗ್ರೌಂಡ್ ಮಾಡೋದು ಯಾರು ಸರ್? ಗ್ರೌಂಡ್ ತಯಾರು ಮಾಡೋರು ಯಾರು? ಸುಮ್ಮನೆ ಅನ್ನೆಸೆಸರಿ ಇವೆ. ಅದು ನೋಟಿಸ್ ಆಯ್ತಲ್ಲ. Heard learned senior advocate for the petitioner. He submits that annexure G dated 10/11/2025. It is an endorsement issued by the Joint Registrar of Cooperative Societies, Chikkaballapura, respondent number Joint Registrar and Deputy Registrar, Joint respondent number 4, refusing to approve the final voters list. Even though the term of office of the petitioner society would expire on 22/11/2025. The apprehension of the petitioners is that the respondents, taking advantage of this order, will appoint an administrator immediately after expiry of term of office of the directors on 22/11/2025. Next paragraph. Then senior advocate refer to the decision of the court, this court in WP number 1098 of 2024, dated 1/5/2025, to contend that a categorical finding is recorded by the coordinate bench that the directions that no directions could be issued under subsection 5 of section 12 of ACS Act, the area of operation of an existing society, be directed to be deleted to facilitate the establishment of new society. And it is also held that the existing PACS to delete from its area of operation a particular Gram Panchayat to enable the establishment of a PACS in that Gram Panchayat. It is held that it would not require an existing PACS to delete from its area of operation a particular Gram Panchayat to enable the establishment of a PACS in that Gram Panchayat. It is for the member of an existing PACS to comply with all his obligations to the PACS of which he is a member, thereafter resign and join the new PACS. In view of the above, it is the contention of the learned senior advocate that there cannot be any direction to form the direction that can be issued under section 12(5) of KCS Act to delete a particular Gram Panchayat or a Taluka Panchayat from the area of operation of an existing society, let alone to facilitate the establishment of a new society. Therefore, he prays for an interim order staying appointment of arbitrator. By staying the impugned endorsement annexure G. Learned AGA prays for time. List tomorrow. ಅಲ್ಲ ನಾಳೆ ಏನೋ ಹೇಳ್ತಾರಂತಲ್ಲ ಹಾ ಅಷ್ಟರೊಳಗೆ ಮತ್ತೆ ಮಾಡ್ಕೊಂಬಂದಿದೀವಿ ಅಂತ ಹೇಳಿ ತಗೊಂಡ್ ಬಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಡಿ. ನೋಡೋಣ ನಾಳೆ ನೆಕ್ಸ್ಟ್
Serial number 11 is Saravana.
Standard register of cooperative society also will be necessary party.
ಅದಕ್ಕೆ ಏನಾದರೂ ಒಂದು ಹಾಕಿ ಅದಕ್ಕೆ ಫೈಲ್ ಮಾಡಿ ಆಯ್ತು ಫೈಲ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಬೇಕಾ ಪಾಸ್ ಓವರ್ ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ನಾಳೆ ನೆಕ್ಸ್ಟ್
Serial number 11 is Saravana.
Number 1 to 13 clause, they are the board of directors of third component society. The lordship may refer to page number 14 section D. The board was constituted on 27/9/2023. The lordship may refer to serial number 15 that out of 15 directors, serial number 15 and assistant minister of cooperative society also one of the directors.
ಎಲ್ಲಿದೆ ಅದು ಪೇಜ್ ನಂಬರ್? ನೆಕ್ಸ್ಟ್ ಡಿ ನಾ? ಬಿ.
the date code is constituted and think of their case as one of the nomination directors.
Serial number?
15, serial number 15. What will get? So he's also a part of the code. So now what happened? On 3/10/2025, delegation is submitted by the third respondent society to the fourth respondent society to participate in the election, which scheduled on 7/12/2025.
Election to which society?
Fourth to the respondent, the federal society.
Who is the delegate?
That's the first petitioner is the president of the third respondent society. After 3/10/2025, delegation form is submitted. Okay, the third connection B, page 20. Assume order proceedings, show cause notice, under section 29C issued.
ಏನಿದೆ ನೆಕ್ಸ್ಟ್ ಡಿ?
Section D, page number 20.
What is this?
This is the show cause notice. We have initiated a under section 29C.
ಯಾರಿಗೆ?
It's to the board of directors,
All the petitioners.
all the petitioners. So there are 5 charges. All trivial in nature, not that we will answer it.
Yes.
He has called us tomorrow to submit our explanation. So our difficulty is not the election is scheduled on 7/12/25. In similar matters, not there is a series of show cause notices. And this code has not notified and has passed the order. Giving a timelines to submit the reply and to consider them and to pass the necessary orders. Argument was different. Same arguments. Similar petition. The side of cases.
Yes. Let them file their explanation. Consider that. And when will you consider that? Why?
Actually, here, first they have to give explanation. They have to file objections, whatever. It's only thereafter order will be passed.
His apprehension is that you may pass order within on 6th evening. ಅಲ್ಲ ಆಗ್ತಾ ಇದೆಯಲ್ಲ. That is the only apprehension. ಅದೇ on 6th you may pass some orders. So I'll permit them to file objections.
section 13 invoke ಮಾಡಿದ್ರು. In this state we apply ಮಾಡಬೇಕಾಗಿತ್ತು ಆದರೆ 29C ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದೆಲ್ಲ ಆಯ್ತು ಇಲ್ಲ. Context is different.
Context ಬಿರ್ಲಿ, but result will be the same ಅಷ್ಟೇ. How much time was given for you to give the reply? Within how many days?
Tomorrow is the 8th.
Tomorrow. You submit the reply by then. Submit the reply and produce the copy of it. Third learned counsel for the petitioner and the first learned AG takes notice for respondent number 1. ಯಾಕೋ ಯಾಕೆ
Auditing procedures by charges is related to purely auditing procedures, not something pertaining.
No, show cause notice is dated
Notice is dated
13/11.
Yes, and the allegations at page 21, everything is related to auditing procedures.
See, he was ready to submit his objections, but for your intervention.
But we are only saying, we file our objections within 2 weeks from tomorrow. Let them consider. These are all the kind of, so far as 2 and 3 is concerned, it's only a compliance. Our audit report, that's the statutory audit itself says that we have already complied with. An objection we file within.
Then I will simply adjourn tomorrow.
Please, Willows.
You take notice for whom respondent number 1 and 2.
1 man to that, I'm used to.
He takes notice for respondent number 1 and 2. Issue notice to respondent number 3. This tomorrow. When counsel for the petitioner submits that. The term of office of the board of the petitioner would expire on 7/12. Election is scheduled on
7/12 minutes to the fourth
election for the respondent number 4 society is scheduled to be held on 7/12/2025. In the meantime, petition number 1. In the meantime, petition number 1 being the president of respondent number 3 society is the delegate appointed to respondent number 4 society, who is authorized to vote in the election that is to be held on 7/12/2025. In the meantime, Annex D dated 13/11/2025 was issued under section 39C of the Cooperative Societies Act, calling upon the petitioners to show cause for various charges which are 5 in number. The apprehension of the petitioner is that without holding proper inquiry and without providing proper opportunity to the petitioners and without holding any inquiry, the petitioners may be disqualified from voting, casting their vote in the election that is scheduled to be held on 7/12/2025. Next, learned AG plays for a day's time to get instructions and to make his submission. This time. Tomorrow.
I represent Millard, impeding applicants. Let this petition will become infectious, Millard, as the election term of the election is already concluded. It will expire on 5 years, expires on 21st, Millard. This petition is not survivable, it has to be dismissed.
Huh?
The register declared on 9/11/2020. Board was constituted on 21/11/2021. So in another 4 days.
The submission may kindly be recorded, matter could be disposed of.
Disposed, Millard, fresh election has to be conducted, Millard, in accordance with law.
So the term of office of the board will expire on 21/11.
21/11, Millard.
2021.
And we are the implementing applicants, my lord. We may be implemented as respondents also.
Pleading and better, sir, in view of the submission.
Yes, yes.
Learned AG for respondent. Number 1, 3 to 3, 5 and 8. And learned counsel for the impleading applicants. Submit in unison that the board of, the term of office of the board would expire on 21/11/2021, and therefore a fresh election will have to be held for which society?
7th society, my lord.
Respondent number 7 society.
Society. Let it's a women's society, my lord. Let there be a direction to conduct the election immediately. Invite the tender, my lord. They have to, as per section 13, 14, my lord, they have to issue notification.
It's not survive for consideration. The senior advocate is also for the petitioner submits that the submissions of the learned counsel for the learned AGA for respondents and the learned counsel for the implementing application may be placed on record and the petition may be disposed of. Both the submissions are placed on record. In view of the above, writ petition is disposed of. In view of disposal of the writ petition, the ISO issue stands disposed of. It's disposed of. Yes.
Great. Next.
Let my submission, then let there be a direction to conduct the election immediately, my lord.
Expire admele, it is their duty, alma.
No, because of pendency of this writ petition, my lord. Pendency of this petition for a whole 5 years, my lord, it was happened.
That will expire on 21/11/2025.
Within 7 days, my lord, they need to issue notification.
26 ಗೆ ಬರೋದು ಇದು. When it will expire, sir?
21st, my lord.
11 of this year.
Yes. Another 5 days, sir.
5 days. ಅಲ್ಲ ಇಮಿಡಿಯೇಟ್ಲಿ ಹೇಳಿರಿ ಅಂದ್ರೆ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಇದಾಗಿದೆ.
They have to issue notification. Calendar of events.
ಅದೆಲ್ಲ ಆಗ್ಬೇಕು. ಆಗ್ಬೇಕು. We do not know. We do not know. ಅದೆಲ್ಲ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ ಅಷ್ಟೇ.
Electoral college to be constituted thereafter.
ಎಲ್ಲ ಮಾಡ್ಲಿ ಅವರೆಲ್ಲ ಮಾಡ್ಲಿ.
Yes.
Next.
Serial number 30.
I pray 2 weeks time. On Friday, I received the statement of objections. I will go through.
ಯಾರು ಮೆಮೊ ಯಾರು?
Other side might have moved.
Counsel for the petitioner prays for time on the ground that he received the copy of the statement of objections only today. Counsel for learned AGA for respondent number 1 and 2 present. Counsel for other respondents remain absent this time.
Serial number 4.
Interim order may kindly be extended.
Interim order is extended.
Akash Kumar Gowda.
The petitioners, the first petitioner is the president and the second petitioner is the director, questioned the nomination of the third respondent to the second respondent society.
1 minute, sir. Last date of hearing on 23/8. You are sought to verify whether respondent number 2 is assisted by the state government as found in the audit report. You know.
My lord, audit report, my lord, Rashma kindly is in the audit report. Rashma kindly come to, I will take that audit report. The end of the letter issued by the society, my lord, annexure B, my lord.
No, what is your reply, sir? Whether respondent number 2 is assisted by the state?
No, because my lord, just I will, no, it is not an assisted society at all. Rashma kindly see page 10, my lord, page 10 of writ petition.
No, I am not going to give any finding with regard to that. ಅದು ಅಲ್ಲಿ ಇತ್ತು ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು ಅಷ್ಟೇ.
According to the Lordship, just I pass on the audit report, my lord. Shall I pass on, my lord?
Who is representing respondent number 2?
I'm three. The
Two.
Respondent number 2?
Two is the government.
2 is government. No, my lord, 2 is a society.
Society.
Who is a society, my lord?
Society.
Served, my lord.
Notice agida.
Served agide.
Unrepresented. Unrepresented. Tavali. Respondent number 2, society is served unrepresented. Stability. Who are the petitioners?
The petitioner's first petition is the president. Second petition is the director of the second respondent society. My lord, the third respondent has been nominated as a director of the second respondent under section 24(8) of the Societies Act. Section 28, subsection 4B. My lord, a director can be nominated by the government only if it is an assisted cooperative society. Rashtra, kindly come to definition, section 2A.
No appointment of respondent number 3 as director is
Of the
under-
second respondent bank nominated as a director
under
under section 28, subsection 4B. I will take your last step to section 24, 28, 4B. Section 28, capital A, subsection 4B. Got it, madam? 28A, subsection 4, capital B1. The state government may nominate one person as its representative on the board of every assisted society.
one ಎಲ್ಲಿದೆ?
Allah,
28A.
capital A, 28 capital A,
4B.
subsection 4B, capital
4B
B.
ಎಲ್ಲಿದೆ? B ಇಲ್ಲ ಮತ್ತೆ ಅಮೆಂಡ್ ಆಗಿದೆ ಅದು ಅಮೆಂಡೆಡ್ ಪ್ರೊವಿಷನ್ ಕೊಡಿ ಅಲ್ಲಿ ಕೊಡಿ
ಪುಸ್ತಕ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇದು ನೋಡಿ ಕೊಡಿ ಜಸ್ಟ್ ನೋಡಿ ಇದೆಯಾ
4B. ಅದು last. The state government may nominate
yes
one person as its representative on the board of every assisted society other than the board of a primary agriculture credit. Rest is irrelevant. Assisted society. Now, Rashmi, kindly come to the definition of assisted society. Section 2, definition, madam. Section 2, A11, section
yes
assisted society means a cooperative society which has received the government or state assistance in the form of share capital or loan or grant or guarantee for the repayment of loan or interest.
yes
Here, my lord, the government has not extended any benefit to the second respondent society at all, bank.
yes
It has been running on its own.
yes
Now, my lord, the third respondent approached the government for nomination. The page 9, my lord. Before 9, my lord, annexure B. The registrar asked whether annexure B, my lord,
Page number.
page 10. In pursuant to a request made by the registrar, this is the letter written by the second respondent society. ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಹಾಸನ ಜಿಲ್ಲೆ ಹಾಸನ ಸೋ ಅಂಡ್ ಸೋ. ವಿಷಯ: ಸಂಘದ ಆಸ್ತಿ ಜವಾಬ್ದಾರಿ ತಖ್ತೆಯಲ್ಲಿ ಸಹಾಯಧನ ಸರ್ಕಾರದಿಂದ ಬಂದಿರುವುದು 1,99,000 ಕಾಣಿಸಿರುವ ವಿಷಯ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಸಂಘದ ಆಸ್ತಿ ಜವಾಬ್ದಾರಿ ತಖ್ತೆಯಲ್ಲಿ ಸಹಾಯಧನ ಸರ್ಕಾರದಿಂದ ಬಂದಿರುವುದು 1,00,000 ಕಾಣಿಸಿರುವ ವಿಷಯದ ಬಗ್ಗೆ ಮಾಹಿತಿ ಕೇಳಿರುತ್ತೀರಿ. ಈ ಮೊತ್ತವು 2019-20 ಸಾಲಿನಲ್ಲಿ ಸಂಘದ ರೈತರಿಗೆ ಸರ್ಕಾರದಿಂದ ಬಿಡುಗಡೆಯಾಗಿರುವ ಸಾಲ ಮನ್ನಾಗೆ ಸಂಬಂಧಿಸಿದ್ದಾಗಿರುತ್ತದೆ. ಸರ್ಕಾರದಿಂದ ಬಂದ ಸಾಲ ಮನ್ನಾ ಮೊತ್ತವನ್ನು ಹೊಂದಾಣಿಕೆ ಮಾಡಿಕೊಂಡು ಉಳಿದ ಸೋಗಳು ಮುಂದುವರಿದಿದ್ದು ರೈತರ ಖಾತೆಗೆ ಹೊಂದಾಣಿಕೆ ಮಾಡಲು ಬಾಕಿ ಇರುತ್ತದೆ. ಹಾಗೂ ಈ ಸಂಘಕ್ಕೆ ಸರ್ಕಾರದಿಂದ ನೇರವಾಗಿ ಯಾವುದೇ ಸಾಲ ಸಹಾಯಧನ ಮಂಜೂರಾಗಿಲ್ಲವೆಂಬ ಅಂಶವನ್ನು ತಮಗೆ ಈ ಮೂಲಕ ತಿಳಿಪಡಿಸುತ್ತೇನೆ. My lord, there was a scheme of loan waiver.
Yes.
In respect of the farmers. This loan waiver, my lord, the government used to pay that amount in respect of the waiving amount. Only that amount is there, and there is no grant or any assistance by the government. And therefore, my lord, the second respondent society cannot be treated as an associate society.
Yes.
In spite of that, my lord, as per annexure A, the third respondent has been nominated as a director.
Yes.
That has been called in question. My lord, I rely upon a judgment of this honorable court, my lord, 2016. Shall I pass it, my lord?
Yes.
2016. Here is a case, my lord, wherein section 29G was considered. Under section 29G, my lord, the chief executive officer can be appointed by the government in respect of an assisted society. While considering whether the respondent is an assisted society or not, the honorable court is of the opinion at page paragraph 34, my lord. Shall I read, my lord? Paragraph 34.
Yes.
It is only if the grant provided by the state government is of such magnitude that an institution is able to run its day-to-day affairs, and that without such grant or assistance, the very existence of the institution is at stake, that it would fall within the bracket of an assisted society, and by an extension be an arm of the state over which the state government could exercise such pervasive control as to have an overarching domination of appointing the CEO of the institution, resting such power otherwise conferred on it bodies such as the KMF, as in the present case on hand, which incidentally is a body which is held to be an instrumental of state under Article 12 of the Constitution of India. Next paragraph. The state government can appoint a government representative as the managing director of cooperative society under section 29G(1) of KCS Act only if there is a society assisted by the state government in a substantial measure. The state government does not have a share capital, nor has the state government made any budgetary grants to the fifth respondent. Financial aid provided to improve the infrastructure and provision of land are not grants in the nature of budgetary allocation, and the fifth respondent cannot be called an assisted society defined under KCS Act. If the expression grant employed in the definition of an assisted society under the KCS Act is to be given an interpretation whereby any single grant made by the state government in a given financial year, irrespective of the degree of support such grant would actually assist the society, it would lead to a situation where the state government could, by virtue of an insignificant grant, claim a right to exercise power, overriding the power which may have been conferred on some other body or authority, as in the present case on hand, and such power would then be exercised for an indefinite period of time. This would run counter to the constitutional mandate under Article 43G(b) of the Constitution of India, imposing a duty on the state to promote the voluntary information, autonomous financing, democratic control, and professional management of a cooperative society. So therefore, my lord, here there is no grant or financial assistance whatsoever to the second respondent, and therefore, my lord, the annexure A is without jurisdiction and beyond the power which is vested with the state government to nominate, and therefore the same is liable to be passed. One more judgment, my lord.
In similar ground.
Similar. Here, some amount was given to scheduled caste, scheduled people to become a member. Can it be considered? No, the court has said no.
Yes.
My lord, first submission, my lord, regarding, I have appearing for respondent number state 1, my lord. R1 only, my lord. 2 and 3, my lord, appearing. This has been considered, my lord, the lordship given judgment, my lord, this is pertaining to the appointment of CO is concerned. The similar judgment, my lord, this honorable court to consider that, my lord, what is the assisted society. Either way, that is a, madam. It is. Lord, the main, my lord, to regarding, my lord, para number 11. Okay. 11, my lord. The definition, my lord, it has been extracted. Regarding, my lord, para 14. Next page. It is, I have read, my lord.
Yes.
It is thus clear that any grant of the receiving either from the government or from the state by the society, it would make society is an assisted society. The very use of the word state in addition of government would make clear the words government and state are referred to the distant entities. The absence of any definition, the terms of state, government or state resource can be had the definition of the state under Article 12 of the Constitution of India. Not the 12 is, my lord, as an extracted Article 12, and the court would not expanding the meaning of the state as found the statutory provision to recourse to the definition of state under the Constitution. Such definition of the state under Constitution could be imported to the word state as found is a statutory provision referred to the above, and such interpretation would be fit within the frame of the work and structure of the act. It is clear that the word state would include the local and other authorities within the territory of India. If that were to be so, the taking note to Jilla Panchayat would be local authority. My lord, that case is, my lord, Jilla Panchayat has given falling within the definition of the state assistant provided the bio of the grant reflecting the audit report ending on 31/3/2021 and 31/3/2023. The respondent would permit the constituting the society would receive the such grant for the sister society. Here, my lord, the kindly see, my lord, page number 10, annexure B. The society itself admits that, my lord, they take assistance from the state.
By way of loan waiver.
Please.
Now, whether that could be considered as a grant by the government.
My lord, any kind of the, my lord, assistance from the state, my lord, any kind that is considered as a under.
That grant was made by the government at the instance of the society.
Please.
No.
Regarding, my lord, regarding my submission is, my lord, to this judgments very clearly say that, my lord.
This judgment does not refer to any loan waivers.
ಖಾತೆಗೆ ಹಾಕ್ತೀನಿ ಅಂತ ಇರ್ತಕ್ಕಂಥ I have got that copy.
my lords may be pleased to appreciate.
It is not Sahayatana.
Highlight my.
Under which scheme?
Loan waiver.
The loan waiver scheme?
No, I beg to differ, I beg to differ. This is not in reference to the loan. Sahaya Dhanadinda, ಅದನ್ನೇ specific ಆಗಿದೆ. ಇದು loan ಅಲ್ಲ. ಇದು loan ಸಂಬಂಧಪಟ್ಟದ್ದಲ್ಲ. ಆಮೇಲೆ, my lords will great respect. I have another case law of the court enterprise wherein 50,000 rupees was graced. That was considered as a Sahayatana. One more case law which my friend is now placed to the court. It is all about a site was allotted in the village. Even that was also considered as an assistance. My lord, may I just present this case law wherein it specifically reads, in the present case, a site having been allotted by the Gram Panchayat of the society, the same coming within the purview of subsection would be an assisted society, thereby the state government would be in a position to nominate a person as its representative of the board. You know, very on the site allotment modification, the court said that's also a Sahayadana. Candidly, very specifically, Sahayadana, 1,99,000 our audited report.
No, according to you, it is not under loan waiver scheme.
No, it is. My lords, just for the hiccup of the situation, ಇದು annexure A with my senior friend. Your lordship will be pleased to see that's a letter dated 17/3/2025.
Annexure B.
Annexure B, I'm sorry. My lords, my appointment is on 18/3/2025. 18/3 is my appointment. The previous day a letter has gone.
One.
How does he justify that? Under what circumstances? What necessitated?
Please, 73 is given a letter.
Moreover.
Your appointment by government dated?
18/3, my lord.
18/3.
I just.
Annexure A, my lord.
Annexure A. And my senior counterpart placing Annexure B as a dated. Annexure A is the one which I placed.
Yes.
He is relying on 17/3/2025. This is a letter, ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿರ್ದೇಶಕರು ಹಾಸನ ಜಿಲ್ಲೆ ಇವರಿಗೆ ಸಂಘದ ಅಸ್ತಿತ್ವ ಜವಾಬ್ದಾರಿ ತನಿಖೆ ಸಹಾಯ ಸರ್ಕಾರ ಬಂದಿರುವುದು ನನಗೆ ಕಾಣಿಸುವ ವಿಷಯ. What necessitated my lord, the just previous day of his appointment? This is a got up manufacture. He is not here before the court. He has to substantiate. And moreover, my lord, the point to which I propose to drag this honorable court is ಸಹಾಯಧನದಿಂದ 1,99,000 ರೂಪಾಯಿ ಅಂತೇಳಿ candidly without mincing words that particular annual general body meeting has report has been placed. How can now that 1,99,000 to be shown to be a loan? When this report holds the field, how does this particular letter substantiate? The circumstance in which this letter has cropped up itself is a very serious issue. Your nomination in subsequent previous day into the letter. And that respondent too is not before the court.
Yes.
So my lords, my only point is, this is an assisted society, and in the context of the two case laws to which I have placed to the lordship, an assistance of 50,000 rupees, which one of the case laws is, when that could be treated as an assistance, financial assistance. We, this institution has got 1,99,000. There is no infringement in this particular appointment of this. Thereby, this petition survives. Otherwise,
My lord, and also definition clause itself say that, my lord, called as a loan also. Assisted society means cooperative society which is received the government or state government assistance in the form of the share capital or loan or grant or grantee for the repayment of loan in or interest.
and just want to add one more point on this case law to which my senior counsel, my lords, my senior was referring to page 30, I mean, para 34 of the case law, the one which he got your lordship. This is in reference to an appointment of the CEO.
Yes.
CEO is on a different pedestal. That's in reference to a different organization as though it's a society. Now I am before this court, and what he has now considered a director of that society. Thereby, the
case laws to which my senior counsel has shown has no relevance to the
Yes.
facts of this.
29G, Rashmi, kindly see section 29G of the Act. 29G, because the judgment in which I had referred to, this 29G,
Oh, you should show that.
my lord, I would file a affidavit that this amount has come to,
Okay, sir, there will be some records that the grant is towards loan waiver scheme.
true, my lord.
There, the documents will be available.
Rashmi, kindly have it next week. I will provide. Yes, I will provide. That is,
And even if it is a loan under loan waiver scheme, whether that will come under definition of assisted society.
well, a loan waiver, because it is generally to the end, it is applicable to all the farmers and not for a particular assisted society, even to the bank also. 29G, my lord. Rashmi, kindly see.
A11,
29G, because the circumstance under which this judgment has been rendered.
definition clause.
29G. For every cooperative society, there shall be a chief executive officer who shall be appointed and be removable by the society, provided next.
You come to the definition of the word assisted society.
Yes, ma'am.
It includes a guarantee for repayment of loan or interest.
This is not for this, Lakshmi, can you see, my lord? Loan waiver scheme. It is the scheme or policy taken by the government.
Guaranteeing repayment of.
Not, it is not guaranteeing. My lord, there was a defaulter on the part of the loanee.
Yes.
The government has taken a policy decision for waiving of so and so amount.
Waiver how?
To all.
To pay that loan amount.
To pay that loan amount. That is, my lord, it is a particular for a
Under this.
for a, no, it doesn't. For a particular period. Those who had taken loan for so and so, waiver is there. That amount, my lord, has to be paid on behalf of the farmers to the society. It is not waiver to the society.
Sir,
that amount would be paid.
If the borrower fails to pay the amount.
Yes.
The government guarantees.
No. The government will pay that amount, whatever under the scheme, on behalf of the borrower. On behalf of the borrower to the account, to the creditor. That cannot be the financial assistance.
What does it mean, guarantee for repayment of the loan?
Suppose I have taken the loan from the government or the financial institution. If the government guarantees, you sanction loan.
Why it will guarantee, sir?
Because some society, it would be there.
In case of default, the government.
No. The society, my lord, certain. As a matter of fact, my lord, I have borrowed loan from the bank, not from the society, and I have got my own corpus. There is no guarantee even for that amount also. This bank, second respondent, my lord, has taken loan from the Nationalist Bank and running its affairs, and for that also there is no guarantee.
Produce that loan waiver scheme.
I
That will clarify the situation.
will, man.
May I just add up to my senior suggestion? My lord, presuming that the institution is raising money from the nationalized bank and in turn being advanced, and according to his submission itself, that money of loan what a planter or a farmer has taken, the government waives off that thing. Who is paying it? Government is paying it. Government is paying or waiving off that thing.
On behalf of the borrower. On behalf of the borrower.
The end point is the borrower is benefited.
No.
At the instance of the government. Is it not an assistance, my lord?
If there is an
And at the
assistance
same time-
for the society to run its business, yes, it is an assistance. If the amount payable by the borrower, if that amount is liable to be payable by the government, it is not an assistance.
Either of you, please produce the scheme.
My lord, very well. We'll get into because I am coming from an agrarian and analyst background. It would be more appreciable if this court could find a finding on that. My point is, this 1,99,000 is a Sahaya Dana. ಆ ಶಬ್ದವೇ ಕ್ಲಿಯರ್ ಇದೆ ಆ ಕಾರಣಕ್ಕೋಸ್ಕರ this writ petition.
ಕೊಡ್ತೀನಿ ನಾನು ತೊಂದರೆ ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Petitioners being the president and the director of respondent number 2 society our approach is taking issuance of writ in the nature of certiorari to quash the notification dated 18/3/2025 produced as per annex issued by respondent.
No, I've given my book there.
Notification dated
ಅವತ್ತು ಒಂದು ಕೊಟ್ಟಿದ್ದೆ ಅಲ್ವಾ?
issued by respondent number 1 produced as per Annexure A, appointing respondent number 3 as one of the
ನಮ್ದು
directors
ಕೊಟ್ಟಿದ್ದಾರೆ.
of respondent number 2
CEO.
under section 28
Thank you.
A bracket number 4B capital B ACS Act. Heard so also. When counsel for the petitioner contends that as per section 28A 4B of ACS Act, the state government may nominate one person as its representative on the board of only a assisted society. Only an assisted society. As per the definition of the word assisted society as found in section 2 small a-1-1 bracket 11, assisted society means a cooperative society which has received the government other appointments also. Therefore, it is he further submits that Annexure B dated 17/3/2025 is the letter written by respondent number 2 society to the Assistant Registrar of Cooperative Societies, making it clear that a sum of rupees 1,99,000 referred to in his letter was released from the government towards under loan waiver scheme. Which is yet to be adjusted to the account of the respective borrowers. But the society has not availed any loan or got any grant from the society. Therefore, it is contended by the learned counsel for the petitioner, the society never got a loan or grant from the society, from the government, and hence it cannot be considered as an assisted society as defined under the Act. Under such circumstances, Annexure A is liable to be quashed. Next, per contra, AGA for respondent number 1, opposing the petition submitted.
8th, 9th.
The definition of section 2 so and so, defining the word assisted society, makes it clear that even if there is a grant or guarantee for repayment of the loan or interest that will bring the society within its ambit, even if it is a loan waiver scheme, it amounts to repayment of the loan or interest due from the defaulters, and as such, respondent number 2 society is an assisted society. Hence, the petition is liable to be dismissed. Next, learned counsel for respondent number 3, drawing the attention of the court to an audited account of respondent number 2 society, submitted that it is categorically stated that a sum of rupees 1,99,000 is received as a grant from the government. Under such circumstances, the society is an assisted society, which respondent number 3 was appointed as a director by the government. Next paragraph, learned counsel submits that Annexure B is dated 17/3/2025, whereas appointment of respondent number 3 by the government is dated 18/3/2022, whereas Annexure A, wherein the respondent number 3 was appointed by the government, is dated 18/3/2025. Therefore, it is clear that with some ulterior motive, Annexure B was got up. He also contended that even if there is even if the amount of rupees 1,99,000 was received by the petitioner under loan waiver scheme, the society will be an assisted society, as it received the grant or guarantee for repayment of the loan or interest as defined under the Act. According to you, even if it is under loan waiver scheme,
Assistance.
society.
Well, the ultimate thing is, government is contributing some funds to the end user is the beneficiary.
Hold on, let him.
Even that is also taken as, I don't admit that.
Counsel for the petitioner. Yes, madam.
Lordship, 10th, my lord.
Please for time. For further arguments. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಬೇರೆ heard counsel for the petitioner learned AGF for respondent number 1, counsel for respondent number 3. After addressing the argument for some time, learned counsel for petitioner prays for time for further arguments. And the notes ನಲ್ಲಿ last ಗೆ counsel for the petitioner undertakes to produce the scheme of the loan waiver scheme. Loan waiver scheme to substantiate its contention that the assistance given under loan waiver scheme will not amount to a grant or a guarantee as defined under section 2, the other so and so. Yes.
10th, my.
ಬೇರೆ ಯಾವ ಹೌದು Yes, 10th.
Serial number 15, P.M. Chowda Reddy.
Lord.
Petitioner, I filed memo.
Not pressed.
Yes, ma'am.
Counsel for the petition filed a memo, not pressing the petition.
So become infructuous.
As the same is rendered infructuous. Memo is placed on record, petition dismissed as the same is rendered infructuous. Yes.
Serial number 1, yes, Saravana, Mohammad Tahir.
Taken and summons to respond by 4 and we are producing the acknowledgement.
Counsel for the petitioner filed the memo producing the acknowledgement for having served respondent number 4 through ransoms. Respondent number 4 called out absent. Anybody representing respondent number 4? No.
The society.
Who filed this IA2 impleading?
The IA2 is filed by SMs.
Not IA number 2 is filed because a statement submission was made that
By the petitioner
the
himself?
cooperative development officer is appointed.
No,
So
it
we are
is
seeking to implement them.
application filed by the petitioner. Notary ಯಾರು ಬರ್ತಿದ್ದಾರೆ ಅಂತ.
Special officer.
Respondent number 3 has filed the objections and the application for vacating the interim order.
Objection ಹಾಕಿದ್ರೆ ಅದಕ್ಕೆ.
Proposed respondent is the special officer.
Lord, special officer appointed under section 31.
To the application. Any serious objection to that? It can be applied.
Sir.
Impleading.
Impleading in Tanzania.
He is the special officer. Senior advocate for the petitioner. Senior advocate for respondent.
Of course, my lord, for both, we are contending that there is alternate remedy, even in respect of special officer also.
Seeking implement of The applicant, it is stated that the applicant is the special officer who is appointed by the competent authority, and therefore he is the necessary party. For the reasons
Election, I guess to
was
say.
allowed, the applicant special officer is permitted to be imputed as respondent number. Yes, to respondent number. Respondent number 5. Counsel for the petitioner is permitted to carry out the amendment and to file amended cost. Yes, what about maintainability of the writ petition?
Please.
Lords, the question is about
Jurisdiction
the, Lords, the question is about the maintainability of the dispute itself. It's in a very short compass. ಇದಲ್ವಾ ನಮ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಯಾವ್ದು ನೋಡ್ರಿ
ಇಲ್ಲ ಇಲ್ಲ ಅದು ಬಿಡಿ ಸಾರಿ ಐ ಕಮಿಟೆಡ್
ಪ್ಲೀಸ್
Appeal. Alternate remedy.
Yes.
It's an award passed under section 70. It's under section 105. There is an appeal provided to Karnataka Appellate Tribunal where there will also be a judicial member. They cannot say that it's not an efficacious remedy.
Lords, it lies in a very narrow compass, Lords, because these are the kind of mischiefs which comes before the court day in and day out. Lords, now that your Lordship is in the
Why you bypass one?
Lord, section 70, there could not have been an award at all in these terms.
That is the
Lords,
challenge you can make.
Lord, the
before-
jurisdiction, what I am challenging is not an award passed under section
Whatever
70.
the challenge you have, it will be under 105.
Lords, may kindly see what is the nature of order passed under section 70.
Whatever may be the nature, sir.
Lords, it cannot be.
Under section 70 is
Lords,
sufficient.
what
To
is
invoke
invoked is
105.
under section 70. Absolutely no difficulty, my lords. If it is an order passed under section 70, I have no problems at all. I would not have been coming before your Lordships if it was an order passed under section 70.
Impugned order ಯಾವುದು?
Lordships will kindly see impugned order at page number 34, the operative portion at page number 44.
That is passed under 72D.
ಅದು ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ಓದ್ಬಿಟ್ರೆ ಓದ್ಬಿಟ್ರೆ ಆಗುತ್ತೆ 72D ನಲ್ಲಿ ಈ ತರ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಕ್ ಆಗತ್ತೋ ಇಲ್ವೋ ಅಂತ ಅಷ್ಟೇ ಪ್ರಶ್ನೆ. Lordships may kindly see that. Not, this is not an order which can be traceable to section 70.
When the ARC passes an order under 72D.
Lords, I'll point out, Lords, just 2-3 facts I'll point it out. Lords will kindly see the next paragraph. That is operative portion. ಪ್ರಕರಣದ 1ರಿಂದ 10ನೇ ಎದುರುದಾರರುಗಳು ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಮಂಡ್ಯರವರು ದಿನಾಂಕ 6/6/22ರಂದು ನೀಡಿದ ಆಡಳಿತಾತ್ಮಕ ಅನುಮತಿ ಆದೇಶ ಷರತ್ತುಗಳ ಪಾಲನೆ ಮಾಡಲು ವಿಫಲರಾಗಿದ್ದ ಕಾರಣ 1ರಿಂದ 10ನೇ ಎದುರುದಾರರನ್ನು 11ನೇ ಎದುರುದಾರರ ಸಂಘದ ನಿರ್ದೇಶಕರ ಸ್ಥಾನದಿಂದ ಅನೂರ್ಜಿತಗೊಳಿಸಲು ಆದೇಶಿಸಿದೆ. ಡಿಸ್ಕ್ವಾಲಿಫಿಕೇಶನ್.
Correct. Whether such an order could be passed under 72D or not.
Lordships
It
may
is
kindly
also a matter to be considered
then
under
in that
105.
event shall I make this request, Lords? Lordships may extend this interim order by 4 weeks, within which time I'll go before the appellate tribunal.
Yes.
There cannot be a request of this type, my lord.
ಅವರೇ
saying
ಎಷ್ಟೊಂದು
interim
ಮಾಡಿಸ್ಬೋದಾಗಿದ್ದಾರೆ,
order.
ಇದು ಒಳ್ಳೆ ಚೆನ್ನಾಯ್ತು.
What is the interim order granted?
Lordships have granted a
There is
stay of this
already
order.
special officer appointed. Against the special officer's appointment, there is no stay.
What is the consequence?
That
We
is
will think
also
about it a little
appealable.
later. Lords, when we have raised an objection regarding the jurisdiction, he does not decide upon the jurisdiction and passes an order of disqualification.
The order dated 2310.
Lord, that is the order which I read to your Lordships now. The order of disqualification.
Let him invoke section 105.
We will be known within a period of 4 weeks, my lords. Your Lordships may extend the interim order for a period of 4 weeks.
ಬರಲ್ಲ ಸರ್. ಲಾಸ್ಟ್ ಯಾವ್ದೋ ಇದು ಮಾಡಿದೆ ನಾನು 10 days ಕೊಟ್ಟಿದ್ದೀನಿ.
Lordships may
The most 15 days ಅಷ್ಟೇ.
very well. Your Lordships may extend it by 15 days. We will.
Third learned senior advocate for the petitioner, learned senior advocate for responding to the appeal.
Special officer is not stable. Already special officer is appointed, my lord. That has not been.
My lords, it's a merely a consequence. What is the legal consequence? We will go in a contempt and make it out.
Then AGA for responding number. Learned senior advocate and learned AGA raised the objection regarding maintainability of the petition. as the impugned order is passed under section 72D of ACS Act, and the efficacious remedy is available, prefer an appeal under section 105 of the Act. Bypassing the same, the petition cannot be entertained. And senior counsel for the petitioner, even though opposes such submission, submits that if a reasonable time is granted to the petitioner by extending the interim order that is already granted, staying the operation of
Just one contention, your lordship may record, my lords,
1
that we
minute,
have,
sir, 1 minute, wait for some.
we have raised a contention, dispute itself was not maintainable.
The petitioner will approach, the petitioner will invoke section 105 and refer necessary appeal. Submissions are placed on record, petition is disposed of. The petitioner will be at liberty to approach, to invoke section 105 and approach the appropriate authority within 2 weeks from today. Till that time, the interim order granted by this court staying the operation of annexure E extended operation and execution. The order dated 23/10/2025 passed by respondent number 2 is extended. Yes, 15 days time. You can invoke section 105.
All contentions may be kept open, including the ones raised in this petition.
Disposed of.
May kindly observe, my lord, they will be making an application for interim order that let the interim continuation of interim order here may not be the.
During that period, only for 15 days.
ಅಲ್ಲ 15 days ತಾವು ಮಾಡಿದ್ರ ಬಗ್ಗೆ ಅಲ್ಲ ನಾನು ಹೇಳೋದು. Let that be not a consideration. It should be independently
Certainly
considered.
it can be considered. Why should it not be considered when the High Court is satisfied that there is a case for interim order?
No, High Court is not satisfied, but anyway, as you have.
High Court is certainly satisfied. That's why interim order was granted.
For the appropriate authority by the petitioners and seeks for an interim order, the same shall be considered independently without being influenced by the high grant of the interim order by this court.
This time, my lord, it is, I'll comply the office objection.
Maintainability.
That is a maintainable, my lord, 226(2) of the Constitution of India, my lord. Any High Court may give a directions, my lord. It is the case, my lord.
Territorial jurisdiction.
Please. Yes, my lord.
The cooperative societies of Maharashtra Act, my
Now
lord.
the respond number 1 situated at Bangalore, my lord, which I have account in the Axis Bank, my lord. And without there being any notice to me, defreeze my account, my lord, by the respondent number 2, my lord. As per the its order, my lord.
You are the resident of.
I am the resident of Bangalore, my lord. And
Account with the respondent number 1 is
in Bangalore, my lord.
decreased.
Bangalore, my lord. And there is, I am not any guarantor or I am not any surety to the which loan, my lord, taken by the respondent number 3 and 4. And the respondent number 2 issued a notice to the respondent number 1 bank to freeze the account, my lord. And I have the gold jewelries in the locker, my lord.
You have not borrowed any amount. You are not the borrower.
I am not borrower, my lord. I am not borrower.
Okay.
In respect of my lord, this is concerned, my lord, 156 of the Karnataka Maharashtra Cooperatives Act notice has issued.
Maybe according to him, he is not the
My
borrower.
state has not made a part here, my lord.
Heard learned counsel for the petitioner regarding maintainability of the petition. When a counsel contends that the petitioner is not the borrower from respondent number 2 bank, but however, it did respondent number 1 bank situated at Bengaluru to freeze the account of the petitioner who is also the resident of Bengaluru and under such circumstances, the writ petition is maintainable. Submission is accepted. It is held that the petition is maintainable.
Lord, now,
Counsel for the petitioner pays for time to comply with the office objection.
this month 30th is the marriage of the daughter of the petitioner, my lord. I have kept all the jewelries, my lord, in the locker, my lord. The only the limited,
Have to comply with the office objection.
my lord, other office objection is only one office objection, my lord. Respond number one, represented by the manager, my lord. I stated in the my cost title, my lord.
Comply with that.
My lord, day after tomorrow. My lord. Kindly, it is in urgency, my lord. Marriage is take place in this month only.
List of compliance. Immediately comply
Day after tomorrow, my lord. Today only I will comply. Please.
Pass over, Madi.
My lord.
Pass over. Comply with that.
Kindly tomorrow, my lord.
Sir, ನಿಮ್ ಖುಷಿ ಬಂದಾಗ ನಾಳೆ ಇಡಿ ನಾಡಿದ್ದಿಡಿ
ಇಲ್ಲ ಸ್ವಾಮಿ, ಏನಾಗಿದೆ ಮದುವೆ ಇದೆ ಆ ಕಾರಣಕ್ಕೆ.
You are not ready to comply with that.
I'll comply.
ಸುಮ್ನೆ.
I'll comply, my lord.
Next.
Serial number 3, urgent 4, Madhukaran Deshpande, Pradeep Kumar.
For the petitioner, my lord, I am challenging the registration issued in favor of the respondent number 3 and also an order passed by the respondent authorities, my lord.
I will take up at 2:30.
Please, my lord.
2:30, I have one particular matter at a special bench, my lord, for that reason.
ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ. ಮತ್ತೆ ಯಾವ್ದಿದೆ? ಅದೇ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Lordship.
ಅಷ್ಟೇ 5 ಇದೆ. ಹಾ.
2:30, I will make my submission, my lord. I will request for a pass over there. 2:30, I will come.
ಅದು ಪಾರ್ಟೆಡ್ ಯಾವ್ದೋ ಇದೆಯಾ? ಅದನ್ನ ತಗೊಳ್ಳಿ. ಮಧ್ಯಾಹ್ನ I will take up further arguments. Parted matters are there. Thereafter I will take up this.
Obliged.
I have some, because it will take up some time, my lord.
My lord, it is for the hearing on a IA filed by respondent number 3, my lord, the registration of which has been challenged. I'm a cooperative society, my lord.
My lord, the position of law is fairly settled. Therefore, the matter can be heard. Therefore, the matter can be heard on main merits itself, my lords.
So I will take up that matter, but at 2:30 there are parted matters that will be taken up. Thereafter it will be taken.
Obliged.
ಅಷ್ಟೇ.
If may I make a request at 2:30 whether it can be taken up, my lord, if they are insisting for the hearing on intellectual. I need only just 10 minutes, my lord. It is covered by the division bench judgment, my lord.
2:30.
My lord, it actually will take more time, my lord, because the court, earlier the court heard the matter, my lord, as appointed an amicus.
All of you have submitted a short point is involved.
Yes,
no, my lord.
It is covered.
My lords, that's correct.
It is
My lord, it is a
covered
short
by
point,
the.
but definitely not in the favor
That
of.
was exactly her submission also.
My lords,
It
we've
is
made a
covered by the division bench
synopsis.
judgment.
Cannot be so, my lord, because the Supreme Court has declared the law very clearly, my lord. There is a central legislation, there is a repugnancy involved.
Then definitely it is a very short point.
My
You
lords,
have to
Very much.
apply the
we've
The
made
lordship
a,
may, only submission, my lord, your lordship may hear me and allow me to hear. That's all, my lord. So 2:30, if it is confined to only 10 minutes, I have a grievance on that.
Have I refused to hear?
No,
you?
not that, my lord, because it is, if it is confined to only
What
10
is
minutes
your-
of hearing.
What is your anxiety, sir?
Not that, my lord. I'm saying it is, if it is confined to only 10 minutes as my learned friend has submitted now, that I'll be have a problem.
Don't complicate
we've made a
the issue.
synopsis of all the judgments of the High Court. My lords.
Raising voice and making complications.
No, I'm sorry.
There is nothing. Be cool and calm.
My lord.
ಏನಿದೆ ಇದ್ರಲ್ಲಿ? I do not know.
Yes, much.
The 33, sorry, 13, 1-3.
Who is for the other side?
Respondent, Subramanya Bhatt.
Subramanya Bhatt.
ಅವ್ರು ಇಲ್ಲಲ್ಲ, ಬಾಕಿ
Colleague
ಬಂದ್ಮೇಲೆ ಮಾಡೋಣ.
Our colleague is, I'll inform him.
Let
have
him
the
come
number.
at 2:30. I will take up. ಹೇಳಿ 2:30 mention ಮಾಡಿ.
Mad.
Let him come.
Please. ಇಲ್ಲೇ ಬಂದ್ರು.
Sir, Devaprasad sir.
Devaprasad sir. Dining.
ಗೊತ್ತಿಲ್ಲ ಈಗ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಇದೆ. These two, serial number 4, Madhukar M. Deshpande, Pradeep Kumar.
With your lordship's kind leave, the mentioning to be made, my lords.
Serial number 13. Counsel for the petitioner prays for time. Yes.
Take it.
4.
On my feet.
Who is the petitioner?
Petitioner is a developer. He has developed a property. That particular project is called as Shobha HRC. And that particular project has been developed. And when that particular project is developed, and that particular property is submitted to the provisions of the Karnataka Apartment Ownership Act 1972. And sales are executed with respect of substantive number of the apartments. Along with the sale deed, my lord, the purchasers have submitted to the provisions of the Karnataka Apartment Ownership Act 1972. That particular association has come into effect. That particular association has taken over the property from the hands of the petitioner. And that particular apartment ownership is managing the property. The apartment ownership association is also being arrayed as a party, that is respondent number 5 before my lords.
Respondent number 5.
Respondent number 5. When that particular association is in existence, the respondent number 3, claiming to be a society registered under the Cooperative Society Act,
yes,
started raising certain issues. It is the case of the petitioner that the cooperative society cannot be formed with respect of this particular project because there are no commercial units involved.
Yes.
The law is that, my lord, if there are only residential units are there in a particular project complex, and in such an event, Karnataka Apartment Ownership Act alone is applicable. Then consequently, my lord, RERA Act is also applicable. If there are mixed project, if there are residential project as well as commercial properties are involved, in such an event, my lord, then the Karnataka Cooperative Society Act also applicable.
If mixed project?
This is not a mixed project, my lord. This is purely residential project.
If it is mixed?
If it is mixed project, my lord, in such an event, my lord, the Karnataka Cooperative Society Act is applicable and that particular cooperative society can be registered.
Yes.
Then, my lord, this particular contention was urged. I request my lords to kindly take Annexure B, my lord, which is the registration certificate which has been issued on 6th September 2023. Annexure B, page number 48, my lord.
Yes.
Then, my lord, this particular certificate was challenged by me under section 106 of the,
At whose instance this was
at the instance of few of the apartment purchasers, my lord, this particular certificate came to be issued. Then, my lord, I challenge this particular certificate, my lord, before the Registrar Cooperative Society, Upanibandhakaru, Bengaluru Nagara Jille. That particular order, my lords, would find at Annexure A, page number 44. My lords can find third line, my lord, section 106 has been referred to. The appeal is preferred under section 106.
Annexure A you are referring
Yes, my lord. Annexure A, page number 44. In the third line, my lord, there is a reference to section 106.
Yes.
So that is the provision under which I preferred an appeal. Then, my lord, I request my lords to kindly take page number 46, my lord.
One.
Yes, ma'am.
Annexure A is the order.
Yes, my lord, which is impugned before my lords, as well as the registration certificate.
Yes.
Then, my lord, that particular appeal came to be dismissed on the count that I don't have the authority or the locus standi to challenge that particular registration. That, my lords, observation, my lords can see at page number 46.
Who is the appellant?
The appellant was there, my lord, is the developer, my lord, in that particular case. In fact, my lord, that particular appeal was disposed of by the division bench, my lord. My lords can see that particular reference at page number 46.
So here petitioner is also a developer.
Yes, my lord. Yes, my lord. I will just try to explain, my lord. Yesterday, that particular matter was listed before my lords. That is Classic Enterprises Private Limited. This honorable court reserved the liberty to the Classic Enterprises Limited, that is the developer, to approach the appellate authority challenging the registration certificate. That particular appellate authority passed the order cancelling the registration. Here, the difference between in this case and the Classic Enterprises Limited on an earlier occasion was that without the Classic Enterprises, without exhausting the appellate remedy, had approached this honorable court, the writ appeal in the division bench reserved the liberty to the developer to approach the appellate authority. And that particular appellate authority at the instance of developer cancelled the registration.
No, there also the developer has approached.
Yes, my lord. Developer had approached. Thereafter, the liberty was given to the developer to approach the appellate authority. Then under section 106, in that particular case, my lord, cancel the registration, taking note of the development in law. That order is under challenge by that particular cooperative society before my lords. Yesterday it was listed.
Yes.
Yes, my lord. Then I have filed this particular writ petition, my lord, challenging these two orders, my lord. I request my lords to kindly take the page number 49, annexure C, my lord. Insofar as Karnataka is concerned, my lord, the earlier to the RERA regime, my lord, there were one particular act applicable, that was Karnataka Apartment Ownership Act 1972, my lord. Insofar as residential units are concerned.
Yes.
So as per that particular Karnataka Apartment Ownership Act 1972, the property was required to be subjected to the provision of that particular act. It is not only the act of the developer, it is also a voluntary action of the purchasers of the property, my lord. So this particular deed of declaration was executed, my lord. And that particular format of deed of declaration, bylaw, what is explained in that page number 49 is a bylaw as provided in the rules itself, my lord. There is a rules which has been framed under the act. The real rules provides for the bylaws, and as per the bylaws only it has been prepared.
Yes.
Then, my lord, the similar type of a declaration or another declaration which is provided under the act, that particular declaration has been submitted by the purchasers of the property. I request my lords to kindly take the form number B, which is available at annexure R4 of respondent number 5, page number 214, my lord.
Along with the objections.
Yes, my lord. Along with their statement of objection, they have filed it. In fact, respondent number 5 is accepts that she has been registered. It has been registered under the Karnataka Apartment Ownership Act. Statement of objection of R5, my lord, page number 216. That statement of objection has been filed on 3rd April 2024, my lord, by respondent number 5.
What is this?
This is a form B, my lord, as per the rule 4 of the Karnataka Apartment Ownership Rules, my lord. They are supposed to execute a declaration agreeing to subject this particular property under the provisions of the Act, my lord. Page number 216 is one such type of a form. 214, my lords can see.
214.
Yes, ma'am. This is the form number B, my lord, which is provided under the rules framed under the 1972 Act. This is a form of declaration, my lord.
Yes.
And right side, my lord, page number 215, my lord, the declaration is made that they are subjecting their property to the provisions of Karnataka Apartment Ownership Act 1972.
Yes.
My lord, totally, my lord, I have constructed 395 apartments. Against 395 apartments, 321 owners as on today have executed this form number B, and they have subjected the property to the provisions of the 1972 Act. Sorry, my lord.
How many have subjected?
Sir, 321 have subjected, my lord, as against 395.
Yes.
In the same compilation, there is a one particular annexure, my lord, that is annexure R5, page number 247. On 18th December 2023, my lord, meeting of the members of this particular owners have been convened, my lord. And as per the bylaw number 24, that bylaw is replica of the format which is provided in the Act, my lord. The office bearers have been elected, my lord. Now they have taken over the property, my lord, in phase manner, my lord. All the original documents have been handed over to them. Then, my lord, in the year 2025, somewhere in the month of June, July, my lord, maintenance of the property also has been given, my lord. I am no longer in the helm of the affairs of this particular project, my lord, and they are managing the property.
Yes.
Now the question is that, my lord, whether this particular association is a properly formed association and whether it should operate or a cooperative society, my lord. This is the issue in this case.
Oh, you have already handed over the association
Yes,
to the association.
Yes, ma'am.
Now, what is the interest of the
My lord, my only submission is that, my lord, I am a duty bound to form an association as per the requirement of the sale deeds as well as the agreement of sale.
So according to you, accordingly, the association is formed under 1972 rule.
Yes.
Act.
Yeah, yes, it has been formed. It has come into existence. I have handed over. In fact, my lord, respondent number 5 has stepped into my shoes. She is the respondent number 5 is supposed to transpose herself to further agitate this particular case, prosecute this particular case. How my interest is involved is that, my lord, I am the person who has developed this particular property. And when I have developed this particular property, I am supposed to hand over to a rightful association.
Yes.
I am not supposed to hand over an association which is not a rightful, competent association. I have handed over to an association which is competent to receive it. Now, my lord, the question is whether Cooperative Society Act is applicable or the Apartment Ownership Act is applicable. This issue has been decided by this honorable court, my lord. I'll just pass on this particular judgment, my lord. The judgment. But. I request my lords to kindly take page number 15, my lord. This was decided on 18th June 2024, my lord, by the division bench, my lord. The facts are as under, my lord. The appellant is an unregistered proposed cooperative society, my lord. Hope my lords can see the rank of the party. Within the bracket, it is mentioned as an unregistered.
Yes.
Sorry, my lord, I'm taking more time, my lord. I should not,
yes.
The respondent number 1 and 2 are authorities, my lord. Respondent number 3 to 15 are the purchasers of the property, my lord. And respondent number 16 is the developer, my lord, in that particular case.
Yes.
Then, my lord, in that particular case, my lord, respondent number 3 to 15, who are owners of the apartment,
yes,
they approached this honorable court and they sought certain relief with regard to the proposed registration of the society under the provisions of the Cooperative Society Act. And then, my lord, this honorable court passed an order. That particular order I have produced to make it complete on 23rd June 2024, my lord, 23rd February 2024. And the operative portion of the order reads as under, my lord. That is at page number 1, my lord. Page number 1 of the compilation. Page number 12, my lord. Para number 17. Para number 17. The observation of the court is as under, my lord. Since the project does not involve commercial unit, the registrar of cooperative societies could not have granted permission dated so and so. Accordingly, same is quashed. Respondent number 2 is prohibited from registering the proposed respondent number 4 society to manage and maintain the residential apartment complex known as so and so. Direction is issued to the respondent number 3 builder to comply all the requirements under law and cooperate with the petitioner and members of the 4th respondent proposed society to form an association under the Act 1972, that is the Apartment Ownership Act, the project known as so and so, referred above. The respondent number 3 shall cooperate in complying with the requirement of section 5. Learned counsel for respondent number 4 would submit that they will take effective steps to maintain and manage the property till the association is registered under the Act 1972. Some of the petitioner who are before the court would also agree that they would cooperate in arriving at a solution till the registration is completed under the Act 1972. This particular order came to be challenged, my lord. That is at page number 15, my lord.
yes.
Then, my lord, the court has considered the provisions of various acts, my lord. At page number 18, my lord. Sorry, page number 28, my lord. para number 16, my lord.
Yes.
The narrow dispute in the present appeal is whether association is to be formed under the Act of 1972 or a cooperative society is to be formed under the Karnataka Owners Flat Act 1972. It is seen from the record that sale deeds would indicate the entire project is a residential and no part of the project is used or intended to be used towards commercial purpose. That apart, the parties in the sale deeds have agreed to abide by the provisions of the Karnataka Apartment Ownership Act 1972 and to form an association. Similarly, in this case also, my lord, they have agreed under the agreement of sale as well as the sale deed, and form number B has been executed. The contention of the learned counsel for the appellant, that is proposed cooperative society, that in the view of the project being registered under the provisions of RERA in compliance with section 11(4)(e), F, G of RERA, a cooperative society is to be formed is not acceptable. The said provision of RERA would mandate the builder to enable formation of society, association or society or cooperative society, as the case may be of the allottees. As the project under consideration consists only residential units, the said provision only mandate the formation of association of allottees under the applicable laws. The law applicable in the present case is the Karnataka Apartment Ownership Act 1972. The contention of the learned counsel of the appellant that even if the project consists only residential house flats, conversion of flats for commercial or use of such flat for commercial purpose is not prohibited. In such circumstances, provisions of Act 1972 would be attracted, and in compliance of section 10 of the said act, the cooperative society is to be formed is far-fetched and is rejected. Learned single judge, after considering the relevant provisions under the Statute Act of 1972 and COAF Act 1972, has held that property does not include commercial unit to attract KOF Act 1972. The conclusion of the learned single judge is on analysis of relevant provision under both the enactments. The order of the learned single judge does not suffer from any error. No ground is made out. Then, my lord, there is a direction. It is made clear that direction issued by the learned single judge to original respondent number 3 to form an association under the 1972 Act shall stand. So, respondent number 3 was the developer in that case.
Yes.
No, my lord, the same issue was considered by this honorable court, whether cooperative society can be registered. In another judgment, my lord, I will not read, my lord, since there is a judgment of the division bench. Now, my lord, it is the case of the respondent number 3 that there is one particular judgment of the Supreme Court, that is People's Representative Act, Forum of People's Representative. In that particular case, my lord, the Supreme Court has considered the repugnancy between RERA Act and West Bengal Act. That, my lord, that particular judgment has been placed by the respondent number 5 in a separate compilation, my lord. It is a bunch of compilation which is separately available in this particular case papers, my lord. Madam, adondu tag ma ittidira. Yes. Forum for People's Collective Efforts, my lord, versus State of West Bengal. 2021 8 SCC 599, my lord. Lord, I will not read this particular judgment, my lord. The RERA Act was legislated in the year 2016, my lord. Subsequent to legislating of the RERA Act, my lord, in the year 2017, my lord, West Bengal passed one more legislation which is repugnant to the RERA Act of 2016. Then that particular legislation as well as the RERA Act was considered by the Supreme Court, and the Supreme Court has come to a conclusion that when RERA Act, which is a central legislation which has already come into effect, subsequent to that particular legislation, whether the West Bengal could have legislated West Bengal Act of 2017 operating in the same field. Then the Supreme Court said that when there is a central legislation, that particular central legislation supersedes the state legislation. And accordingly, it was held that the 2017 West Bengal Act is repugnant and declared unconstitutional.
Is the paragraph, relevant paragraph.
Yes, ma'am. Para number 180 to 181, my lord. And then, my lord, paragraph number 183 to 185. Lord, I will not read, my lord, trouble, because that is not the issue here, my lord. Then, my lord, there is one more issue which has been decided by the Supreme Court, my lord. (181 to 185), my lord.
Yes.
My lord, there is one more issue which was decided in this particular case, my lord. In the West Bengal, my lord, there was one ownership flats regulation of promotion of construction, sale, management and transfer Act 1963. And in this particular judgment, that particular act also has been held is unconstitutional, my lord, because the RERA Act supersedes that particular legislation. This is the observation which has been made in this particular case, my lord.
Oh, which is the act? West Bengal?
West Bengal ownership flats regulation of the promotion of construction, sale, management and transfer Act 1963.
Regulation of ownership.
Yes, ma'am.
Regulation of
A regulation of the promotion of construction, sale, management and transfer Act 1963.
'72 Act.
Sorry, my lord. In West Bengal, it is 1963, my lord.
2017 Act.
The 2017 Act is a subsequent act. There are two legislations were considered in that
Which
case.
is the 2017?
The 2017, my lord. Yes, my lord. I will just read out that particular name of that legislation, my lord. It is West Bengal. It is HIRA Act. That is what it has been explained. I will just explain, my lord, what is the complete name of that particular legislation. West Bengal Building Regulation of Promotion and Construction and Transfer of by Promoters Act 1993. Sorry, my lord, it is not 1963. Then, my lord, the other bill, my lord, namely West Bengal Housing Industry Regulation Act 2017. Then, my lord, it is the case of the respondent number 3 that this particular judgment has not been taken care, has not been considered by this honorable court in the 3 judgment which I have referred to, and also the provisions of the RERA, and therefore this particular judgment is contrary to the judgment of the Supreme Court judgment. My submission is that, my lord, this particular aspect has been considered by this honorable court on 30th June 2025. June 2025, after referring to the judgment of the Supreme Court, that is Forum for People's Collective Efforts and State of West Bengal, the single judge of this honorable court has come to a conclusion that if it is only a residential unit, then Karnataka Apartment Ownership Act is applicable, then commercial cooperative society is not applicable, and then, my lord, the judgment which I have referred to, that is serial number 2 in my compilation, that has been approved in this particular judgment, my lord.
This decision of the apex court is also considered?
Yes, my lord. Yes, my lord. My lords can see the questions framed by this, the court, and the questions have been answered. At page number 143, my lords can see the questions which has been formed, my lord. Points for consideration at para number 19. Totally 8 questions have been formed, my lord.
Yes.
First question is that, my lord, whether the association of allottees contemplated under RERA 2016 would include an association formed under Karnataka Apartment Ownership Act 1972, or would the association of allottees be different from an association under a Karnataka Apartment Ownership Act 1972? Second, whether the association under Karnataka Apartment Ownership Act 1972 can be formed by allottees before conveyance in their favor by the developer. They are referring to this particular question, my lord, and they are saying that earlier formation is bad. But however, my submission is that Form B has been executed subsequent to the execution of the sale deed. That has been taken care. Next, whether there is any conflict between Karnataka Apartment Ownership Act 1972 and Karnataka Owners Flat Act 1972 on the one hand and RERA 2016 on the other hand. If so, which enactment would prevail? My lord, while answering this particular question, my lord, this honorable court, the learned single judge has come to a conclusion that the KOFA Act 1972 is in conflict with RERA Act, whereas KOA Act is not in conflict with RERA Act. This is the observation which has been made.
The answers are due,
Then, my lord, I directly draw my lord's
What is the
attention.
answer to question number 3?
Yes, my lord. Yes.
Page number 169.
Yes. My May I read the answer, my lord? Hence, I answer point number 3 by holding that there is no conflict between Karnataka Apartment Ownership Act 1972 and RERA 2016. In as much as RERA 2016 is applicable pre-ownership, Karnataka Apartment Ownership Act 1972 is applicable post-ownership. Insofar as KOFA and RERA 2016 are concerned, there is a conflict. However, RERA 2016 would override COFA 1972, and it is the rights and remedies which are provided under RERA 2016, which would override these under KOFA 1972. By declaration, my lord, the RERA is only applicable. Now COFA has no application at all. Then, my lord, the judgment which I have referred to has been considered by the learned single judge at para 29.5, page number 202, para 29.6, my lord. Then the learned single judge has observed that the Starnest Apartment Owners Cooperative Society Limited holds the fee even today.
Where the apex court decision was relied on?
Yes, my lord. Yes, my lord. The apex court decision has been considered at para 11.32, my lord, page number 117.
Yes.
My lord, my submission is that, my lord, at para number 29.5, 29.6, the court has observed with regard to Starnest Apartment Owners, which I have referred in my compilation at serial number 2, my lord. And then, my lord, the court has also observed that a cooperative society with respect of a residential unit cannot be registered. In this judgment also, that is the observation.
ಇಲ್ಲಿ ಅದು specific
Yes.
observation at serial.
Yes, ma'am.
Page, paragraph number.
Yes, ma'am. Para 29.5, my lord. May I read the 29.5, my lord?
Yes.
Karnataka Society, Karnataka's Cooperative Society Act 1959 enables a cooperative society to carry out maintenance activities of the apartment complex, including those of common areas and common amenities. It is only KSRA 1960 which does not provide for such an object. Though this court in Starnest has held that for the purpose of cooperative society under so and so, a commercial unit have to be part of the development. I am of the considered opinion that the division bench of this court, while considering such restriction, was only considering COFA 1972 and not RERA 2016. The enactment of registration of cooperative society for carrying out the maintenance activity and agitation of the rights of the allottees would have to be considered with reference to so and so, not COFA 1972. Since most of the rights which could be agitated under COFA 1972 would have to be agitated by the allottees now under RERA and not under COFA. Several of the provisions in RERA 2016 containing non-obstantive provision, RERA 2016 would override COFA 1972. Apart from this, RERA 2016 being a central enactment that occupies the field relating to disputes between the allottees, developer, promoter, would override COFA 1972, a state enactment, in order to maintain uniformity across the country. Taking into account these aspects and factors, I am of the considered opinion that decision of the division bench holding that a cooperative society can only be registered in so and so if there is a commercial unit would no longer be applicable after RERA 2016 has come into force. More so since RERA 2016 was not considered in so and so. This would also have to be taken into consideration with reference to provision A of subsection 1 of section 14, which requires that such an association is required to be formed within a period of 3 months of the majority of the allottees having booked their plot or apartment. Thus, the association of allottees in terms of clause E of subsection 1 of section 14 could be an association or a society or a cooperative society. But if such association were required to carry out the maintenance activity also, then it could only be a cooperative society under the KSCT, and such cooperative society is required to be formed within a period of 3 months or majority allottees having booked their apartment. In the present case, it is not in dispute that majority allottees have booked their apartment. The construction has not been completed despite the period fixed having lapsed, and several of the allottees have formed themselves into a cooperative society, which has been registered in pursuance of the direction of RERA. In view of the above, it is clear that cooperative society could agitate the rights of the allottee. Whereas here, my lord, in this particular case, the court has answered question number 1, 2, 3 with reference to Karnataka Apartment Ownership Act, and answering question number 1, 2, 3 of the Karnataka Apartment Ownership Act, if it is registered under the Karnataka Apartment Ownership Act 1972, that is the appropriate association to maintain the property. However, if before completion of the project, if a cooperative society is registered, that particular cooperative society can agitate the dispute.
Yes.
My lord, once again, if my lords permit, I will read page number 169, para 2211, my lord. If the project is complete, my lord, the scenario is different. If the project is incomplete, the scenario is different. Hence, I answer point number 3.
Yes.
Yes. Hence, I answer point number 3 by holding that there is no conflict between Karnataka Apartment Ownership Act 1972 and RERA 2016, in as much as RERA 2016 is applicable to pre-ownership, and then COFA is not applicable. Karnataka Apartment Ownership Act 1972 applicable post-ownership. Here, my lord, occupancy certificate is complete, seal deeds have been executed. Insofar as COFA and RERA 2016 are concerned, there is a conflict. However, RERA 2016 would override COFA 2009, COFA 1972. It is the rights and remedies which are provided under RERA 2016, which would override those under COFA 1972. Then, my lord, para number 22.12. Though there is some overlapping, however, still the Karnataka Apartment Ownership Act 1972 is applicable. That is in view of the two judgments, my lord, which I have referred to in my compilation. That is VDP Saldana and DS Max case. At para number 22.12, that has been taken care. I am referring to this particular judgment only. That is DS Max case. So my submission is that, my lord, with reference to the three judgment which I am referring to, as well as the judgment of this honorable court decided on 30th June 2025, the registration issued in favor of respondent number 3 is required to be cancelled, my lord. And then, my lord, the respondent number 5 should be allowed to, which is continuing the maintenance, it should be allowed to continue the possession. Now an interlocutory application has been filed, my lord. That application is that to direct me, seeking a direction to me to maintain the property. One date I will mention, my lord, that is the date of issuance of the occupancy certificate. The occupancy certificate was issued 26th May 2023. Then this association, respondent number 5 association has already taken over managing the affairs, my lord. Now at this point of time, this application is not maintainable. I have filed my objection to that application.
What is that IA number?
IA number 3, my lord. IA number 3. It is listed today, my lord.
It is filed by?
It is filed by the respondent number 3. He wants me to maintain the property, my lord. Now it is being managed by the respondent number 5. Yes.
IA ಹೇಳ್ತಾರಲ್ಲ. No, you are referring to an application.
Yes, my lord. That is filed by respondent number 3, my lord. That application was filed on 5th July 2024. Correct, sir. Oh, 5th July 2024. The idea behind the applicability of the Karnataka Apartment Ownership Act is that, my lord, the association formed under the 1972 Apartment Ownership Act, insofar as residential units are concerned, it is more autonomous in nature. It has more autonomous features, and there is a minimal interference of the registrar. And with that object, the Karnataka Apartment Ownership Act 1972 was legislated. Whereas COFA 1972, my lord, it gives more teeth because it is a cooperative society. Interference would be more. So there should be minimal interference, my lord. 1972 has been upheld, and it is also operating in a different field. And RERA Act is also operating in different field. Once the project is completed, my lord, it is always 1972 Act which is applicable. And there is no repentance.
And the association has taken over the project?
Yes, sir. The complete handing over has been completed. In phase manner, the handing over has been completed, my lord. That has been explained by me in page number 7 of my statement of objection, my lord.
Tell me when the handing over
Yes,
is
my lord.
complete.
My lord, yes, my lord. That is between December 2023 and complete handing over has been completed on 9th November 2025. Sorry, 30th October 2025.
30th October
2025, my lord.
The apartment owners association was registered.
My lord, the apartment ownership would not be registered, my lord. It is Form A, Form B, which has to be submitted.
Form
Because,
was submitted.
It was submitted, my lord, 12/6/2023, my lord. And the Form B has been submitted from time to time when the sale deed has been executed, and they have submitted after the execution of the sale deed, my lord. Not prior to the execution of the sale deed, as per the requirement. Before execution of the sale deed, they cannot, my lord. They are supposed to, pursuant to the sale deed only, they have to execute Form B.
Yes.
Yes.
May I please?
My lords, I appear for respondent number 5. I want to make only one submission. I'm adopting the arguments made by the petitioner. There's only one submission that I want to point out to your lordship.
Respondent number 5.
5, my lords.
Yaru
Today
respondent number 5.
today I'm maintaining the property. I'm collecting maintenance and I'm maintaining all the common areas.
Subsequently read as a respondent number 5.
Owners association.
Yes.
Please, my lords, under 1972.
Yes.
My lords, in addition to the submissions made by my learned friend regarding RERA, KOA and COFA, my lords may kindly see the agreement to sell and the sale deed. There are only 2 clauses where there is a contractual agreement between the developer and all the allottees as well as the owners saying that they will register an association under KOA 1972. Your lordship may kindly see the agreement to sell, which I've annexed along with my statement of objections at page 140, my lords. And at page 143, in the definition section itself, in the agreement to sell,
Agreement to sell executed by the petitioner in favor of the purchaser.
all the purchases, please, my lords. First was agreement to sell with the allottees. So at the stage of allotment itself, in the agreement to sell, there's a clause wherein it defines what an association or owners of association shall mean. Clause 1E. It says it shall mean being the association of owners that is established by the vendor developer in respect of the apex body Shobha HRC Pristine, and the subcommittee association for Shobha HRC so and so shall also be a project as per the provision of the Karnataka Apartment Ownership Act 1972. Thereafter, in clause 21, my lords, of the agreement to sell, I won't burden my lords by reading out, but clause 21 again talks about association of owners, where very clearly they're indicating that they will form exactly the submissions made by the petitioner. They say we are going to execute a DOD under Form A and Form B at the time of sale deed. Entire clause 21, wherein all the purchasers were already informed that an association is going to be formed under 1972. In further to that, my lords, the sale deed, which your lordship will find annexed to R3 of my statement of objection. Even in the sale deed, there is a similar clause. At clause 6 of my sale deed, my lords. Clause 6 says the purchaser has become the member of Shobha HRC Pristine Owners Association by executing this deed of sale and agree to abide by the terms thereof and participate in the administration and other aspects of the project constructed on the part of Schedule A property, and accordingly the purchaser has also executed the Form B under provision of KUE 1972 along with the execution of this deed of sale. So both in the agreement to sell as well as the sale deed, there is already a contractual obligation where each and every owner has signed saying they will submit to KUA, and the builder, as per his rights and obligations under any enactment, if your lordship were to consider, has promised that he'll form an association, and the same has been done following the due process of law. And to this, my lords, the VDB Celadon case passed by this Honorable High Court, the division bench. I made a synopsis of all the judgments chronologically.
Only ಅದ್ ಮಾತ್ರ ಕೊಡು.
Please, madam.
ಅದೊಂದೇ.
Adonde illa. Your lordship already has it.
ತೆಗಿ.
Your lordship already has the judgment. I'll point out to the para. Because in this judgment, this is what the court had considered.
Which is that citation? Tell me.
It's writ appeal number 974 of 2019. He already read it out. It's already there.
Yeah,
Petitioner has already filed this case law.
I'm just giving this.
Oh, you give.
It is not part of the.
It's not part of the compilation. Sorry. You can look at this. My lords, may kindly look at para 9, 10 and 11 of this judgment.
Yes.
Thus, the main object of the appellant was to do something which could have been done by the association in accordance with the provisions of 1972. In fact, documents of sale executed by the developer in respect of the flat apartment contain a stipulation that the purchasers of the flats shall form an association society condominium in accordance with the provisions of the said Act of 1972. That is how the learned single judge, by modifying the impugned order dated 15th February 2019, has clarified that steps can be taken to register the appellant association under the provisions of the Act of 1972. Thus, having perused the dominant objects of the appellant association, we find the said objects are not covered under 3 of the 1960, so on and so forth. So primarily, my lords, this was VDB Celadon was 1960 Societies Act versus KOA. But however, as per the facts here, because there was already a contractual obligation between the developer and the purchasers that an agreement will, that an association will be formed under 1972. That was the holding. My lord, in fact, there are 2025 judgments as well, which is already produced before your lordship, where similar fact situations have happened where there's already a contractual obligation. So my lord, as per the contractual obligation, they are bound to form under 1972, and that is what the petitioner has done today.
Yes. Yes.
May I please?
In case any issue is required. If any issue is required, I will.
May I please? Your Lordship, admittedly, this project is a RERA project. The petitioner herein is a developer.
Respondent number?
My lord, I am for the respondent number 3, the cooperative society. The project is registered under the RERA, and my lord, I have produced the RERA certificate as annexure A in my statement of objections. My learned friends would not object to the fact that it is a RERA registered project. Your Lordship may kindly take my statement of objections, page number 48, annexure A, my Lord. My statement of objections, my Lord. Okay. Statement of objections by respondent number 3 filed on 11/3/2024.
Yes.
Page number 48, Your Lordship.
That is not disputed.
Yeah, there is, that's not, I'll take Your Lordship to a very important point there. Your Lordship, in that point number 2, this registration is granted subject to the following conditions, namely, in that clause 2, the promoter shall execute and register a conveyance deed in favor of the allottees and the association of allottees, as the case may be, of the apartment or the common areas as per section 17 of the Act. The Lordship may kindly see what is section 17 of Karnataka Apartment 1, the RERA Act. Karnataka, the RERA Act, my Lord.
Read that.
The promoter shall execute a registered conveyance deed. Section 17, Your Lordship. Transfer of title.
Yes.
The promoter shall execute a registered conveyance deed in favor of allottee along with the undivided proportionate title in the common areas. Undivided proportionate title in the common areas to the association of allottees or the competent authority, as the case may be, and hand over physical portion of the plot, apartment, or the building, as the case may be, to the allottees and the common areas to the association of allottees. Your Lordship, may I pause here. The common area definition of associate under the RERA, my Lord, section 2N. 2N, my Lord, the entire land of the real estate project or where the project is developed in phase or the registration under this Act is sought for phase and the entire land for that phase. That means, my Lord, after the RERA has been enacted, which is a beneficial legislation, specifically to protect, my Lord. Your Lordship may see the objective primarily, which says for the protection of to protect the interest of consumers in real estate projects. There is a scheme under this. After the RERA has been enacted, my Lord, there is a paradigm change in the real estate, the sector itself, as far as how the scheme of development should happen. My Lord, RERA is a central legislation legislated under the concurrent list number 3.
Yes.
Where the 2 state enactments were already prevailing, my Lord. Various states had already enacted, and it is the inadequacies of this state enactments, the RERA was enacted, and admittedly, there is no dispute on the fact that whatever the clauses, whatever is inconsistent with the central enactment of the state act, where it comes in the way of enforcement of a central act, the state acts, that provision is void. Repugnancy 254 of the Constitution, my Lord. And there is a clear provision in the RERA which says that anything, section 80, my Lord.
No, is there any dispute that?
Yes, that is what, my Lord.
Applicability of RERA?
My Lord?
Yes. No. Applicability of RERA is never disputed.
I have the first day order, my Lord. I have been restrained not to agitate my allegations before my complaint before the RERA, where I have sought for.
Today, I have heard his argument.
My Lord.
He never disputed the applicability of provisions of RERA.
If that is the case, my Lord, my learned friend is saying that he has handed over the project to a registered association.
Yes.
What is a handover? Whether section 17 conveyance under section 17 as templated under section 17 of the RERA has been complied or not.
No,
there is a judgment, my Lord.
Sir, why you are saying that the Societies Act is applicable?
Societies, that is what my learned friend has.
Why you assume jurisdiction over the property?
My lord, that is because that is only a cooperative society is capable, because the cooperative society is a competent body which can the conveyance can be done again which can contract. That means a conveyance.
Regarding various decisions relied on.
Yes, my lord. The decision which my learned friend has read now, where justice, I mean, in 27341, my lord. Your lordship, the judgment is already before your lordship. Page 198, para 28.8, my lord.
Yaudರಲ್ಲಿ?
In the Akhilesh Anand matter, my lord, 27341 of 2024.
Yes.
Your lordship may kindly take page number 198. Unlike what my learned friend tried to submit about this judgment is, my lord, this judgment is one which upheld the requirement of a cooperative society, a legal body, a body corporate is required for compliances under section for the RERA regulations. 28.8, my lord. Under RERA 2016, the common areas are required to be owned by the association of owners. Common area includes the land, my lord. Again, the association under KA 1972 would not have the requisite legal characteristics to be registered as the owner of such common areas. The cooperative society having requisite characteristics, if formed within 3 months from the majority of apartment being sold, the said cooperative society could also be the owner of these common areas and amenities. 1972 Act can never own as a body corporate. It cannot act as a body corporate. That has been once again declared by the Honorable Supreme Court in a matter where the petition.
If it is formed within 3 months.
My lord, it was the forming of a cooperative society was a mandate where the builder under section 11(4)(e) should have enabled formation of a cooperative society of the allottees when more than 50% persons have booked the apartment.
Under which mandate?
Mandate under the central legislation, the RERA, my lord, 11(4)(e). Functions and duties of the promoter.
1 minute. You just now refer to which paragraph?
28.8,
98.
Page number 190, which categorically observes that 1972 is not a competent body. And in this matter itself, my lord, the learned single judge has directed the builder to convey within 120 days, comply with section 17, my lord. It is a mandate, and my lord, in one judgment by the Odisha High Court, a division bench judgment, it has been made mandate that the registration of a common registration of the undivided interest in.
Then what should happen to the Owners Association Act?
My lord,
Apartment Owners Association Act.
under Karnataka Apartment Ownership Act,
Under
there
what
is no.
Circumstances that is applicable?
My lord,
Under what circumstances the provisions of that act is applicable?
it is not applicable after, as far as my lord, after the RERA's enactment. My respectful submission is 1972 is inconsistent with RERA. I will take each and every provision and demonstrate the same. And whatever is inconsistent is all void. The first thing, my lord, I'll begin from section 11, my lord, chapter 3 of the RERA. The lordship may kindly.
But it was not declared, the Karnataka Apartment Owners Association.
I have already challenged that, my lord. When this matter was going on, it was suggested by the Honorable Court
That is the Act of
1972. After the RERA is enacted.
But unless it is declared as.
But whichever provision is inconsistent is void and cannot be enforced. That is what
happened to your challenge?
My lord?
What happened to your challenge?
It is pending, my lord, because it was filed that when there is a suggestion by the court which heard this matter in detail, and in fact a learned amicus was also appointed. Considering the ramification, larger ramification on the public at large, learned amicus was also appointed, and I was.
Is challenged by whom?
I have challenged the 1972 Act at its.
Yes.
My lord.
Assistant Registrar.
No, as a cooperative society, my lord, I have challenged the validity of 1972 Act since after the RERA's enforcement. The respondent number 3, my lord, in a separate petition I have challenged. In a separate. May I just read your lordship the 11.4E, my lord. WP 3308, my lord, of 2024. No, I am the agreed. That 2 matters, my lord, pending. My lord, it is a duty of the promoter. Under chapter 3, my lord, functions and duties of the promoter. 11.
You are referring to which act?
RERA Act, my lord.
Which is the provision?
11, my lord. 11.4E, my lord. Enable the formation of an association or society or cooperative society, as the case may be, of the allottees or a federation of the same under the laws applicable. The lordship.
So there is a word association,
Association,
society, or cooperative.
Or society or cooperative society, whichever is applicable. Now, as far as an association is concerned, if an association under 1972 is formed, whether that can become a body corporate, which the provisions of RERA can be enforced or not, is the primary question. Now, there, my lord, same section, my lord, next 4E and 4F, my lord. Thereafter, execute 11.4E and 11.4F, my lord.
If
Execute, again, it is a duty of the promoter to execute a registered conveyance deed of the apartment, plot or building, as the case may be, in favor of the allottee, along with the individual proportionate title in the common areas to the association of allottees or competent authority, as the case may be, as provided under section 17 of the Act. Section 17 I have already read, my lord. So now, my lord, an association is required to be formed when more than 50%, the moment of more than 50% of the allottees have booked the apartment, it is a duty of the promoter to form an association, and that formation of an association cannot be made under Karnataka Apartment Ownership Act 1972, which provides only for association of owners. Allottees are not, all owners are allottees, but not all allottees are owners. So, my lord, the very provision that is a mandate requirement of the builder to form an allottees association when the project's 50% is sold is not been complied with that, though he has initiated that, and that is where the cooperative society came into existence.
No, in this clause E, there is reference to association, society,
well, whichever is applicable.
Whichever is applicable.
Yes, ma'am. So here,
which is applicable in this case?
In this case, in all RERA projects in Karnataka, what is applicable is either it should be a cooperative society or a company, because an association under 1960 Act, An association,
Why this, the word association is used in this?
my lord, it may be in any other states where there is a body corporate being formed under association, where in Karnataka 1972 Act, there is no registration of a society. It has been very clear, my lord, there is no registration of the society. They just file a deed of declaration, and it has been categorically held by the government itself like that it cannot be. It is in the objections filed by the government itself. It has told that just by filing and deed of declaration, association is not formed at all.
Is the requirement under RERA to register the association?
My lord?
Under RERA, whether it is the requirement of law?
Yeah, only a registered association can approach the RERA, my lord. Even unregistered association, which is not voluntary in nature, cannot approach even the consumer forum also. That has been held where by the Supreme Court. I'll provide the judgment.
But in the Act, there is no mandate.
Rule, my lord. It should be the registered association to agitate.
Agitate alert.
Not only that, it should be a body corporate.
Yes.
When it has been categorically held that 1972 is not a body corporate, by the Supreme Court itself, it has held that it cannot agitate. Hibiscus. May I please? Office copy. And that has been referred in this judgment also, my lord. I'll go through this judgment first. First. Let me start from the judgment which is before your lordship itself, my lord, where my learned friend has already read, which is misread certain portions where it has been very conveniently by holding that it is not the cooperative society, it should be 1972. The court did not held so, my lord. It has categorically held that in all the RERA projects, it is a cooperative society.
He has also relied on this.
Yes, my lord. That hibiscus judgment is also relied. That is why I produced that one. Unless it is a registered association, it cannot either go before the RERA, it cannot go before the consumer forum, it cannot be a party to the conveyance as required under section 17. And 1972 cannot be formed of the allottees. It is only the owners. That can happen only subsequently. Admittedly, my lord, and 1972 is applicable only when all the owners submit the property to the Karnataka apartment ownership.
Now, whether section 17 mandates that? No.
My lord?
Section 17 also does not mandate that.
Sorry, section 17 mandates only the conveyance. Yes, sir.
Registered conveyance.
Yes, whether the conveyance can be made to the association under 1972 is a moot question. If that is held so, because it has been categorically held, it cannot be 1972, and that has not been done also. Yes, my lord. RERA, RERA rule 2.
Rule?
Association of allottees, my lord. 2B.
RERA rules.
RERA rules.
How do RERA rules? It's behind RERA rules. RERA Act ಇದೆ ಆಮೇಲೆ ownership act.
ಎದುರಾದ ಪರಿಣಾಮ explain.
Just take it out. Just take it out.
Let me get the book. Now, why you are replacing reliance on this?
My lord, I will come to that, my lord, because it categorically says that 1972 is not an association at all, which is competent enough to even go to the consumer.
I will come back. Yes.
it is not even, there is some mischief also from the petitioner here, my lord, where they don't want me to have a recourse to any legal remedies against whatever they have committed. Primarily, my lord, I have a serious agitation about agitation against the method in which a registration of sale deed is being done. In the sale deed, they will not show the entire consideration. I have questioned that in the RERA. The moment I started questioning that, they went and immediately registered a deed of declaration, told that there is an association formed under 1972 and the cooperative society cannot be formed. Neither you can go to the consumer forum nor you can go to the RERA. So this, to overcome their mischief, they want to ensure that there is no body corporate formed which can agitate against them. And it has been categorically told my learned friend also that there will be no interference at all. That means I, as an allottee, should shut up and keep quiet, never ever agitate against whatever they do. It is precisely their requirement.
Individual owner cannot approach the district consumer.
Individual
forum.
owners cannot ask for a conveyance in the allottees association. And it cannot ask that an association of allottees to be formed. An association of allottees for them will form only when the 1972 is complied, when everyone submit their rights in the under 1972, file their form B, and thereafter when everybody registers the association, register the sale deed, they become the owner. Only then there can be an association of owners. Only that association of owners of all owners constitute, that also even does not constitute a body corporate. That is the law. That has been held by the Supreme Court, confirmed by the same judgment where my learned friend has produced already. My lord, I will read from the beginning, my lord. It is lot of things coming in that same judgment, my lord. It is where a cooperative society has been upheld by the court, my lord, in this judgment.
Which paragraph?
And this judgment is more important, my lord, because the judgment DX Max Tarnished Apartment, where writ petition and the writ appeal, which says that only in the residential apartment, only in the residential, purely residential, let me, may I take your lordship from the, I have certain points to specifically point out, my lord. The first thing, my lord, page 157. My lord, the writ petition number 2734.
No, now you refer to this Mrs. Shobha anything?
I will read that.
Shobha Hibiscus.
Shobha Hibiscus is referred to in that judgment, my lord. That's why I produced it. Your lordship is having this judgment, my lord. Yes. The learned counsel appear. I mean, your lordship at page 832, my lord. Para 10, your lordship.
Yes.
It starts with the learned counsel appearing for the respondent also relied on the very same judgment in the case of Malavikam Trust Heights flats affected buyers association. In the aforesaid decision, a full bench of the National Commission has taken a view that even a residents welfare association, if registered under a statute, will qualify as a consumer association. And under the provisions of section 12 of the act provided, it qualifies as a voluntary association. For the aforesaid reasons, in the view of the reasons recorded in the impugned order of NCDRC, we do not find any merit in this case appeal so as to interfere with the same. The civil appeal is accordingly dismissed, wherein, my lord, it is held categorically that in essence, above that, my lord, above para 10, it is that in essence, a voluntary consumer association will be a body formed by a group of persons coming together of their own will and without any pressure or influence from anyone and without being mandated by any other provisions of law. The appellant association, which consists of members of flat owners in a building which has come into existence pursuant to a declaration which is required to be made compulsorily under the provisions of 1972, cannot be said to be a voluntary association to maintain a complaint under the provisions of the act. Unless an association is registered under a law where the membership is voluntary in nature, they cannot approach the consumer forum, and that cannot be considered as a registered body member. And that has been categorically observed by the coordinate bench here, my lord. Writ petition 27341, my lord. Page 157. Separately given by my learned friend. The bigger bunch. My lord.
You are referring to the compendium of
Akhilesh
decisions.
Anand.
Decisions, sir.
Yes, my lord. The decision of the coordinate bench. In 27341.
Having 208 pages.
The bigger bunch, my lord, it is there itself. Just give it.
Repetition. Sir.
Lay that.
ಇದೇ ಅನ್ಸುತ್ತೆ ಇದಾ ಇದು
Yes, my lord. Page 157.
ಅಖಿಲೇಶ್ ಆನಂದ್
Akhilesh Anand.
150
157. Wherein an identical challenge was brought questioning the authority of a cooperative society, my lord.
paragraph number.
My lord, para 21.16, page 150.
Again, reference to VDB.
Yes, it says, it observes that whatever has been observed in, one is VDB Seldon has held that 1960 associations cannot be.
Now, I think you are the amicus curiae appointed in which matter?
This matter, my lord, and yesterday also another matter. Both these matters are.
I think he can clarify.
Both these matters was actually clubbed, my lord.
But other,
My lord,
other matter? ಇದೆಯಾ ಇವತ್ತೇ ಇದೆಯಾ?
yesterday it was listed. Earlier it was clubbed and then it was separated later.
Similar questions of law? Questions
My lord, not very identical because here mine is clearly a RERA project where it is this judgment itself, Akhilesh Anand itself clarifies it clearly in any RERA project. 1972 is not an appropriate association because it cannot be competent for enforcement of RERA provisions, particularly section 17. The Starnest Apartment Owners Cooperative Society Limited, my lord, the judgment which the learned friend was referring where only under the residential apartment 1972 only will apply.
This Akhilesh Anand.
My lord.
Which is the paragraph we are placing reliance?
My lord, it starts from para 21.16 and altogether it has, this is categorically observed, it is 1972, 1959 cooperative society only is applicable in RERA matters. And it has given a specific direction to the builder to convey, do the conveyance in favor of the cooperative society within 120 days. Conveyance na helti. Para 29.3.
29.3.
Page 201. Para 29.3, my lord, the cooperative society now having been formed, the builders developers would have to execute necessary deed of conveyance in respect of common areas and amenities in favor of the cooperative society within a time bound manner, that is within a period of 120 days from the date of receipt of this order.
When this society was formed?
Your lordship, it was formed by the when the construction activities was going on, when the builder and the allottees had issues between them. They had approached the RERA. The cooperative society was required to approach the RERA. They formed it. And here also, my lord, there were multiple issues that the allottees had to agitate with the builder, and that right is confined only to a body corporate, and that body corporate formation is happening only in two cases where it is either a cooperative society or a company, and either a welfare association which cannot take over the property under the Conveyance Section 17, or they can conduct the maintenance activities been categorically held, and its objectives also does not permit for that.
No, this is some facts of the case, 29.3.
29.3 says that there should be a conveyance done. It is the rule of under RERA, because when there is a rule, they cannot bypass that. When there is a rule 11.4E says that they should have formed an allottees association, they cannot make us wait till all the apartment owners, apartment allottees become the owners. They cannot deprive my right of becoming an allottee and make use of all the preventive provisions of RERA. And that means that will come in the way of enforcement of RERA, and it amounts to repugnance. That is my case. My lord, in this matter, where the author of the judgments earlier, which has gone to writ appeal referring to that matter.
What do you say regarding paragraph number 22.11, answering point number 3?
My lord, with my respectful submission, my lord, there the conflict is, and as much as section 17 is complied.
No, the coordinate bench.
Because if, my lord, this judgment has to be read as a whole, my lord, which explains why 19 and cooperatives.
See, specific questions were raised.
Yes,
and it is answered.
My lord, the specific question has answered from the beginning, my lord, whether which is a competent to have compliances. They cannot escape the compliances, my lord.
The same order and challenge even parameter they came to this conclusion.
Your lordship may kindly see para 21.25, my lord. 21.25, my lord, at page 161. Why it is important is, my lord, the court has made a categorical observation about the earlier judgment by the very same judge in Shantaram Prabhu's case, my lord.
Sir, you come to page number 143. The court has formulated several questions.
Yes, ma'am. Whether an association of allottees contemplated under the RERA 2016 would include an association formed under 1972, or would the association of allottees be different from the association under KU 1972? First question, my lord. Second is whether the association under KU 1972 can be formed by allottees before conveyance in their favor of the developer. So in this case, admittedly, my lord, they have not done the conveyance. So the answer, if the answer 2 is negative, then that the formation of 1972 is not applicable. It is very clear, my lord. The first, let me read the first and second points, that the entirety in its entirety, my lord. Point number 2, my lord, directly.
Conveyance, it is okay. Now the conveyance is already executed.
No, they are not done.
No.
Nobody is doing in the entire Karnataka. Section 17, no one is doing.
They want the project to be registered. Here the conveyance is referred to the sale deed.
No, that is what, my lord. After the RERA is enacted, there is a paradigm change where it says that the entire area should be in the name of association.
Sir, now we are referring to this judgment.
Yes, my lord.
You said you are also relying on this.
Yes, I rely on this.
That's why I am asking, which is the question formulated and answered by the coordinate bench favors your contention.
My lord, answer to the point number 2, my lord. Answer for point number 2 at paragraph 21.28 or page 164, it says, I answer to the point number 2 by holding that an association of allottees contemplated under KU 1972 cannot be formed by the allottees before conveyance in their favor by the developer.
According to the petitioner, the conveyance is already complete.
That is what, my lord, that I leave it to the court here. What is conveyance? When the RERA, the conveyance itself comes under RERA section 17.
What do you mean by conveyance?
Yes, my lord, the conveyance is when the common area, the land including, is conveyed through a registered deed. Only then the RERA, they are out of, it can be called as the project has been completed. Till then he is liable to maintain the project. That law cannot be changed, my lord. Your lordship, I'm producing another judgment of the Odisha High Court, my lord.
Sir, first you convince the court regarding this.
Yes, my lord.
Thereafter, we can go to other decisions.
My lord, it is very clear, my lord. It says that for conveyance, only the 1972 can come, if at all it is required, only after the conveyance. In this case, it is admittedly no conveyance has been done. And the cooperative society is formed before that. And
No, 21.2, if we read that, it refers to individual allottees.
no, my lord, I answer the point. By holding that an association of allottees contemplated under KO 1972 cannot be formed by the allottees before conveyance in their favor by the developer, no declaration being capable of being submitted by them. So unless I file a declaration,
19.2, the crux of the matter in the present petition is
21.2, my lord.
Yes, in page number 145.
The crux of the matter in the present petition is who is to represent the interest of allottees in whose favor no sale deed has been executed.
So, with that in view, what do you mean by conveyance? Individual sale deed.
No, my lord.
In favor of the allottees.
No, section 17 very clearly says the conveyance is, in that case also.
Here I am saying the crux of the matter in the present case.
The crux of the matter.
Who is to represent the interest of allottees in whose favor no sale deed has been executed.
Wait, let me read it, man. The crux of the matter in the present petition is who is to represent the interest of allottees in whose favor no sale deed has been executed. That is to say, the allottees being those in whose favor an allotment letter or an agreement of sale has been executed. There being no sale deed which has been executed. My lord, the requirement of the law is when more than 50% of the apartments are conveyed, are booked by the allottees, an association has to be formed. That association formation cannot happen when it is 1972. 1972 will come into effect only when the purchasers become the owners completely and not under an agreement. So here, the mischief of the petitioner is that when he completes everything and it has been conveyed, 1972 will come only after.
What purpose you are relying on this decision?
My lord, in this it says that it has categorically upheld that for all RERA projects, the proper association is a cooperative society. The entire case says that, and the court has categorically held.
Where in which paragraph?
Though it has not been specifically told, it applies there. No, Lord, clear agide, Swami. It is this here, my lord.
Runs into how many pages?
209, my lord. Here, my lord.
Even then you say.
Here, no, my lord. Here.
Explicit words, it is not.
My lord, it is an explicit words. It is clarified that it was in earlier.
The learned counsel for the petitioner has drawn the attention of the court to few paragraphs in support of his contention. According to you, you also rely on this decision to support your contention.
I rely on the entire judgment as a whole, my lord. I will prove. I will show you. I demonstrate it to your lordship if your lordship allows me to.
I asked you specific questions are formulated by the court and answered it.
It has been categorically answered 2 questions, my lord. It says that 1972 association is not competent for conveyance. It also answered that an association to be formed in a RERA project is to be formed when more than 50% booking has been done. These 2 things has not been done there. Now the same petitioner cannot say that when he has not complied with the legal requirement, he cannot say that I have now formed a association under 1972. Anything before to that cannot be considered at all. He has defaulted in his obligations, and he has continuing to default by not conveying the not complying with section 17 also. This is my case.
I will hear you some other day. Not convinced.
Please, my lord. And in this, my lord, incidentally, in this matter,
is it beneficial for me to hear the learned amicus curiae?
Very much.
Independently, he may
very much
guide the court.
Very much. And here, my lord, incidentally, in this petition, I represent the cooperative society.
Of course, you represent it.
Where this detailed judgment has come. I represent the cooperative society which was formed as per the direction.
Let him throw some light.
Because all these points were dealt there, and it was the division bench judgment was also based on the order of this very own judge, my lord, in Shantaram Prabhu's matter, where it was told that there was a bifurcation made.
In explicit words, nowhere in the judgment it stops.
That I will demonstrate that, my lord.
Demonstrate, you go through the entire judgment and form an opinion. No, I will not do that.
No, my lord. I'll refer to the specific provisions.
No, can I hear the learned
Yes, my lord.
query on the next day
Yes,
of
ma'am.
hearing? Please guide the court.
And I may also file a written submission.
Yes.
Detailed one.
Detailed mean how many pages?
My lord, your lordship, please don't restrict me at least on that, my lord, because I have to bring in multiple judgments. Because, my lord,
You may file it. but
My lord,
I
I
may
will-
have my own reservations.
my lord, my submission is this, my lord. They cannot use a repugnant state legislator.
Because already you have filed the statement of objection.
Yes, my lord. I have brought in
Statement of objection.
my
Where
one.
where is the scope for filing another?
My lord, one
submission?
submission, my lord. My respective one submission is I wanted your lordship to club that matter also, where I have questioned the validity of 1972. Because that filing happened itself because there was a suggestion by the court which where in the
Then why it was dealing?
my lord,
Why it was dealing?
it was not dealing. I filed it subsequently. It was not clubbed. Clubbed one was earlier one, my lord. Clubbed one is the matter which your lordship heard yesterday. That's a different matter.
No, there is a specific order to dealing WP number so and so from the main matter.
My lord,
There is a specific order dated 3/12/2024 dealing WP number 1.
no, that is a different matter, my lord. That is not my matter. I have filed a matter challenging the validity of
It
1972.
was never clubbed.
No. It was filed because there was a suggestion by the court.
No, that.
So your lordship may kindly.
Let me hear the learned amicus query.
Please,
Thereafter,
ma'am.
I will form it. Heard learned counsel for the petitioner and counsel for respondent number 5. Please, learned counsel for respondent number 3. 3 in part. ಅವರಿಬ್ಬರದು full ಮಾಡಿ. Heard learned counsel for respondent number 3 in part. It is felt to hear the learned amicus query, who can guide the court in proper appreciation of the contentions taken by the parties. Hence, to hear the learned amicus query. Yes, sir.
Interim protection may be continued.
Yes.
A date, ma'am.
When you can. December. 8th or 9th. 8th.
My lord, can it be on 9th, my lord? 9th.
9th. 9th.
Oblige.
Further arguments.
7. Further arguments. Venugopal, Mukkadappa.
Serial number 5, 7. 44.
Serial number 7. MS Venugopal. SP Mukkadappa.
Suggested if
settle it.
No, my lord, suggestion, in fact, my lord, that they have given some proposal, the very big.
ಆಗಲ್ಲ ಅಂತ ಬಂದಿದೆ ಇದು.
ಹೌದು sir.
Already recorded, no chance of settlement.
Your lord, she can post it.
On merits.
Please.
Counsel for respondent. You represent respondent number?
Yes, sir.
Respondent number?
What?
Respondent number 2, 1 or 2?
Two, or no, it's point number 2. I'm sorry.
He has already addressed this argument. And the matter may be decided on merits. Counsel for the appellant is absent. Petitioner is absent. It is noticed that both the learned counsel, the petitioner and respondent number 2 were heard at length on the previous dates of hearing. Further arguments, if any.
The lordship kindly.
Already heard at length, however, further arguments, if any, waiting.
And I have, the lordship kindly, because I referred some judgment, I leave it to all these judgments in the court.
What judgment?
Some of the judgments, only 3 judgments are there. I leave it in the.
ಎಲ್ಲಿದೆ?
ಕೊಟ್ಬಿಡ್ತೀನಿ ಸರ್. ಬಿಫೋರ್
ಫೈಲಲ್ಲಿ
ಮೇಲೆ
ಕಂಪೈಲ್ ಮಾಡಿ ಇಷ್ಟು ಕೊಟ್ರೆ ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್ ಯು
ಹೆಡ್ ನೋಟ್ ಅನ್ನೇ ನೋಡಿ ನಾನು ಮಾಡ್ತೀನಿ.
Yes. Anything more to submit? Already addressed. But still I will post it for further arguments. If I come across any doubt, I'll come back. Otherwise, I will pass judgment. Date kodal on week areas.
Serial number 8, Dev Prasad Shetty.
ಅದು ಒಳಗೆ ಕಳಿಸ್ಬಿಡಿ. ಸರಿ.
Prashant.
8.
Or the petitioner society registered on 13/2/2020, it's a women's cooperative society as per annexure A. Not on 24/10/2020, the office bearer election was held after the.
That milk collection center.
Yes, my lord, exactly. Milk.
That was not provided.
Yeah, though representation is given on various occasions to the respondent number 7. To the respondent number 7, my lord, who will have to establish the milk collecting center. They have not done anything, they have not taken any steps after the registration of the new society. Now on the last occasion, last occasion, my lord, your lordship were not about to allow the petition. Then the counsel for respondent number 7 appeared through VC and took time to file objection. Now it is almost more than nearly 1 month. They have not filed the objection also.
Who is representing respondent number 7? Who is the contesting respondent?
Contesting respondent number.
We have filed impleading application.
Respondent number 7.
7 is
on Prashant BR, my lord. Prashant BR is appearing for respondent number 7.
for Tumkur Milk Union.
Neither they have filed objection, nor they are considering the.
Your allegation is against respondent number 7.
7, they are not. Now, only because not the milk collecting center is not established. Now the assistant registrar, my lord, has passed an order for liquidating the society, saying that you have not done the business. So those orders are challenged and there is an interim order.
Next J and L.
Yes, ma'am.
Yes.
My lord, I beg your pardon, my lord. We are the villagers, my lord. In fact, they did not function. My lord, we gave complaints also that, my lord, it's not functioning. On that, my lord, the order is.
He has explained under what circumstances he could not.
My lord, so far as those, but those are concerned, my lord, it's not supported by any document.
And there is a
alternate remedy
For respondent number 7, my lord, one submission, my lord. My lord.
Have you filed the statement of objections?
No, my lord, I have to. My lord, one submission, my lord. One submission, my lord.
Submission.
My lord, with regard to this, my lord, they are challenging the order and passed under 72.
they have to approach under 106, man. Under annexure J, man. That annexure J is at page number 33, man. The order is passed under
How you are justified in issuing an Annexure J and L? Please convince me prima facie, then I will direct him to approach section 106.
It is.
You cannot say.
It is the respondent state.
You are not
violation.
contesting respondent?
I am also a contesting respondent.
Tell me.
My lord, what has happened?
Who issued Annexure J and L?
It is respondent number.
12.
No, my lord.
No, we have issued it.
But Deputy Registrar, government.
We have issued. Lordship may kindly see, this is a case wherein the society was registered on 13/2/2020.
Yes.
They are supposed to commence the Lordship.
He has given some explanation.
Explanation.
Under what circumstances he could not carry on the business.
Business. That is, your Lordship, after expiry of 1 year he has given it. Not before that. It is not his case, your Lordship may kindly appreciate. Within 1 year he has given that explanation or any representation to the concerned authority or the respondent number 7.
Only on representation of the petitioner, you will, the respondent number 7 will establish the milk collection centers?
Please. Lordship,
Position?
No. Because they have to commence it, your Lordship, within 1 year, as per section 72(4). They have to commence it within 1 year. That they have not done it. And after lapse of
What do you mean by
commencement, ಅವರು ಬೋರ್ಡ್ ಮೀಟಿಂಗ್ ಹೆಲ್ಡ್ ಮಾಡಬೇಕು, ಬೋರ್ಡ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗಬೇಕು, ಆಮೇಲೆ they have to collect milk and supply it. They have not done it. Therefore, we have taken action. Now, your Lordship may see, he is relying upon the representation. That representation was given only on 7/10/2021. That is after lapse of 10 months, 8 months. ಅಲ್ಲಿ F1, F1 ಎಲ್ಲ ಇರೋದು, E2, F1, E1 ಎಲ್ಲ.
Not before that, kindly see page number 23, annexure D. Nam share amount collect ಮಾಡ್ಕೊಂಡು ಇವಾಗ they want us to give a representation. Kindly see annexure D, my lord. 1,218 rupees they have collected the share amount from the primary society. Lord, they have collected the share amount. They are within the knowledge that, Lord, the society is established. Along with all the documents, Lord, we furnish annexure D is the share amount. And they don't, Lord, establish the milk collecting center, and then they say that we have not commenced the business. Lord, for commencement of the business, there must be a collecting center. Now, all the one adana elli idodudna.
That again after lapse of 1 year.
In fact, even the department itself has given.
Statute is very clear.
Directed them.
We can't go beyond the statute. Your Lordship, there is no continuation of delay or anything so far as 1 year is concerned, your Lordship.
Collection center ilde idre what business he can carry on? ಅಲ್ಲಿ ಸೆಂಟರೇ ಇಲ್ಲ.
ಅಲ್ಲಿ ಇವರು ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ, ಕಲೆಕ್ಟ್ ಮಾಡಿ ಕೊಡೋದು ಸ್ವಾಮಿ, ಸಪ್ಲೈ ಮಾಡೋದು.
ಮಾಡಾದ್ಮೇಲೆ ಸೆಂಟರ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಎಲ್ಲಿಗೆ ತಗೊಂಡು ಹೋಗ್ಬೇಕು ಸರ್?
ಅದು ಅವ್ರ ಗ್ರೀವೆನ್ಸ್. ಅಗೇನ್ ದಟ್ ಗ್ರೀವೆನ್ಸ್ ಇಸ್ he has raised it, that society has raised it after 1 year, not before that.
The society has waited for some time, 2-3 months.
Subset.
No.
There will be sub centers, my lord. They have to provide there. There will be sub centers. They have to provide the milk there.
ಎಲ್ಲಿದೆ?
No, they have to provide.
Your contention that you have established the centers, collection centers.
Sub centers are there, my lord. There is no dispute with regard to that. Near the where they have formed the society.
ಬೇರೆ village ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ಕೊಟ್ಟು ಬರ್ಬೇಕಾ?
My lord, first they have to prove, my lord, how much they are. My lord, it is like this, my lord, to register, my lord, 250 liters of milk, they have to give it to the sub centers, my lord. Then only their the program will start.
Who will establish the sub centers?
It is already there. We will establish. It is already there. Sub centers there. It is there.
Distance ಇದಕ್ಕೂ ಅವರಿಗೂ ಎಷ್ಟು ಡಿಸ್ಟೆನ್ಸ್ ಇದೆ? ಯಾವ ವಿಲೇಜ್ ನಲ್ಲಿ ಇದೆ?
That is not their case also, your Lordship.
See, few representations were given to you.
And
E-series. Is there any reply?
My lord, we have not replied to those representations, my lord.
You could have rejected it. See, there are substations,
I understand, my lord.
centers. You go and provide the milk anta helbodalla, supply the milk anta.
I understand, my lord.
There is no,
they have not replied to that. I have taken this.
You cannot keep quiet, sir, after receiving the representation. Now you cannot find fault with the petitioner.
My lord, first they have to establish, my lord, that 250 liters, my lord, they have to bring daily, they have to put 250 liters for.
Today they have brought 300 liters. Where it is to be supplied? There is no center, that is his grievance. And representation annexure E at least dated 7/10/2021. There is no reply. You kept quiet. Suddenly annexure J and L issued by the registrar.
ಫಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಮಾಡಿದೀವಿ ಸರ್, ನಾವು ಮಾಡಿದೀವಿ ರೆಫರೆನ್ಸ್,
ಏನಂತ?
ಬರೀ ಉಲ್ಲೇಖ ಮಾಡಿದೀವಿ, ಅದನ್ನ ಉಲ್ಲೇಖ ಮಾಡಿ ಅದನ್ನ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ.
ಅದಕ್ಕೆ ಏನಾದ್ರು ಒಂದು ಬೇಕು.
ಒಕ್ಕೂಟದ ಕರ್ತವ್ಯವಾಗಿರೋದು ಕಾರಣ ಸಂಘ ನೋಂದಣಿಗೊಂಡು 1 ವರ್ಷ ಗತಿಸುವ ಹಂತದಲ್ಲಿದ್ದು ಈ ಬಗ್ಗೆ ತಮ್ಮ ವೈಯಕ್ತಿಕ ಗಮನ ಹರಿಸಿ ಸದರಿ ಸಂಘ
reasonable opportunity should have been given. Even after that, there was no
ಅದರಲ್ಲಿ
business.
ನಮ್ಮ ರೋಲ್ ಬರೋದಿಲ್ಲ, ಇವ್ರದೇ ರೋಲ್ ಬರೋದು.
ಅದಕ್ಕೆ ನಾನು ಅವ್ರಿಗೆ ಕೇಳ್ತಾರೆ.
Now I cannot tell, my lord, we have given or
You
something.
cannot take advantage of your own wrong.
My lord, we have not replied to those representation
Then
what they have given.
You have not
As-
established the collection center also.
No, my lord, we have not established a collection center, but there are sub centers, my lord. There are sub centers, my lord, where they can go and put the milk.
ಅದು ಯಾವುದೇ ಹೇಳಿ, I will permit him to collect the milk and supply it. Just-
They were supplying before they were supplying, before this society was registered, my lord, they were going and supplying there. They were going and supplying there, my lord. There is no dispute with regard to that. They were going and supplying there.
What was the difficulty for you to reply? There is nothing on record. What is your stand? Even till today, you have not made it clear. You have not replied to annexure E. You have not filed the statement of objections. In the air, you are arguing. Substances, where are those? Nobody knows. You could have stated him. You go and supply the milk to such and such sub-centers. What was the difficulty? Why you kept quiet?
Well, at one submission, there was sub-centers in nearby 3 kilometers village in Mavanalli.
ಅಂದ್ರೆ 3 ಕಿಲೋಮೀಟರ್ ಹೋಗ್ಬೇಕು ಅವರು.
ಅಲ್ಲ, ಸಬ್-ಸೆಂಟರ್ಸ್ ಹಾಗೆ ಇರುತ್ತೆ. ಆ ಲೊಕ್ಯಾಲಿಟಿನಲ್ಲಿ ಆ ಪಶುಗಳು ಎಷ್ಟಿರುತ್ತೆ ನೋಡಿ ತಗೊಬಂದು ಹಾಕಿ ಕಲೆಕ್ಷನ್ ಒಂದು ಸೆಂಟರ್ ಇರುತ್ತೆ. ನನ್ ಕಂಪ್ಲೇಂಟ್ ಏನು ಅಂತಂದ್ರೆ they have not acted properly. That's why I want to plan for the villagers.
Not he is the person who has filed the impeding application. About why all this started, about 8%.
What is you are the impleading respondent.
Yes, my lord.
Implead ಆಗಿದಾರ?
ಇಲ್ಲ, impeding application not allowed. I filed my objection.
What is your interest?
My lord, we are the villagers there, my lord. In fact, my lord, my application may kindly be produced.
Villager of which village?
That where they want to Kalahalli village, where the present dispute is going on. My lord, we were also the shareholders.
How many of you? Only one?
No.
There are eight.
We are about 8.
8 impeding application.
What is your stand?
Our stand is that, my lord, the society which they want, they have become defined. They have not done it, and the order passed by the society on administrative side is proper and correct.
Is it your contention that in Kallalli there is a milk collection center?
Please, that I have not mentioned here.
Then what is the difficulty?
No, my lord. My submission is they did not function properly, defunct. Therefore, we requested to, my lord, this society itself is not functioning. We complained. Our complaints are there, my lord. Kindly peruse, my lord.
Yes.
Annexure, my lord. Annexure R6.
Without collection center, what business, what functioning that they can carry on?
My lord, annexure R6 and my documents may kindly peruse.
No,
my lord. My submission is, I understood where, my lord, the honorable court is considering. One submission is this: they have not acted promptly, and it was motivated with ulterior intentions.
What do you mean by acted promptly?
My lord, they should have immediately, my lord, proceeded.
Collecting the milk, supplying it.
My lord, they should.
A distant place.
My lord, suppose, my lord, my prayer is this: suppose, my lord, if there are members of the society and office bearers, my lord, nothing prevented to prevail upon the authorities to do it.
No, if now the petitioners are permitted to function,
Please.
what is your difficulty?
My lord, my grievance is they are not functioning properly and we have filed complaint.
Tomorrow they will start functioning.
My lord, we are reviving this entire exercise, my lord. It's very difficult for us because we have been kept out. Now my prayer is, yes, please, my lord, this is the ulterior motive, they have done it. And therefore, I may be permitted to come on record. And my lord, my grievance may kindly be considered.
Not convinced, sir.
No, my lord, my documents may kindly be, my lord, kindly appreciate.
It is between petitioner and the respondent number 7.
My lord, the complaint was, my lord, inquiry was at my instance also. Kindly peruse, my lord, annexure R678, page number 14 ನಲ್ಲಿ ತಾವು ನೋಡಬಹುದು. ನನ್ನ ಐಎನ್ ಜೊತೆ ನಾನು annexures ಹಾಕಿದ್ದೀನಿ ನಾನು.
What complaint?
Complaints to the ಸಹಕಾರ ಸಂಘಗಳ ನಿರ್ದೇಶಕರು ತಿಪ್ಟೂರು ಉಪವಿಭಾಗ annexure R6, my lord. ಇವರು ಯಾರಿಗೂನು ಸರಿಯಾಗಿ ಸದಸ್ಯತ್ವ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ತನಿಖೆ ಮಾಡಬೇಕು.
ಅದು ಬಿಡಿ, ಅದು ಬೇರೆ.
ಹೌದು.
ಸದಸ್ಯತ್ವ ಮಾಡ್ಕೊಳ್ಳೋದು
ಅಲ್ಲ, ಅದು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ R7 ಅದು ಮಾಡ್ಕೊಳ್ದಂಗೆ my lord. ಇನ್ನ ತಾವು ನೋಡಬಹುದು.
Scope of this petition is entirely different.
No, my lord.
Not about
my lord, our complaints because kindly appreciate, my lord, in the order which is passed by the government, it is reflected. They have also considered that. That's what I want to bring it to your lordship's consideration. Illi ಏನು ಮಾಡಿದ್ದಾರೆ?
I will not enlarge this scope. I will not enlarge.
No, my lord, they have not implemented us purposefully. This is my anxious submission.
You cannot have any say in this matter, at least.
No, my lord, I was also
if you are not admitted as a member.
Please. No, my lord, defuncting, as a shareholder.
No other remedy?
My lord, as a shareholder, and my lord, I am bound to, my lord, bring it to your lordship's notice what has all transpired. And even in the order.
Are you a shareholder?
Yes, my lord. We have done.
Then you can address your grievance elsewhere.
My lord, that's what
you have taken any
my lord,
steps.
that's what we have done. Kindly peruse my annexures.
Not by impleading in this petition.
No, my lord. My submission is this. Now, they want to keep it as in darkness and they did not implead us. Now, my lord, in the order, for a moment, my lord, kindly peruse the orders passed as, my lord, annexure J and L, where, my lord, it has been, our representations is also considered, my lord. This is what, my lord, I want to bring it to your lordship's consideration. Kindly, my lord. Page number 33, my lord. ಸ್ಥಗಿತಗೊಂಡಿರುವುದನ್ನ ಸಮಾಪನೆಗೊಳಿಸುವ ಬಗ್ಗೆ ಇದನ್ನ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲೆ ನಾವು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ನೋಟಿಸ್ನ ತಾವು ನೋಡ್ಬೋದು. ರೆಪ್ರೆಸೆಂಟೇಷನ್ಸ್ it starts from, my lord, annexure R11, 12, 13, 14.
Your grievance is also that they have not hit the milk.
Yes.
And thus they have, the society has become defunct.
Yes. ಅದನ್ನೇ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಈಗ ನನ್ನ ಪ್ರಾರ್ಥನೆ, my lord, ನನ್ನ ಪ್ರಾರ್ಥನೆ ಏನಂದ್ರೆ, my grievance, my lord, they should have added me as a party. Now I filed a caveat at the earliest.
Raise a dispute with regard to that.
Yes, my lord, that liberty may kindly be given. ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಲ್ಲ, ಈಗ ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡದೆ ಹೋದ್ರೆ ಐ ವಿಲ್ ಬಿ ಔಟ್ ಆಫ್ jurisdiction.
You are not a party before this petition. In this
No, I have been.
If you are having a grievance, it is independently you can.
My lord, that liberty may kindly be given.
Liberty I will not grant.
If it is not granted, my lord, kindly appreciate, my lord, my situation.
The
difficulty is this. I will be immediately, if I file any dispute or like that, both the government and my learned friend will say that your mouth has been shut before the Honorable High Court. You cannot re-agitate. That is my apprehension, my lord. That may kindly be noted.
My lord, may I make one submission, my lord?
Nimdenilla sir, sumne.
My lord, before only one.
Be seated. Please be seated. Third learned counsel for the applicant proposed respondent number 8 to 15, and the learned counsel for the petitioner on IA 1 of 2022 filed under Order 1 Rule 10, seeking to implead themselves in the petition. The only ground argued by the petition, the applicants, is that the petitioner society has become defunct and it is not functioning, as it is not collecting the milk from the milk producers and therefore rightly annexure J and L came to be issued. Next paragraph. The petitioner has approached this court seeking to quash the very same annexure J and L on the ground that respondent number 7, district society, never replied to any of the representations produced as per annexure E, nor it has established milk collection centers to enable the petitioner society to collect the milk and make the business. If at all, under such circumstances, the presence of the petitioners, presence of the applicants, public proposed respondent number 8 to 15 is not at all necessary in the present case. Hence, application is rejected. It is made clear that if the applicants are having any grievance, they can agitate the same by raising necessary dispute. Accordingly, IA is dismissed. Next, we will continue. Also, of the petitioner that it is registered under the provisions of Cooperative Societies Act on 13 to 2020 is not in dispute. The society is affiliated to respondent number 7. It is the specific contention of the petitioner that respondent number 7, being the district milk union, is required to the petitioner to establish milk collection center within its jurisdiction. This fact is not disputed by any of the respondents. The petitioner has produced annexure E, the representations submitted by him to respondent number 7, requesting to permit the petitioner to establish milk collection centers and to do the business. Admittedly, there is no reply to annexure E. In the meantime, respondent number, who issued annexure J and L? Respondent number?
Annexure J is issued by the
R3 now.
Deputy Registrar. Respondent number
4.
4.
Respondent number 4 issued annexure J and L. Seeking to cancel the
And annexure L also.
Registration for the reason that the petitioner has not carried out any business. Unless there are milk collection centers permitted to be established by respondent number 7, the petitioner could not have carried on the business. Therefore, I am of the opinion that respondent number 7 was duty bound to permit the petitioner to establish the milk collection center, and even after that, if the petitioner fails to carry on the business, then the respondents would proceed against the petitioner in accordance with law. That being so, the annexure J and L issued passed by respondent number 4 will have to be quashed. Accordingly, I proceed to pass the following. Petition is allowed. Annexure J and L is also quashed. Yes, petition is allowed.
My application.
Rather dismissed.
Dismissed.
You
No.
can have your own grievances.
My lord, whether that observation
Yes,
is,
I have made it.
please, if that observation is made, my lord, I am much obliged. Kindly, much obliged.
Please.
Next, ಯಾವುದು 9 ಒಂದು ತಗೊಳ್ಳಿ ನೋಡೋಣ. ಇನ್ನೂ ಒಂದಿದೆಯಾ ನೋಡೋಣ. Yes, tell me. ಹಾ. 9 ಕರೆಕ್ಟ್ ನೋಡೋಣ.
ಮಹೇಶ್ ಅವರು
Respondent number 3 and
Yesterday they have filed affidavit minutes.
ಅದು
Flats, ಇದು
okay. Auctioning of the
auctioning of the property. Now my lords, I have one submission, my lords. Insofar as my lords, 25 WP number 27200 of 2024 is concerned, my lords. It's 27200 is concerned, my lords. The auction notice at annexure A, page 24 was under challenge. Lords, my learned friend made the submission that, my lords, as on the date, my lords, outstanding amount is 73 lakhs 56,000. So I inquired with, my lords, the petitioner, whether he is willing to purchase this particular penthouse. He says, my lords, that is not worth of that much, my lords, so he is not willing to purchase that apartment. My lords, reserving liberty for me to, my lords, state my remedy, because I am claiming, my lords, pursuant to the consumer court's order, insofar as this particular property is concerned. I had entered into an agreement, and, my lords, since they did not adhere to the terms of the agreement, I had filed, my lords, consumer complaint, wherein, my lords, the order is passed to refund that amount.
Yes. What was the amount paid by you?
Amount was paid, my lords, 55 lakhs.
Who has to refund?
Now the private respondents will have to refund, with the reserving that liberty, my lords, to pursue the remedy.
No, already there is an order by the
consumer court. I have that.
Pursue your.
That is what, my lords. With that observation, my lords, this can be disposed of.
If you can file a memo. to
I'll
the
file.
effect,
Memo
on record.
Yes, please. Taken as filed, my lords, I'll file.
No objection. That is the submission. In fact, I wanted to make.
Learned counsel for the petitioner filed a memo.
Yes.
Seeking permission to withdraw the petition as not pressed, with liberty to pursue his remedy pursuant to the order passed by the district consumer. Yellidu.
Udupi, my lords.
Udupi. Memo is placed on record. Petition is dismissed as not pressed, with liberty as paid.
But insofar as other petition is concerned, my lords.
200.
15929 of 2024 is concerned. Lords, may kindly take yesterday's affidavit filed by, lords, the respondent 1 to 3. Yesterday's affidavit. Kindly go to page 2, my lords. There, my lords, kindly see G, my lords.
Yes.
Now, only 3 flats are available for sale for realization of outstanding dues of our society, and the loan outstanding as on this date is rupees 28 lakhs. Let them sell that, my lords, and recover that, realize that amount, leaving this particular apartment. I made it very clear, my lords, in the.
Which are these 3
These
flats
3 apartments are, my lords, your lords.
belonging to you?
Yes, my lords. Kindly go to, my lords, annexure K, page 134. Annexure K, page 134, my lords. First 2 are my properties. A wing only, first A block, B wing, 1 and 2 are my flats. And serial number 4, my lords, they have sold during the pendency of this particular writ petition. Remaining, my lords, 3, according to them, 3 are there. Let them alienate, and if in case if they, my lords, still there is liability, my lords, then they can consider, my lords, bringing this particular property for.
That we will do it, my lord. But the question is, my lord, what is our right, my lord? Even if we realize the amount over and above this 28 lakh, whether we are entitled to retain it as a right of lien in respect of third loan. Your lordship may kindly see, my lord, there are 4 of my affidavit.
Who is the borrower there?
Please, my lord.
Who is the borrower?
Again, same partners were there.
Same
my lords,
partnership. Same petitioner in that also.
Now there also, my lords, there is one penthouse in their, my lords, custody.
We will
even
do one
if
thing,
that.
my lord. Now, your lordship may kindly see, my lord. Third loan is concerned, my lord. Totally, there were, my lord, 20 flats and one penthouse. Your lordship may internal page 3 of my affidavit. 3 of my affidavit filed.
Yes.
A total number of 20 flats and 1 penthouse But para 4, I further submit that petitioner in above writ petitions is also a partner as well as surety to another project loan advanced by our society to Messrs. Aplam.
How much time you may, both of you may require?
This is the last one.
Astena.
Only.
Adu other matters so may not reach. List ಇನ್ನೊಂದು further ಒಂದು ಇದೆ ಅದೊಂದು ಇಟ್ಕೊಂಡು serial number ಇದರಲ್ಲಿ ಇನ್ನೊಂದು 10 ಒಂದು ಇದೆಯಲ್ಲ.
First list on matter is further is first matter.
Lengthy matter ಅನ್ಸುತ್ತೆ.
ಅಥವಾ ಇನ್ನೊಂದು ದಿವಸಕ್ಕೆ
ಆಗ್ಬೋದು. ಇದು ಮುಗಿಸ್ಬಿಡೋಣ ನಾಟ್ ಮಚ್ ಅಲ್ಲ. 10 ಒಂದು ಇಟ್ಟಿರಿ ಉಳಿದಿದ್ದೆಲ್ಲ ಚೆನ್ನಾಗಿ.
Serial number 10, all the matters are 10.
I may take up only serial number 10. Other matters.
Serial number 12, my lords, yesterday's matter come up for today, my lords. That where senior counsel argued the matter with respect to the prospective effect of that 5 years in 2022.
I'll hear something.
For tomorrow, my lords, because the elections have been coming.
ತುಂಬಾ ಹತ್ರ ಬೇಡ. ಇಲ್ಲ tomorrow ಬಿಡಿ.
My lord, serial number 19, my lords.
Can it be taken up?
Sir, you can take the date from the court officer, sir.
Yes, my lords.
Serial number? Noted. Passover ಇವಾಗ ಯಾವುದು ತಗೊಳ್ಳಲ್ಲ. You have lost the opportunity. No, ನಾಳೆ no. ಬರ್ದಾಗ ನೀವು ರೆಡಿ ಇಲ್ಲ. You lost the opportunity. ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. Yes, yes sir. Proceed.
My lords, insofar as my lords, my learned friend's contention regarding third loan is concerned, lords, now that is not the subject matter of the present writ petition. Let them, my lords, my respectful submission. Let them proceed
Only
with
regard to this.
three apartments. Let them.
My submission, Lord. I have a right of lien, Lord, over.
If you have, you exercise it.
Please, Lord.
If you are having the
Yes,
lien,
Lord.
and if you are advised, you can exercise that.
Yes, Lord, that liberty will be reserved.
Liberty ಆಗ್ಬೇಕು. No. I do not know what are the terms between the parties. How can I reserve liberty? No. I cannot reserve liberty, sir. I do not know anything about the terms between the parties.
Admittedly, he was a partner.
Maybe,
in that
sir.
firm also.
Maybe.
And he was a surety also.
There are several documents entered
That is,
into.
my lords,
Whatever the
Sir, that
whatever permissible under law, I may be.
whether you are entitled to exercise lien or not is not a subject matter.
Yes.
Of this.
That may be kept open, Lord, at least.
Why should I refer to that, sir? Why should I refer to that?
I leave it to your lordship.
It is entirely outside the scope.
I leave it to your lordship, Lord. I leave it to
Outside the scope.
I leave it to your
Why
lordship.
should I enlarge this and ella adunu idunu ella ಮಾಡಿ?
I leave it to your lordship, Lord.
Then you take the legal opinion, proceed.
Yes, Lord. Yes.
ಅಷ್ಟೇ ಹೇಳಿದ್ರೆ ಇವರೇ ಲೀಗಲ್ ಒಪಿನಿಯನ್ ಕೊಡ್ತಾರೆ.
ಅದು ಏನಾದ್ರೂ ಮಾಡಿ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗ್ಬಿಟ್ಟಿದೆ ಈಗ 20 ಮನೆ ಇತ್ತು, 20 ಮನೆನೂ ಅವ್ರು ಸೇಲ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು. Now this 3 flats, which are those flats?
My lords, annexure K ಅಲ್ಲಿ ಫಸ್ಟ್ 2 ಬಿಟ್ಟು ಅವ್ರು ಬೇರೆದೆಲ್ಲ ಆಕ್ಷನ್ ಮಾಡ್ಲಿ.
ಎಲ್ಲಿದೆ ಪೇಜ್ ನಂಬರ್?
ಪೇಜ್ 134.
ಫಸ್ಟ್ ಇಂದು 2 ಇಲ್ಲ.
First
Third one already.
Fourth one was sold by them only, they have realized the amount.
So serial number 3 is available.
3 is available, 1 to 4 in B block is also available.
But he is saying only 3.
He says only 3.
Only 3 are available.
Which are those?
That number I will furnish, Lord. I will file a memo, Lord.
First 2 ಬಿಟ್ಟು ಮಿಕ್ಕಿದ ಆಕ್ಷನ್ ಮಾಡಿ.
ಮೆಮೋ ಹಾಕ್ತೀನಿ.
ಹಾಕಿ ನೀವು ಮತ್ತೆ ಫಸ್ಟ್ ಇಂದ 2 ಹಾಕಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ 3ಕ್ಕೆ ಮಾತ್ರ ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ, ಬೇರೆ ಇನ್ನೇನು.
ಅಲ್ಲ 3ಕ್ಕೆ ಅಂದ್ರೆ ಇನ್ಕ್ಲೂಡ್
3 ಅಂದ್ರೆ ಅವ್ರದ್ದು 2 ಇನ್ನೊಂದು ಯಾವ್ದು ಉಳಿದಿದೆ ಅನ್ನೋದನ್ನ ಮೆಮೋ
ಅದನ್ನು
ಬೆಳಿಗ್ಗೆನೆ ಹಾಕ್ಬಿಡ್ತೀನಿ.
ಅಲ್ಲ ಸರ್, ಇಲ್ಲೇ ಕ್ಲಾರಿಫೈ ಮಾಡಬಹುದಿತ್ತು. ಓನ್ಲಿ 3 ಫ್ಲಾಟ್ಸ್ ದಟ್ ಈಸ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂದ್ಬಿಟ್ಟಿದ್ರೆ ಮುಗಿದು ಹೋಗ್ತಿತ್ತಲ್ಲ.
ಮಾಡ್ಬೋದು ಆತರ.
ಅಲ್ಲ ಮಾಡ್ಲಿಲ್ಲ, ನೀವು ಮಾಡ್ಬೇಕು, ನಾನ್ ಮಾಡೋದಲ್ಲ.
ಅದು ಇನ್ನೊಂದು ಯಾವ್ದು ಅಂತ ಗೊತ್ತಿಲ್ಲ ನನಗೆ, ಅದಕ್ಕೆ ಮತ್ತೆ ಆಮೇಲೆ ನಾನು
ಇನ್ನೊಂದು ಅಂದ್ರೆ 2 flats belonging to the petitioner.
ಒಂದು ಅದು 2 ಇನ್ನು ಒಂದು ಉಳಿದಿದೆ.
ಇಲ್ಲ ಇದು ಬಿಟ್ಟು 3 ಇದೆ ಅಲ್ಲಿ. ನೀವೇ ಕೇಗೆ ಹೋಗಿ, annexure ಕೇಗೆ ಹೋಗಿ.
ಅಲ್ಲ annexure ಅಲ್ಲ ಕ್ಲಾಸ್ ಜಿ ತಾವು ಓದಿದ್ರೆ, now only 3 flats are available
Which
for
are
sale,
those?
for realization.
See, annexure K ನಲ್ಲಿ, there are reference to 8 flats.
Yes.
ಹೌದು.
3 flats ಅಂದ್ರೆ, you are referring to which flat?
ಅದು ನಾನು ಹೇಳ್ತೀನಿ ನಾನು.
Was it not necessary to clarify? ನಾಳೆ
I will.
ಮತ್ತೆ ಇದೇ ತೊಂದ್ರೆ.
ಇಲ್ಲ ಈಗಲೇ ನಾನು ಮಾಡ್ಲಿಕ್ಕೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆನೆ ಹೇಳ್ಬಿಡಿ ಫಸ್ಟ್ ಅವರ್ ಅಲ್ಲಿ.
Tomorrow.
Could it be adapted?
Say after.
This interim order to.
You have to clarify.
Please.
Great.
And if you refer to the item number 1 and 2, the dispute will not be resolved.
ಇಲ್ಲ ಹೀಗೆ ಸಿವಿಲ್ ಸೂಟ್ ಬೇರೆ ಹಾಕ್ಬಿಟ್ಟವ್ರೆ. ಅವ್ರು 20 ಜನ ಪರ್ಚೇಸರ್ಸ್ ಹಾಕ್ತಿದ್ದಾರೆ.
ಅದಕ್ಕೆ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ, ಇದ್ರದ್ದು ಹೇಳಿ.
Shekar, Devaprasad Shetty.
Review allowed. Connected matter to this petition, my lords. Has been restored through review petition, my lords. If it could be.
Then it is not server for concern.
Nothing survives in this petition.
The
Review allow agide. Allow agi not original writ petition restored. By virtue of the order passed in review, this order was passed. This not impugn order in this petition was passed. Now that review petition is allowed, original writ petition restored. So nothing survives in this petition.
If be connected and listed along with the matter.
That will be considered independently.
Yes.
Why should it be connected?
It is pertaining, it has to be quashed, my lords, pertaining to the ineligible voters list, my lords. If it could be connected and listed, my lords.
See, he makes a specific submission that it survive for consideration in view of restoration of
The writ petition number.
petition.
Petition number 14692 of 25. 692 of 25
692
of 25. Disposed on 22/5/2025.
So it could be connected and taken up for consideration, my lords.
May I submit, my lord? My lord, actually, what happens, my lord, and writ petition number 14692/2025, my lord. An order came to be passed by correcting it to the Ramanagara MPCS societies, my lord. By virtue of this order, my lord, the assistant registrar of cooperative kindly passed an orders, my lord. So based upon that orders, my lord, this writ petition came to be filed. Second writ petition came to be filed, my lord. So subsequently, we filed a review petition number 266/2025, my lord, which came to be allowed. The original writ petition came to be restored. Either this court has required to be quashed the order passed by the assistant registrar of cooperative society. Sorry.
ಎಷ್ಟು ಜನ ಅಡ್ವೊಕೇಟ್ಸ್ ಇದ್ದೀರಿ ಇದೊಂದು?
Sorry, my lords. My lords.
ರಿಲೇ ನಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? You are passing on the baton. ಒಬ್ರು ಆಯ್ತು, ಇಬ್ರು ಆಯ್ತು, ಮೂರು ಆಯ್ತು.
Sorry, my lords. My lords, now the review petition 266 of 25 is allowed, my lords. So, my lords, the writ petition is restored back, my lords.
Yes, that is what they are saying.
My lords,
Review
now,
is allowed, writ petition is restored on file.
please, my lords. My lords, pursuant the direction of this honorable court, ARCS has issued the notice, my lords. So this would go, my lords. If the writ petition itself is restored, my lords, it has to be heard afresh, my lords. So this will go, my lords. Because he could not have, because pursuant the direction of this, my lords, kindly see page number 27, my page number 37, my lords. In that page number 39, my lords.
Mm.
39, I shall read out 4, my lords. The question whether they are to be permitted to vote or not is a matter which has to be determined by the assistant registrar of the cooperative society. If for any reason the assistant registrar of cooperative society holds that these petitioners are disqualified, the right of hearing and opportunity of them would be ended. In that view of the matter, an interim arrangement has been made. Hence the following orders. And at page number 40, the order at serial number 3, my lords. The assistant registrar of cooperative society shall decide the matter regarding the qualification of the petitioners to vote in a time-bound manner and all probabilities not more than 15 days, my lords.
My lords, except, my lords, in the order retaining 1 and 2, everything is set aside, my lords. In the review petition order, my lords, the final order is still not uploaded, my lords. I shall produce that, my lords. But against this direction only, the ARCS had issued the notice, which would now go, my lords, because the writ petition has to be heard afresh.
Which writ petition?
The same writ petition, my lords, page number 37, 14692. 25, my lords.
Then whether this writ petition will survive for consideration?
My lords, it has to be set aside, my lords. The notice issued by the assistant register has to be set aside, my lords. Or my lords.
No, that was pursuant to the order passed in writ petition then.
Please, my lords, that is now
already set aside.
That is a review. We had filed a review, my lords.
Yes.
Review is allowed.
Yes.
Now the writ petition.
Afresh it is to be heard.
Yes, my lords. So this order goes, my lords.
Yes.
It has to be set aside, my lords.
Not done.
Yes.
Please.
Let the writ petition 1469.
May be heard. This may
Please,
be.
please.
Yes. So good. Heard and counsel for the petitioner, then the AG for so and so. You are for?
Lord, I'm for the, in this case, Lord, I'm for the impeding applicant. Respondent number.
Deviator, my lord, respond.
Now submitted.
Not part in.
Figure L, which is challenged in this
Respondent number.
petition, was passed pursuant to the order dated
22.
Right. At page number 37.
dated 22/5/2025, passed in WP 14692 of 2025, produced
R7.
a review petition came to be filed, seeking hear the matter afresh. The said review came to be allowed today, order dated 27/6. Allah.
It's allowed on 14/11/2020.
11/2025. Thereby restoring WP 14692 of 2025 for fresh consideration. Under such circumstances, counsel for the petitioner submits that annexure L impugned in the present case will not. Will have to be quashed. This position is admitted by the learned AG and learned counsel for respondent number so and so. Hence, I proceed to pass the following. And if in view of restoration of so and so, the order dated 14/11/2025 passed in RP 266/2025. Annexure L, passed by respondent number 5, is quashed. L is quashed.
Much of that.
Lord, I appear for the respondent number 7.
7.
Aita.
Serial number 12, my lords, the matter which your lordships have heard, can I request for tomorrow, my lords? My lords, we will have to.
ನಾಳೆ ಆಗಲ್ಲ, ನಾಳೆ ಆಗೋದೇ. No. Yes,
Lords.
ನಿಮ್ದೇನಿದು? Yes.
Your lordships had only asked them to mention the date when it is to operate. That's all the reason why, because this matter is heard in extenso. After your lordships recorded yesterday's proceedings, they took time for today. Lords, the reason for which we are requesting is that from 22nd, our nomination will have to, we'll have to start filing the nominations from 22nd. That is the reason, my lords.
Till what date the nomination?
24th, 2 days will be there.
So Monday, next Monday.
Lords, can I request for tomorrow or day after, my lords?
ನಾಳೆ ಹೆವಿ ಪೋಸ್ಟಿಂಗ್ ಇದೆ, ಸುಮ್ಮನೆ ಅನ್ನೆಸೆಸರಿ ಬರ್ಡನ್ ಮಾಡಿ.
ನಾಡಿದ್ಗಾದ್ರೂ ಒಂಚೂರು ಹಾಕೊಂಡ್ರೆ ಅಂತ 20th.
ಸರ್ ಎಲ್ಲ RSA matters, 2009 matters.
I understand, my lords. RSI matters, of course, your lordships is taking up the matters. But this will not, because your lordships have
Monday I will
completed the
take
hearing.
Monday I will take it.
Lords,
You
can
will
I
have
request that
time
let it be in the
up to
top of
20.
the list, my lords?
ಬರುತ್ತೆ, ಬಂದ್ಮೇಲೆ ಹೇಳಿ.
Because if the same thing happens like what it happened today, my lords. Nomination start.
Trustees need to be- ಈಗ all the questions are
Lords,
answered.
20,
Almost 80%.
lords,
ಈಗ ಮತ್ತೆ any
80% ಮಾತ್ರ ಕಂಪ್ಲೀಟ್ ಆಗ್ತದೆ sir.
fresh questions are arising.
lords, 24th will be the last date for filing nomination. So that is the reason, my lords, even if it,
Sir, ಇವತ್ತು first ಗೆ ಇತ್ತು.
lords,
Of the list ಇತ್ತು.
no, today, now 12, my lords, 11, it is not reached.
Sir, morning ಬಂತಲ್ಲ.
No, it is not reached.
ನಿನ್ನೆ ಬಂದಿದೆ.
Yesterday matter, my lords. Lords, can I request for tomorrow? Because your lordships have already heard the matter.
ಅವರು ಖಂಡಿತ ಸಾಧ್ಯ ಇಲ್ಲ. Please.
Lords, Monday it will become infructuous.
ಇಷ್ಟು ಆಗೋಗಿರುತ್ತೆ. Thursday or Friday. Thursday ಇದಿದೆ 4 o'clock ಇದಿದೆ. ಕಡಿಮೆ ಮಾಡಿಸಿ. Yes, Thursday.
So grateful, lords.
ಇದೇನು?
Mention ಮಾಡ್ಬೇಕಷ್ಟೇ.
Who filed this synopsis?
Both the parties. And it is filed by me.
By both?
Both.
Together?
Both. Yes.
Good.
It will answer 80% of the.
But you have not signed this. Only counsel for petitioner has signed this. Please
That I
sign
not.
this so that I can take it on.
Affidavit ಇದೆ.
There is no dispute with regard to those facts. Learned counsel for the petitioner and the respondent number 2. File. Synopsis. Huh? Yes. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕಾಮನ್ ಮಾಡಿ. They submit that there is no dispute with regard to the facts stated in this synopsis. Yes, just ಹೇಳಿ further arguments of the victim.
There are some disputed. Synopsis my friend has filed in the form of notes of argument, my lords. So we can't say that there cannot be dispute. But certain facts he has also pleaded, some questions raised by the court, my lords, that were answered by him.
But the synopsis, whatever the facts stated in synopsis is not in dispute.
Facts in issue not in dispute.
Yes. If I find any difficulty, I'll come back once again.
Yes.
Yes.
May please, my lord. I submit one citation also, my lord, along with that. But recent judgment of Supreme Court. One judgment of Supreme Court I kept along with the file, my lords. That is in respect of the same aspect, alternate relief available in the matter of auction.
You have produced
Yes,
it?
I produced
Really
it. Fine, good. Madam, adrottiga ಉಂಟು.
Why you are relying on this? Respondent number 1 alla.
Sorry.
Therefore, respondent number 1.
R2.
R2.
It's a similar set of facts, my lords, wherein the property was sold, sale proclamation, sale was questioned.
ಏನು efficacious remedy ಅಂತ.
House, efficacious remedy. Para 13 onwards, man. I underlined it. ಅದರಲ್ಲಿ ಆ ಆಕ್ಟ್ ಅಲ್ಲಿ ತಮಿಳುನಾಡು ಆಕ್ಟ್ ಅಲ್ಲಿ ರೆವಿನ್ಯೂ ರಿಕವರಿ ಆಕ್ಟ್ there is a clause to the effect that they should deposit. In that case it was complied. In my case it was not even complied.
Ultimately, what is held?
Ultimately, my lordship held that you have an alternate remedy. Page 14, my lords. Appellant failed to invoke the statutory remedies under section 37A or 38 of Revenue Recovery Act within the prescribed time. The auction held on so and so and confirmed so and so was conducted in accordance with law. Interim orders, High Court did not preclude the appellant from pursuing the statutory remedy which was not exhausted by them. Even in the Karnataka Society Registration Act, Cooperative Societies Act, my lords, there is a statutory remedy which has not been exhausted by following the procedure contemplated under law. And even in that Revenue Recovery Act, my lords, the irregularity in the or illegality in the auction that ought to have been pointed out. Fraud should have been pointed out. Similar to this. ಇದೊಂದು ಹೇಳ್ಬೇಕಾ?
ಆಗಿದ್ರೆ ಅದು ಕಂಪ್ಲೈಂಟ್ ಅಂತ. ಆಯ್ತಲ್ಲ?
ಕ್ವಶನ್ 80% ಆನ್ಸರ್ ಬಂತು ನಿಮ್ಮದು ನಮ್ದು ಸೇರಿ ಕೇಳಲಿಕ್ಕಿಲ್ಲ.